Welcome to another episode of the Environment in Canada podcast, a podcast about the environment in Canada by Sierra Club Canada. I'm your host, Connor Curtis, and we're coming to you today with a compilation episode on the rights of nature. These are a series of episodes that you might have heard before, and so there might not be anything new here for you, but we also wanted to let you know about a few actions you can take in September of 2025, including a Rights of Water campaign that we are currently accepting photos. So ways you can take action in September 2025 include sending a message to Prime Minister Mark Carney to stand up for community-based renewable energy and pledge to advocate in your community. Join our year-end campaign, which is centered on hope. And to do that, you just need to send us a note about what hope signifies to you. You can send that story to info@sierraclub.ca, and we might feature it in our emails or on social media to celebrate our community and inspire others. You can also tell us about your project of national interest. We'll be following up with you in October on those. Again, celebrate, reflect, and take action by sharing a photo of water in an area near you. All of the specifics on all of those are below in the description of this podcast. We also have some new fact sheets for you in talking to others about different issues. We have a fact sheet on electric vehicles, we have a fact sheet on wind power, and we have a fact sheet on why Canada can go 100% renewable. You can learn how to effectively communicate with others via a previous podcast, which we're also linking below. And if you're listening to this after September 2025, you can always find our Take Action section linked below the podcast, and that will have whatever the most recent Take Action items are, and you can check them out there. So without further ado, here's that Rights of Nature compilation. I think these are episodes that are really inspiring, that get us thinking a different way about our relationship to nature, and that really do help inspire hope for the most part. And again, you might have already listened to these, in which case there's nothing new here for you, but as a favorite podcaster of mine likes to say, you can make your own decisions.
Welcome to another episode of the Environment in Canada podcast, a podcast about the environment in Canada by Sierra Club Canada. I'm Jessica Murray, Sierra Club Canada's Ontario Director. Today, I have the pleasure of chatting with Owen Stewart, who sits as Sierra Club Canada's Board Vice President and is an Aboriginal rights lawyer living in BC, British Columbia. Today, Owen and I will talk about the current state of Aboriginal law in Canada, and Owen shares his insights on how Aboriginal rights might just be the best way to protect our environment. We also talk about reconciliation and unpack what that really means as we look forwards towards seeing Canada as a state with three heads: Anglophone, Francophone, and Indigenous. Before we begin, just a reminder that you can take action on environmental issues by visiting sierraclub.ca. We have tons of petitions, other actions and events, and regular new updates you can sign up for on the homepage. You can also find Sierra Club Canada on social media, and you can listen to the Environment in Canada podcast on Spotify, Apple Podcasts, iHeartRadio, and YouTube, or wherever you get your podcasts. Don't forget to click follow or subscribe so you can get the latest episodes from us. I hope you'll enjoy this conversation with Owen Stewart. Hello, Owen.
How are you?
Good. How are you?
Not bad. Happy to be here.
Oh, I'm so happy for you to be here too. Owen, you've been so helpful for answering all of my questions. I know you're incredibly busy, and you've always been so not only willing to chat with me about all of the issues, but also incredibly friendly and so easy to speak to. So I'm incredibly grateful for all of your support and really excited to have a conversation with you. Maybe we could just start with some introductions. So who are you? Where are you?
Yeah, so I currently live in Campbell River, which is sort of a small town. It's roughly dead center in Vancouver Island in British Columbia on the east coast. It's sort of the largest town for the northern half of the island, which gets quite rural. It's sort of classic coastal BC, fishing, mining, and timber. And so I'm born and raised on the coast. I'm from Burnaby, which is a suburb in Vancouver. I've been lucky enough to live in almost every province in the country. I haven't been to Newfoundland or Manitoba yet, but it's on my list. And so I'm an Aboriginal rights lawyer. I've been practicing for a few years now in the field, and I'm also the vice president of the Sierra Club too. I guess I should say that too.
Thanks so much. Yeah, I'm so super, super excited to talk to you about all of this. So I'm curious, you said you've been practicing Aboriginal rights law for the last 3 years. What's been your experience overall, just like as a general
Uh,
view of your experience so far?
I'm super lucky to be able to practice in the field. It often feels like you get to work for the good guys, which you don't always get to say practicing law. And just for me, like I'm a huge nerd. I'm a sucker for Canadian history. I'm a sucker for like I fish a lot, so I'm a sucker for sort of biology and environmental science, and I get to do a lot of that stuff in this field. Yeah, no, I'm reading old explorers journals. I'm reading about Alexander Mackenzie. I love this stuff. So yeah.
Very cool. And I'm not sure, like, are you allowed to talk about your cases?
In general, like some parts of them I can, some parts of them I can't. I can in broad strokes, yeah.
Sure. Why don't you tell us in broad strokes kind of what you're up to? Because I know you're very busy.
What's coming down the immediate pipeline is I'll be in court March 11th for a week. I'm one of the counsel involved in the New Chatlet Aboriginal title claim. We're in year, I think, 5 now. We've been in court a couple times, and we're going back. We're nearing the end zone, and so I'm actually I'm excited for this hearing. I think we're going to put some really persuasive stuff before the judge, and we'll have. No matter what happens, we'll be pushing Aboriginal title law forward, and I'm cautiously optimistic there'll be a good award for the client and for reconciliation, frankly. New Chatlet are a small First Nation on the west coast of Vancouver Island here. I had lots of interesting history. I mean, they were when Captain Cook made it to Canada, it was Nootka Island where he stopped, and the New Chatlet are on northwest Nootka Island. So, yeah, lots of interesting stuff there.
Okay, so we need to backtrack. Who's Captain Cook?
Okay, great question. So this is where so much of Aboriginal law has to do with history. And I think if you take a very long view of Canadian history, there's these different sort of eras of sort of Indigenous settler relations. And so Cook is the start, right? He's not the first European to make it to the west coast of North America. I think the Spanish got there first, but he was the first British person there. There was a big controversy about who gets to colonize the West Coast. Does Spain get it? Does Britain get it? Who got there first? Who, effectively occupied the territory, and then neither sort of did. But it's his records end up being evidence, and so all of these sort of counters that are recorded in the historical record, and they're not the only sort of source of evidence, but they're a really important one. And so yeah, that long answer of Captain Cook, he was one of your sort of classic British explorers. He was the guy who got murdered in Hawaii. I think he went all over the world. Your sort of classic, yeah. Actually, I got his complete journal in the office here.
Does he count as a colonizer?
Good question. Yeah, probably.
So
It colonizer. Yeah, I suppose he never like set up a fort or anything, but he definitely was the like planting the flag, which is the one of the first steps to making a territorial acquisition. We can talk about this. That I'm sort of fascinated by this law. The terra nullius we can talk about if we got time today.
yeah.
And just the law is sort of it's a common myth, I think, in Canada. Terra nullius isn't real. It never existed in Canada.
What? No. Okay, backtrack first. What is terra nullius?
So terra nullius is fancy Latin for what does it mean? Terra means earth, nullius means empty. Mm-hmm. So it's the idea, it was an empty land, right? Any first person to go there gets to own it because native folks didn't use it and weren't, people. And it often gets thrown around as the sort of the foundation of North America was this terra nullius myth, and it's not true. And Canadian courts have said it's not true in multiple decisions from the Supreme Court of Canada to lower courts. And I think it's true used picking the history. If it was true, why would Canada have bothered signing any treaties with anyone if the land was just there to take? Because they knew that there were people there who were using it, who owned it, and they needed to at least do something to justify taking it, either declare a war or sign a treaty. And because they knew that it wasn't this sort of empty land, this terra nullius myth. Now, the myth still has had a huge impact in North America. Of course it has. And unfortunately, it's quite pervasive. Many people think it's real, but at law, it's not. Absolutely not. And I think you see that through the at least historic government actions and more modern case law. So,
right, because if you're going to recognize that you need something to be done, then clearly it was actually empty.
If why would we bother signing these treaties if we could just take it, right? If at law we could just take it, why bother buying it? And the same thing, right? Like if I could just take that car, why would I bother giving somebody money for it?
Hmm.
Because they knew somebody owned it and somebody was using it. In fact, there were commissions that the federal government or the British government at the time created to go, meet with the chiefs, find out who the proper owner is and roughly what their territory is, and then let's figure out what the details of the treaty is going to be. And these commissions came back and said, okay, these guys are the rightful owners, and this is roughly their land, and these are the people who we need to treat with. And so they wouldn't have done that if Terra Nullius was real. They just would have taken it. And even the American example is the same. Like they declared wars as sort of their experience, Custer's Last Stand and things like that. They also signed treaties and then broke them, but they wouldn't have gone through this sort of legal process of war making if Terra Nullius was real. Like, why bother? Just take it.
And then I think maybe like another added complexity of looking at geography for the First Nations is that there's really a lot of overlap too. Like from my understanding, and you can correct me if I'm wrong, they didn't understand borders the same way that like we've carved out the world. There's not like, oh, like here's the line, and if you step on the other side, you're in another country, or another province, right? Here it was a lot more alliances and shared spaces and kind of a lot more like, I think, collaboration and cooperation. Does that sound about right?
So it depends. I think it like, and I'm gonna have to give a lot of lawyerly answers.
It depends.
Where there are very different. I think like we're talking about a continent's worth of cultures, right? And they're going to vary wildly from the West Coast to the East Coast to the middle. And so my experience looking at a lot of the anthropology is that on the West Coast here, there were very clear territorial boundaries that were readily understood and everybody recognized. You knew where the border was.
Interesting. Okay.
And I think that also would have existed in other places in the country, but there also would have been sort of places of shared ownership. I often think it's valuable to compare what, like, Europe wasn't this sort of perfect modern nation state thing until really the 1800s, right? Like there wasn't really a common language in France until they had public schools. Someone would speak Burgundian and in that province and then speak something else in Normandy. And so you wouldn't necessarily be able to communicate that clearly. And that is sort of what it would have been like, I'm sure, in Canada. There would have been like a trade language. And then as you sort of spread out, there would have been varying levels of sort of organization and government. I mean, just like anywhere, sort of everyone, people are members of communities in both higher and lower orders. You get up to like a nation state, but then there's even higher than that. NAFTA. Or even right? What's the real topical one? The military alliance in the North Atlantic that Trump wants to pull out of or is threatening to pull out of. The UN or another example, right? There are these sort of higher, meta organizations. First Nations would have had that too. There would have been sort of local sort of government style, of sort of higher head of government, and then a confederacy sort of order of government. I think traditionally, but again, we're talking in broad strokes, so it's a long way of saying it depends.
And I have a feeling that's going to be a lot of the response that you give me. So just for our listeners, Owen's been very good at always splashing cold water onto my face when I feel like I have got an idea that might be helpful. Oh, but
you never want to. I mean, lawyer never comes to you with good news. he'll usually just say, "Don't do that." But it is. I think there's a lot of passion in this field and a lot of rhetoric that gets thrown around. I think it is very valuable to sort of sit down and sort of run through some of the things that are out there to see, what is the strongest path forward? What are we trying to aim? What are we trying to achieve? And what are the tools to get it?
Sure. So I have a question actually, just to come back because we're talking about borders and boundaries and the kind of acknowledgement from the Canadian government or, the early settlers that people were living here, they were controlling and also owning the land, whether you want to call it stewardship or what have you. My next question is like, in a lot of the discourse, even now, like if you go on the governmental website, it really says that it recognizes First Nations bands as sovereign nations. And so when we talk about, let's go back to like the United States and Canada, sometimes when we're talking about a resource that is shared or there's kind of like something where operations are kind of mixed together, there's sometimes something called jurisdiction that comes up. So then it's like, whose laws prevail? And so my next question is kind of like, okay, well, if we're recognizing that the First Nations are a nation, I mean, it's called First Nation, so it's all kind of really, really folded into there itself. What is going on? Because, let's say the Wet'suwet'en issue right now. From their perspective, they're like, we're upholding our laws. And then Canada's coming in saying that, like, kind of different things, is a bit confused. So I'm wondering if we can peel that apart a bit, because if we're going to call something a nation and it's within their geographic location and jurisdiction, what in the world is going on?
Yeah, so I think you've got two questions here. One is sort of what is a nation, and then the second is what happens in a situation where you have conflicting laws. And so I think I'm going to answer the second one first, the conflicting laws question. It's a great question. Nobody quite knows. We're in early days in terms of the resurgence of Indigenous law and what exactly those laws are and how they interact with the rest of sort of Canadian society. We don't exactly know. There will be moments of conflict for sure. And there are already rules that exist to determine this, just in the same way that there are constantly fights between municipalities and provinces and between provinces and the federal government. There tends to be an order, a hierarchy of whose law wins. And so generally the higher order of government wins. Province trumps municipalities, federal government trumps the province, constitution trumps everybody. How Aboriginal law fits into that hierarchy is unknown at this time. And there will be different ways that Aboriginal law interacts with different laws. For instance, I think it's going to be hard for any Aboriginal law to supersede the criminal law, for instance. But others, there will be tons. I think there will be room, and it'll be an interesting sort of future as there's push and pull between different heads of government to find out where these boundaries are. I think a very clear way forward for sort of Aboriginal law to grow and develop is how it applies both on reserves and sort of on traditional owned lands by a given band, how those Aboriginal laws start to interact when they come into conflict with the province or the federal government. It'll be interesting to see what happens. I think an interesting background piece that you sort of constantly have to be aware of when talking about Aboriginal law and sort of Aboriginal heads of government is the division of powers in the Canadian Constitution. It's super dry and boring stuff, right? You go back to high school social studies. Some powers are given to the federal government. They get international relations and the army and criminal law. And then some powers are given to the provincial government to control. And they get property, which is generally the big one that the province gets. And they each get the power to give taxation. There is no express sort of heads of power for Aboriginal governments in the Constitution. But that doesn't mean that there isn't space for Aboriginal governments to sort of fill voids that are left. One of the big things that's not in the Constitution is who has jurisdiction over the environment. And it's sort of a constant fight about who gets to rule on the environment. And because of that gap, I think that it's a huge void that leaves jurisdiction for Aboriginal heads of government to have a lot of power. And we can talk later about the relationship between Aboriginal rights and environmental protection and how I think they're some of the strongest tools for environmental protection in the country. But you sort of have to know that the division of powers, sort of what government gets to do what, isn't a perfect box. There are these things sort of set out in the Constitution, but there are gaps between them, and there's nothing expressly given to First Nations, which leaves, I think, a lot of room for them to be creative and to develop their own sort of Aboriginal laws and practices. Now, the second question, what is a nation? That's a really tough one. And I would actually say that I think most bands effectively are nations at this point.
Are not, sorry, are?
They are nations. Yeah, they're not necessarily functioning or flexing their powers yet as nations, but the power is there for them. And it's already recognized, I think, by the Canadian state. Now, like, what is a nation? That's a complicated question. I think you'd be hard-pressed to find a super clear answer on that. Even within Canada, right? I think the Parti Québécois says Quebec is a nation, right? Within Canada, they're their own nation. And so then other provinces are sort of nations within nations. This gets back to the sort of we're all communities within communities within communities.
Sure.
And so the question is, what power comes with a nation? And so if Quebec is a nation, they get these express powers to control property and emit taxes and things like that. Well, bands already have those powers. They can control property on reserve. They can tax members on reserve. Bands also have power that extends beyond reserves, and this is their Aboriginal and treaty rights, to generally recognize some right to hunt and fish and trap. And to be able to hunt and fish and trap, you need a relatively pristine environment. So there are sort of powers, I think, that bands in this country already have at their disposal that are effectively the powers that nations have. Now, can they form an army? No, but neither can the province. I mean, there are bands that have their own police force. So I think the nationhood question, I think, can quickly fall into rhetoric. But I think if you peel
Mm,
away at it, the power is there for them. It's just we're in this growth period where they're sort of, puffing their chest out and filling in the space that's there. It hasn't been recognized, and the crown has been fighting it for the last 150 years. But I think the power is there for them to be considered nations, at least as a head of government that's similar to provinces.
interesting. And I think in some ways, considering there's been so much conflict between the federal government and different First Nations all across Canada, I find it particularly interesting that the judiciary has quite like space there to really kind of develop the space that you like you say is kind of open and then really unclear as to where we're going.
I guess it's the profession tooting its own horn, but I do think our judiciary deserves some credit. There
Mm,
are some significant wins for First Nations rights in the last sort of 20 or 30 years, where, I mean, God, if you were in a South American court, you couldn't have been able to bring this kind of thing. So
mm.
I do think some credit is some due, and credit due to the clients who push these cases forward. I mean, it takes a brave First Nation to put their credibility on the line and fight for these things. It's not
Mm.
just the court too; it's the clients as much as anything else.
For sure. So recently I listened to the Wet'suwet'en hereditary chiefs talk about what they've been going through, and it was really incredibly moving. I'm just really floored by their level of engagement and activism, considering, like the rates for what they're experiencing are really horrifying. Really, it's heartbreaking and tragic. So the fact that they've been able to find the resilience and strength and kind of organization to really come at this and the funding, like, I actually don't know how much this kind of stuff costs. Maybe you can fill me in, but it's not cheap to start these legal wars with the federal government, which has, a lot of whether I guess you'd call it political power.
So
And
I want to stop you there because,
yeah,
like, you're right, it isn't cheap, but I also think that's not necessarily an accurate narrative. I think that
okay,
gets thrown around as a way to inhibit some court cases, frankly. And I
okay,
don't want to, the legal profession, charges an arm and leg for their services for sure. But so let's talk about the Chilcotin case, for example, which I know quite well. That didn't cost the Chilcotin First Nation a penny. They
okay.
didn't pay a single thing for it. And it gets quoted, I think it cost $20 million or something over 50, 20 years, some crazy number. They didn't pay a penny. There's something called an advance costs order, which is rarely, awarded at law. But in rare cases, you can get it, and it's where the opposing side pays your lawyer's fees ahead of time because there's some genuine. I mean, there's a number of factors to it. So there are times when this isn't crazy expensive. Now, that's not to say it's not a large endeavor, and it takes a lot of willpower and research and time, and
Mm.
frankly, intelligence and creativity. But I sort of push back against the everything's so expensive. These things are so expensive narrative. It's like they are, but they're in the big picture, in the relative scheme of things, they're not. And there's ways to make them cheaper, frankly. And I think they are getting cheaper as there are more wins in the court.
Is that
Um,
specifically for Aboriginal rights law, or are you saying that in general for the legal system?
Advanced costs, or
Yeah.
so I think it's available generally for the legal system, but it's
Okay.
a it's a high bar to get. It
Okay.
Cost is a thing in court where generally if you win,
Yeah.
the other side pays your legal fees or a portion of them. And
Hmm.
so by awarding costs ahead of the actual end of a trial, the court can sort of seem like it's picking a winner already. And they don't want
Yeah.
to do that. You don't pick a winner before the end of a trial because you got to hear everyone, you got to hear both sides, right? You got to
Yeah.
weigh the evidence. So it's rarely awarded, but it is a thing that's available.
Look at you. You've got good news.
Oh no, I think the Aboriginal rights field is one of the places to look for good news in sort of environmental law, or not just the Aboriginal sort of rights, but just Aboriginal reconciliation, Aboriginal parks projects. I think there's a lot of exciting stuff happening.
Yeah, I'm actually curious. So when you work with the client that I assume is always like the Aboriginal band, do you ever come across kind of when their laws are kind of also guiding what you are going to say in the Canadian Judiciary Court?
Absolutely. So one of the we can get into the weeds of Aboriginal title. So it can be evidence. Absolutely. One of the ways that you own land at a territorial level is to sort of assert an intent to own it. And what does that mean? What is inserting an intent? Well, it's basically making rules for how people access and use things. And those are Indigenous laws there. And so if you have those laws either sort of recorded orally through oral history, or written in the anthropology or recognized elsewhere, yeah, it's evidence. Absolutely.
Very cool. Okay. And from your exposure of Indigenous law, and when I say Indigenous law, let's just, like, for the purpose of this conversation, call Indigenous law like their laws, like the laws within the band, and then Aboriginal laws kind of like the laws within the Canadian
Mhm.
legal framework. So just to have, like, I don't know what
No,
there's,
no, yeah.
maybe
That's
that's
probably
easy.
a fair way to split it.
Yeah.
Yeah.
Yeah. So what would you say if you've had exposure? Like, can you speak to the difference between Indigenous versus Aboriginal law?
It's a good question. I can't say I've ever thought of it. It's sort of impossible to generalize, I think, about Indigenous law,
Hmm.
um, or Indigenous laws that may exist. Is there are I think there's over 600 bands in the country. So does that mean there are over 600 different Indigenous laws? Maybe, I don't know. Or are there, or is what we're talking about become more sort of overarching principles and less sort of specific law as legislation? I don't know. Yeah, it's a good question.
Cool. You talked earlier about good news in the world of Aboriginal law. Can you highlight a story for me that you think is going really, like, as an example of like something to celebrate?
Oh, I mean, I would highlight the New Chatlet case. I think it's a David and Goliath fight between a small First Nation and the province of British Columbia mostly, and hopefully it'll be a David and Goliath fight with a big victory at the end. The Chilcotin decision is a big success. There's been a number of decisions on the coast here. The Ahousa decision has been a big success for sort of commercial Aboriginal fishing rights. Desautels decision has been a success for recognizing sort of international trans-border Aboriginal rights. Yeah, lots of sort of good things. And it's outside of court too. There's a project that's sort of close to home here called Salmon Parks. It was founded, the idea came up, New Chatlet's former chief, Walter Michael. It was his idea. And I love the concept. I like to fish a lot. And it's the sort of, you need a land-based park to protect an ocean-based species. And it really kind of breaks down dichotomies, I think, in protection. And it is an Indigenous sort of led park. I forget what the principle is. I'm going to mispronounce it. It's Hishish Sawak, which is a Nuchanolt word that means everything is interconnected, everything is one. I think
Hmm.
it's a great way to think of animal management and sort of environmental management. It's very ecological, seems.
Sure. And wouldn't you say that, at least from my exposure, it seems to be kind of the, like, when we talk about differences in perspective in terms of understanding the environment, the main thing that I've really gotten across in terms of relating with First Nation people is they seem to really understand this, like, not, I wouldn't even just call it connectivity, that it's just like, it's all, not just that it's all connected, but it's like one living, breathing organism together. And there's like no chopping things up and like this is over there and this is over here.
Yeah, so that's a great. I completely, or I guess I don't know that I would say that every Indigenous group I've met has that viewpoint, but I completely agree that that is the sort of classical European view of nature. It's this very sort of traditional view of parks, which is, you stick the park in, people can't go in there anymore because people aren't natural. Nature is natural. No, but absolutely, and this is how parks were run for hundreds of years, right? I mean,
Yeah.
it really comes from this, I think, classic medieval. The King's Park is where he gets to hunt. There, no one else is allowed in there because it's a park, and it's very in a black and white dichotomous thinking, which is often very European, I think, and has had a negative impact for sort of environmental management because we've had 100 years worth of parks where I think people don't get to go in there. You can have a long chat about parks legislation in Canada and the sort of constant tension between preservation and recreation that is a constant pressure in all the parks.
Yeah, I definitely experienced that myself too, as like a rock climber when we go outside. I mean, one case in point right now is Bon Echo. I don't know if you're familiar with Ontario, because I know you're on the West Coast, but at Bon Echo there's a Mazenah rock, and there's a lot of I think they're called petroglyphs, but there's art, and there's a lot of sacredness to those sites, and it's definitely an issue of contention. We've for whatever reason, even though these, and same with the petroglyphs park, I guess, also in Ontario. So it's like, I find it very peculiar that like these sites clearly have Indigenous Aboriginal markings on them, and yet it's an Ontario park, and the Ontario park gets to decide what happens to it.
Totally. So a great example is Banff, right? It was you put Banff National Park in, you kick all the native folks out because it's a park now. Nature can't be in there messing with it, but then they can come back in once a year for the parade kind of thing, right? Which is kind of what happened. And it is this sort of false idea that we talked about Terra Nullius earlier, that this was just this kind of, beautiful empty landscape that where people could just sort of pluck fruit off the trees and live harmoniously. No, this was a heavily managed and heavily used landscape. There would have, it would have been as fully occupied as it could have been supported through people's use. There were big populations of people here pre-contact, especially on the West Coast.
Yeah.
They figure it would have been, the Great Lakes would have had huge populations too, just enormous pre-contact. Yeah.
Yeah. Really, really interesting stuff. Okay. I kind of want to switch gears when you talk about there's rights for the indigenous that are living on reserve. And then now an issue that I've kind of seen more in the cities is that the reality is that maybe perhaps, and maybe you can explain to me why there's so much poverty and challenge and kind of like issues with drinkable water, for example. And so a lot of the First Nations people have actually started going towards the urban centers. And in Toronto, where I live, it's become an issue where, you come to Toronto and it's like, even if this is a site that your people used to connect to, and here I'm thinking about Mount Dennis area, Eglinton Flats area by the Humber River, in that way, because they're no longer on reserve, they don't have any rights in terms of like protecting their access to these spaces. So I'm curious to know what your thoughts are in terms of, rights for urban Indigenous.
Yeah, so everyone's moving to cities. Like small
Mm-hmm.
towns across the country are all shrinking. It's an international phenomenon, I think. Rights for urban Indigenous peoples my first question ends up being, well, what kind of right? Because there are all sorts of things sort of beneath the umbrella of Aboriginal rights. They can be used in many different ways. If we're talking about, let's like a right to hunt moose or something, that while it's a real right, I think you would be hard pressed to have any effect with that right. It's not like no judge is gonna tear down Toronto, right? That's too much of an ask. But there would still be, even if you are an urban Indigenous person, you have the right to exercise your right elsewhere, the right to exercise a treaty right or an Aboriginal right outside of the city. Now, there are ways that Aboriginal rights can be exerted, I think, in an urban setting. It's just complicated as to how. And it really does depend, I think, on the treaties that may have been signed in each place. It's sort of it's a long way of saying it depends.
Like speaking of treaties, I even just in understanding it, it seems like there's even a disagreement of like whether treaties sometimes were signed or not. Can you kind of speak to that as to what's going on there?
Yeah, so there's a long history of treaty signing in the country. It goes back to before Canada. I think 1600s is some of the first treaties, and the sort of historic treaty process runs up until 1920, so almost 300 years worth of treaty signing. And they changed a lot sort of throughout history as the relationship between the First Nations and the British Canadian governments changed. Generally, the treaties all involve a surrender of territory. The treaties are what the crown would rely on to say that we bought your land from you. And you still have a bunch of rights sort of on the land that has been surrendered, but ultimately it's now the crown's and we can, do with it what we will. A lot of these treaties were signed in suspicious circumstances, and I've done a fair bit of treaty work, and some of these treaties, frankly, stink. I think if you challenge them in the moment, some of them would be unconscionable bargains, right?
Mm-hmm.
It's sort of gun to your head stuff sometimes. That said, I think you'll be hard pressed to ever overturn a treaty. Like you'd need really, really clear evidence. So much. There's 150 years worth of decision making that is based on these treaties as being valid documents. It would need to be something enormous to overturn that. And I
Mm-hmm.
also think the treaties actually end up being a better tool to protect Aboriginal rights, because
Interesting.
they do enshrine protection in them. While there is a land cessation sort of element to all of them, they also all include protection for hunting and fishing and trapping rights. And so this is how Aboriginal rights end up being such powerful environmental protection tools. To have a functioning right to trap wolverine, you need enough wolverine to be able to have some to kill, right? And so to have a surplus of wolverine, you need a healthy environment that keeps enough wolverine around. And that it gives you great leverage in terms of development, even in territory that's been ceded under treaty. So yeah, that's right. I'm a big believer in Aboriginal rights as powerful environmental tools.
Okay. Interesting, because I don't know, it's just I find let's kind of go back to what's happening in Ontario at Chalk River. And if our listeners aren't familiar with the topic, there was a podcast I think a few weeks ago now with Ole Hendrickson, and he's been working with I can't remember how many bands it is, but a handful of bands that have said no to a near surface disposal facility for Canada's first permanent radioactive waste facility. And they've been very outspoken that, and in some ways it's kind of bizarre to me because it's like this has been happening for years, and they've kind of had their stories of, oh, we found a moose that has, they find, I think it was like there was too much blood and there was blood in its stool. So like clearly issues where it's like, okay, well, the radioactive waste has caused harm to the animals. And all very funnily points out, like, well, you can't tell the moose not to go outside of the boundary. So it's
Yeah.
like all these, like this idea of this carved up landscape of boundaries, and this really falls apart once you start looking at wildlife, right? It's like, especially when there's like
Well,
migrations across the world.
I'd say it depends on the boundary, right? I think there are lots of European boundaries that are natural boundaries too, right? It's the river, it's the height of land, and generally, in broad strokes, that ends up being what the boundaries are between First Nations territories in the country. It ends up being natural boundaries, things that are easily identifiable. That no one's going to miss the middle of the river, right? Everyone knows that's the end of the territory, or the Rocky Mountains, or something like that. And so there are examples where those are valid boundaries in Canada, but the country was made in this sort of era of just agreed upon boundaries. Like what is it? Oh God, what's the American border? Not the 49th parallel. Is it the 40? No, it is the 49th parallel. Woof. The 49th parallel. How did they pick that? Well, they didn't want to fight about what the natural boundaries were, because it can be kind of vague what a natural boundary is on the plains, right? How do you tell what the height of land is in Saskatchewan? And so they just agreed upon a number. Let's just pick the 49th parallel, perfect straight line. And that's when you get these sort of traditional territories that are split up because it was this negotiated boundary. It's not based on this sort of natural thing.
I'm kind of like also tying it into resources though. So if you're talking about hunting and trapping, like let's say the animal, like let's even say like an animal is on one side of the boundary and there's some sort of toxic whatever that's happened there and it travels into the Indigenous territory where they're hunting and trapping and they're getting sick and so forth. Is that kind of the premise of the Wet'suwet'en kind of claim in some ways? Because like I think from my understanding, they're almost quite broad stroke saying like the federal government has not been responsible in keeping the global temperatures, like their decisions have not been aligned in alignment with those agreements. So yeah, is that kind of what the premise of their argument is? Like,
So I gotta say I don't know. I'm not directly involved in the case or the claim. I'm aware of it, and I'm quite fairly knowledgeable about. So the Wet'suwet'en were involved in a Aboriginal title claim, the Delgamuukw case, which is very famous for the first case that sort of said oral histories are valid testimony. Like this is real evidence, or it can be real evidence. And so the Wet'suwet'en were there were two different First Nations involved in that case, and the Wet'suwet'en were one of them. And I think this is a great example of what happens when being in British Columbia, the question of who owns the province is huge. It's essential, right? There's almost no treaties in BC. And this is what happened. The current problem in Wet'suwet'en territory is what happens when this problem isn't solved in the court case 40 years ago. They brought this claim forward in the court. It goes all the way to the Supreme Court of Canada, and they sort of say, the lower court judge made a mistake. We can't make a new mistake, but you obviously need a new trial. And so they've never had this new trial to whether they have Aboriginal title in this region in sort of northern central BC. And if the court had answered this question 40 years ago, we would know, and there wouldn't be this fight in Wet'suwet'en right now, which is bad for everyone, frankly. I think everybody loses with what's going on up there. It's a shame.
Why do you say that?
I think there's value to win or lose. There's value to having certainty. Who owns the land is worth knowing. And I think the First Nations will own it. They'll have a property right in it. But even if they don't, if this has been a question for 150 years, it's about time somebody answers it and we can move on. What that answer is and what moving on means is a complicated thing. But maybe I'm being young and naive, but it's like we got to do something. Otherwise, we end up in fights like this, right? We end up with protest people on the street, people getting arrested. Someone will get hurt sooner or later, frankly.
Well, it sounds like they already have. It sounded like when they were protesting, they actually sent the RCMP in. The RCMP were quite violent with the arrests from their accounting.
Yeah. No, it's a breakdown of civil society. It's not. Anyway, I mean, I'm a supporter of Wet'suwet'en for sure. It's a shame. I have a great book called Colonialism on Trial, Colonization on Trial. And it's this beautiful sort of newspaper clipping scrapbook following the Delgamuukw trial decision in BC. It was it was one of the first trials in the New Vancouver courthouse. It's got a lot of history. The Chief Justice overheard it. It's a really interesting case. Yeah, yeah.
I want to kind of come back to the big picture as we kind of get closer to the time that we are up. So I was kind of like, looking at my Aboriginal Law 101, Section 35 of the Constitution Act. And at least this is off of the government website as of now. It says, quote unquote, promise that Indigenous nations will become partners in confederation on a basis of a fair and just reconciliation between Indigenous peoples and the Crown. And so from my kind of reading of that, I'd be curious to know your perspective. Things that come up for me in understanding that is like self-determination and self-governance. And I'm curious to like when I read that to you, like what do you think is like the core there?
Self-determination. I mean, my brain goes to reconciliation, the word reconciliation. I'm a sucker for it and I still believe in it.
What does it
But
mean? Let's like define
complicated.
reconciliation.
So there's different meanings to it. And unfortunately, the concept is being ruined and watered down by both. All heads of government seem to want to put every agreement they sign with the First Nation, they call it a reconciliation agreement. Reconciliation agreement, sign this reconciliation agreement. That's absolutely ruining the concept because these are not reconciliation agreements, I don't think, most of the ones that I've seen. I've spoken to First Nations folks who call it reconciliation with a WR, rec, like WRECK and
Reconciliation.
Yeah, which is a shame because I think it is an important concept and it is sort of a guiding light for future relations in the country. No, I think reconciliation isn't an end zone. It's a process, and it's a process that involves give and take from both sides, right? It's this. I mean, the country is really emerging of three societies. It's francophone, anglophone, and indigenous, and we're working on the sort of indigenous part. And I do think it's important to remember that it is a process. I mean, it's taken us 300 years to get to this point. Reconciliation isn't going to happen in my lifetime. It'll be the next, or maybe the one after. It'll be a long process.
If we could kind of try to nail down a definition of what that process is, could you try to attempt that? And I'll try to be the midwife.
So it's a merging of sort of indigenous and Canadian or Euro-Canadian legal concepts and societies. I think it's a question of recognizing the promises that were made and the relationship that existed at the start of the country. I really think when Canada was sort of created, there is 100 years, 150 years of alliance between First Nations and the British Crown. Really isn't until the 19th century that the worst sort of, I mean, not the worst effects, but the really kind of overt modern colonization begins and the relationship changes and Indigenous peoples and interests and needs become much more subservient. But that first 100 years is when the country was founded. First 100 years, there's current legislation that sort of has roots in that first 100 years. And I think we're moving towards a relationship that is more equal, that is more like those first 100 years than it has been like the last 150 years. It's going to take a long time. And that isn't really a definition of reconciliation, but I think it can help sort of paint a bit of a picture of it.
Sure. From me understanding what you said, it kind of sounds like an openness to be influenced by kind of the somewhat right now separate bodies of law, where it's like we actually recognize their laws and maybe are even influenced and adopt some of them. Is that kind of...
I think we already have. I think it's a constant disservice, I think, done to First Nations across the country. How much of sort of Canadian culture, quote unquote, is borrowed from Indigenous people. I mean, you think of any sort of Canadian iconography, canoes, beavers, like these are all Indigenous things, right? Canoe's even an Indigenous word, I think. Kayaks, right? Like all this stuff. I think we don't quite recognize how much was shared from First Nations to sort of broader Canadian culture.
It's interesting. It's almost like we've taken like the thrust of colonization even into those language pieces of those named items like canoe.
Oh, Manitoba is an Indigenous word. I mean, British Columbia is not.
No, definitely not.
It's something we got to work on. But Ontario, I think, is an Indigenous word. I think Quebec is an Indigenous word. And I say sharing. You could call it appropriation in many instances too.
Yes,
but it's there, right?
Okay. So I'm curious if let's say we've continued this process of reconciliation, and what do you think? Maybe 20 years is too short-sighted. Like, let's say upon your deathbed, or even like, generations later, what will Canada look like if true reconciliation has happened?
Oh, geez. That's a great question. I think what we're talking about sort of broadly is what are the limits of a third head of government in the country that hasn't really been recognized to date?
Hmm.
That is when we know roughly what those limits are, and you'll never know exactly what they are. That's probably when we've reached a point of reconciliation, I guess. And I say we'll never know exactly what the limits are because there's always like the province and the feds don't know exactly what the limits are between the two of them. They're still fighting about, the details in these things. But that's I suppose maybe that's what reconciliation looks like.
What would it look like in more practical terms? Like, what do you think that would, like, that's kind of like a legal, almost like abstract, hard to,
Oh, you okay? Like what can the government do tomorrow?
no, I'm just
um,
curious to know what it might look like in terms of, you know,
in for BC, I'd love to see the government admit possession like the fight that many First Nations have about Aboriginal title is, prove you own that bit. Now prove you own the bit beside it. And it's like, how do
uh,
you do that? That's really difficult. Proving land ownership is difficult. And it's kind of silly because of course they would have used all the things that available that they're disposable. They were people, right? People take advantage of things like idle hands, are the devil's plaything. People just start doing stuff in their spare time. So of course they would have made a living from their lands. You don't have to prove that they use that tree. Of course you can just assume they would have. That would be a big step forward, I think, for the province and for relations. We were talking about wins earlier. I know, I think a quiet success was Jody Wilson-Raybould when she was the Attorney General. The federal government had a new directive on litigation with Aboriginal peoples that I think, did away with some of the more contentious and disrespectful things that lawyers could have argued if they wanted to in front of a judge, which is sort of a nice, credit to this federal government for that, and their former Attorney General. Yeah. I mean, what else? Easy sort of things. What would be another big step forward? We could do what we do in the States. So the American states have an interesting relationship where when there's a lawsuit that involves a band in America, the federal government usually comes in on the same side as the band suing a state.
hmm.
Whereas in Canada, that's not the case. Generally, lawsuits are pit the First Nation against the province, and then the federal government just kind of sits there and doesn't participate super much. But it'd be great if this federal government copied what the Americans do and came in on the side of the bands.
Oh,
That would
interesting.
be a big help for First Nations across the board. It'd be a significant policy change, but it's not without precedent, right? They do it in the States.
What's preventing it?
Oh, I have no idea. I'd love to meet the attorney or minister of justice. I think it is federally. I'd love to meet them and ask.
I'm wondering, and I know we're wrapping up soon, but I'm wondering whether it has anything to do with the fact that the federal government seems to be quite, kind of rubbing shoulders with industry, like the extractive industries, and be kind of benefiting from a lot of those activities.
Yeah. I mean, I feel like Canadian governments have always rubbed shoulders. I mean, industry and government, those relations go back hundreds of years.
Hmm.
I think there's always an element or the risk of sort of doublespeak from government. I think there's lots of rhetoric that gets thrown around. I mean, UNDRIP, we haven't talked about UNDRIP. That's a great
No.
example
How
of
did we skip UNDRIP?
yeah, a great example of powerful rhetoric that doesn't necessarily, I think, mean that much on the ground.
Let's break down UNDRIP quickly for our listeners, just to know what it is.
Quickly, yeah. So UNDRIP stands for the United Nations Declaration on the Rights of Indigenous Peoples. I think it's been quote unquote adopted in local legislation everywhere in the country. I think every province and the federal government in BC definitely have UNDRIP legislation. It's a very topical concept. I think it's a very powerful. I think it's a good document and it's very powerful rhetorically. I'm skeptical that it'll have any pull in court. There's at least one judge who disagrees with me in Quebec.
Well, that's
Um,
good.
yeah, absolutely. No,
Good
totally.
news.
But there's also a couple decisions from British Columbia that go the other way and say this is not that useful. There are no legal hooks in it. We don't know. This is something that'll probably work its way up the courts, and we'll see lots of litigation over. But I'm a bit of a cynic as to its value, and I think that it has a lot of pull sort of rhetorically, politically, but doesn't actually do that much on the ground. And it's a good example of government saying reconciliation and then not actually doing reconciliation.
But is there a sense of hope, at least in the judiciary, that as these court cases continue to come up, and so is Wet'suwet'en or Leroux that's come out recently, and all that. So do you at least have a sense of like hope that we'll kind of slowly get there, and maybe UNDRIP will eventually?
Oh, totally. And I'll say, like,
North Star.
I can't speak for the judiciary for sure, but this is progress. This is moving forward. Just pushing these questions is progress, I think. There will be losses for First Nations in courts in the future, like absolutely, and that'll be part of reconciliation. But even these losses, I think, are important because you're forcing the question, you're pushing the law forward, you're helping us know where the boundaries are. That ends up being good for everybody, I think. And of course, it's even better when the Aboriginal band wins, when the right wins.
But it sounds like what I'm picking up on in your concept of reconciliation is that it does not mean we just go with whatever the band says. Reconciliation seems to have a lot of compromise.
Totally, it goes both ways. Yeah, this isn't. And this is, I think, a common misconception is it's not a zero-sum game. It's not like recognizing Aboriginal rights is removing rights from other people. There is a way for this to sort of succeed for everyone. And reconciliation is a two-way street, right? It's about both sides coming together. It's not just one side. Now, obviously, there's a very one-sided history for the last 100 years, but it takes two to reconcile, right? So, and yeah, it'll be a long process. And it is, we are in the process of, the subjugated party for the last 150 years is pushing back. That's the harder thing to do, right? Is to stand up after you've been held down for a long time. So
yeah. Okay. So last question. So who or what in your line of work really inspires you?
Oh, absolutely. Clients, all the time. There are times when I think it's amazing that you will find a community who's willing to reach out to help. I mean, there's no shortage of, there were lots of losses in courts for First Nations. I think a lot of First Nations are gun shy about going to court because it's usually a European, a colonial judge or a settler judge sitting behind the bench. Not that they're, bad people and not doing the best job they can, but I can understand how a First Nation would be hesitant to sort of engage in that realm. And I think I take a lot of inspiration from the leadership in these communities, the weight of some of the decisions that these folks have to make, both for their sort of, immediate communities and their sort of broader rights. These are difficult things, and it takes a lot of leadership, and it's amazing meeting people who do it.
Are you allowed to name them just to kind of call out?
Oh,
kind of give them like claps, shout out.
I mean, I give a lot of credit to New Chatlet. I actually think they've shown a lot of restraint, which I think has been really intelligent on their part. It's been very strategic. And also, yeah, for sort of shooting for the stars.
So great. Okay, Owen, I think that's time. So thank you so much for joining me. And thank you for our listeners for sticking with us all the way to the end. I hope you enjoyed this conversation. Hopefully you learned something interesting. And thanks again.
Yeah, cool. No, thanks for having me. It was great.
Hi there, Connor Curtis, Head of Communications with Sierra Club Canada, just jumping in to do the Q&A for this episode. So the Q&As are not connected to the episode in any way. They don't reflect the views of our guests. It's just a chance for people to send in their questions to us on the environment and for us to answer them. And so we also encourage you, if you're listening, to send in your questions on the environment. And the question that we're going to be answering this week in the podcast is, Alberta drains raw sewage from lagoons into our lakes. What bacteria and viruses are present? So I reached out to our Prairie chapter and got their feedback on this, and I'm going to share what they have to say. It's going to be a bit more general because really in order to answer this question in a meaningful way, we would need to know more specifics about exactly where is being talked about and what sort of sewage is being drained. And so, but here's what the Prairie chapter did have to say of this generally, and I am inviting a person who asked the question, or maybe people listening in with the specific issue, to write in and give us more specifics, and we'll be able to get a more precise answer. But nonetheless, here's what the Prairie chapter had to say. In Alberta, municipalities are supposed to treat wastewater The province might have some jurisdiction regarding monitoring standards, but one would need to look at a more local level to assess the situation. Raw sewage can't be simply dumped into water bodies by major city centres, and it shouldn't be regardless of the size. The city of Calgary has an extensive treatment process and decontaminates the wastewater to mitigate risk. Smaller cities and towns are still required to treat their wastewater, but depending on where this is and available funds and other factors like aging infrastructure, some treatment plants have differing abilities to treat waste. Certain biological controls require more advanced processes than smaller municipalities have the capacity to do. This is likely a common issue and speaks to a wider issue of funding for rural treatment plants and upgrades. That being said, the water coming from these plants is still supposed to be treated and in some capacity and should not be raw. Of course, there is always risk, and processing could always be improved, for instance, on the nutrients contained in wastewater. There are stories of, for example, older septic tanks around some lakes in Saskatchewan that aren't maintained and pose a risk of leakage. But again, that's a very local situation. Regarding what viruses you might find, E. coli is a bacterium that can be found in water bodies that receive wastewater, but not all strains are virulent or cause harm. It can also come from waste from cattle, so even agricultural waste could be a possible contaminant. Again, in order to dive more into, specifically what viruses and bacteriums we're talking about in this case, we need to know a bit more about the situation. I recognize this is a very general overview to your question. We'd need more specifics on what's happening locally in order to look into this in depth, and I want to say please do feel free to follow up with us. You can send us your Q&A questions for us to answer during an upcoming podcast episode at info@sierraclub.ca. A reminder also that you can take action on environmental issues by visiting sierraclub.ca. We have tons of petitions, other actions and events, and regular news updates you can sign up for on the homepage. You can also find Sierra Club Canada on social media, and you can listen to the Environment in Canada podcast on Spotify, Apple Podcasts, iHeartRadio, and YouTube, or wherever you get your podcasts. This podcast also airs on CKUT Broadcast Radio in Montreal, 90.3 FM, bi-weekly on Tuesdays at 11 a.m. ET. Don't forget to click follow or subscribe so you get the latest episodes from us. Welcome to another episode of the Environment in Canada podcast, a podcast about the environment in Canada by Sierra Club Canada. I'm Connor Curtis, Head of Communications at Sierra Club Canada, and today I'm going to be talking with Professor T. Bertel Dawson, an Associate Professor at the University of Carleton's Department of Law and Legal Studies. We're going to be talking about the rights of nature, a concept you might be familiar with from some of our earlier communications. How rights for nature is an increasingly implemented legal system from places like New Zealand to Bangladesh to Quebec, and why it's strange we would assume nature doesn't have rights. Before we begin, just a reminder that you can take action on environmental issues, including the rights of nature, by visiting sierraclub.ca. We have tons of petitions, other actions and events, and regular news updates you can sign up for on the homepage. You can also find Sierra Club Canada on social media, and you can listen to the Environment in Canada podcast on Spotify, Apple Podcasts, iHeartRadio, and YouTube, or wherever you get your podcasts. This podcast also airs on CKUT Broadcast Radio in Montreal, 90.3 FM bi-weekly on Tuesdays at 11 a.m. ET. Don't forget to click follow or subscribe so you get the latest episodes from us. Thank you for joining me today on the podcast.
It's great to be with you.
Can you tell me a little bit about yourself and how you got involved with work on the rights of nature?
Okay, so I was born in New Zealand and I came to Canada in 1983. And I'm a professor at Carleton University in Ottawa in the Department of Law and Legal Studies. So this is a program which focuses on law and society, and it's interdisciplinary. But my training is squarely in law. So when I began at the university, and the first time I encountered the rights of nature, it was teaching a course called Private Law. And there were three main components to the course. One was the law of persons, one was the law of property, and one was the law of obligations. And these are fundamental building blocks of the law. Like somebody's even said, they're sort of the heart of the semantic architecture of Western legal systems. So what the law of persons does is it defines the legal subject, who it is who is visible in the law, who has legal standing, is capable of holding rights, and has a legal life, if you will. And then there's property, which is those resources which have been identified as valuable, as things that can be owned, sold, and transferred. And the law of obligations is the doctrines and rights which protect the legal person and property. So it was a blockbuster kind of a course to take on and think about. And those first materials weren't my own materials. I inherited them in the department, but they included an article by Christopher Stone, the famous article by Christopher Stone, Should Trees Have Legal Standing? And towards rights for natural objects. It was published in 1972, so it was actually quite recent back then. But it had caused a sensation when it was published. And he had proposed, and this is a quote, proposed that we give rights to forests, oceans, rivers, and to other so-called legal objects, indeed to the natural environment as a whole. So he later recalled it as a vague, if heartfelt idea that he tossed off in the heat of a lecture and then worked up into an article. It caused a sensation, and it got into the hands of nature's Justice Douglas of the Supreme Court of the United States, when it was hearing another famous case, Sierra Club and Morton. And that was a case in which the Sierra Club wanted to object to the development of a ski resort in the Sierra Madre. And the question was, well, did the Sierra Club have the legal standing to have sufficient connection to the area or to the project to raise an objection to the plans of the Forest Service? And the majority of the Supreme Court of the United States said no, the Sierra Club didn't have legal standing. But in his dissent, Justice Douglas said, wouldn't it be simpler if we could just bring an action like this that brought together all the fragmented interests of the natural environment, the eagles, the river, in front of the court in its own name? So it would be the Sierra Madre against Morton. So he took the idea seriously. But in my first encounter with that article, it was early in the introductory material, and I formed the opinion that it was just there kind of to get students a bit stirred up, and that it was really just sort of a bit of a laugh before we settled down into the serious work of the course. I suppose I fit into the category that Stone himself identified of people. Until you see something as having rights, it's kind of unthinkable. It's ridiculous. And I think a lot of people, when they first encounter the idea that nature has rights or could have rights or could be recognized as being a legal person, first reaction is to say, well, it's just not possible. So I took a break from the course a few years later, and I taught it, and I came back about 15 years ago. And so I redeveloped my materials, did some more research in the area. And I learned that this idea towards legal standing for the natural environment had taken off. There was a body of jurisprudence called Earth Jurisprudence. Cormac Cullinan had written a book called Wild Law. The idea was being picked up at the local level. Champlain, Maine had passed an ordinance so that the council could push back against, or could be required to push back against, giving Nestle a permit to draw water from their river. That was the moment when it became real to me. Its transformative potential became real to me. And that's when the rights of nature blew my mind. And I've been engaged with it ever since.
It's funny because you brought up something that I was very much thinking about, which is most of the time when somebody says the word rights, right? Like we have a very kind of common sense idea of what that actually means. And in fact, looking back, I actually did my undergraduate in history and connected to various social movements. And even the idea of rights is not like necessarily as a concept, quote unquote, it's not necessarily like historically, it's very fluid, right? Like what that means. And you go to another period in time, the medieval age, for instance, and, ask people something about rights, they might have very little concept of that in the way that we think about it now. But when we actually look at like the world right now, corporations have rights. I mean, this is a non-person in a sense that has rights. So it's not actually that strange of a concept legally, it seems, but it is interesting how much individually perhaps we have this concept that rights are a certain thing. And I guess this ties into my second question, which is, for some of our audience who are less familiar with that concept, what is the core idea you're giving to this? Is that, again, a natural space can have rights, or I guess maybe there's a clarification I'd love to dive into, which is, what does that mean in terms of like if you're then walking past this lake that has rights?
Okay, so it's a great question. And just as you were asking it, and you mentioned medieval times, I was thinking, well, one of the core ideas, and it goes back even earlier, was this great chain of being that somehow put rocks and stones at the very bottom of the order, and you work your way up and it becomes human beings, and then it becomes the monarch at the very top. So we're very also accustomed to this idea of humans being at the top of the heap and law being for humans, a very anthropocentric way of looking at the world and legal orders. And yes, there have been changes. There's been sort of an opening up of who has rights and how they got those rights, which is kind of foundational when thinking about why it's viable and to think about natural entities as having rights. So a little tutorial then, because you've already said we're familiar with in our society, we're familiar with the term rights, right to life, liberty, security of the person, for example. We're also familiar with the idea of capacity and having legal capacity so that we can make decisions that are legally effective, that have to do with ourselves or our property, the ability to enter into contracts. So there's this idea of having rights and then having capacities. And it's my training, of course, I think of rights in terms of legal rights. And in the context of the law and in the context of rights, well, somebody has to be able to hold them. Somebody has to have them. Somebody has to be able to exercise them and find them useful. So who are the someones is kind of the question you get to pretty quickly. And you've already pointed it out already, that not every entity that holds rights has to be a human being. And indeed, legal person is a term or a category which is different from human being. So corporations are legal persons, they're jural entities, they're represented in court by lawyers or legal representatives. They can take actions in the best interests of the corporation by the officers of the corporation. So they can be very active, even though they're not even remotely human. And this idea that corporations are legal persons is as much of a mind bender, really, as the idea that rivers could be legal persons or ecosystems could be legal persons. And the only reason why we don't let it blow our minds is because we're so accustomed to it. We're so familiar with it. But when the United States Supreme Court came down with one of its iniquitous decisions, the Citizens United case, they really analogized corporations to human beings and having rights to free speech and expression. But after that, there was a perfectly legitimate and appropriate hue and cry from people about how it is that this corporation could have legal existence, how it could have and accumulate so much power and wealth. And there was a movement started in Vermont to that corporations aren't legal persons, and whatever legal provisions there are that say that they're legal persons should be repealed or changed. So But yes, corporations are legal persons. So if you follow the line through that, then it's actually relatively non-controversial that a non-human entity could have legal rights, and that's the platform or the base on which this idea of rights of nature has been built. So what rights of nature is about seeking recognition for natural entities as legal persons or juristic or jural of the law, jural entities with legal rights and legal standing to protect them at the negotiating table with Hydro-Quebec, at the negotiating table if there are development proposals that affect the natural entity. But not just at the negotiating table, although very importantly, this idea of the natural entity having a voice outside of the courtroom as well, and that it becomes a member of conversations in its own rights and its own best interests.
Yeah.
But if necessary, the river, the mountain can go to court through its human representatives and seek remedies for breach of rights or an injunction to stop whatever harmful activity is going on. And so remedy is to receive damages, hold it in a trust fund, and to pay it out if somebody else takes the river to court. So kind of there's an architecture or a structure that can be put in place in which rights of nature is about putting in place for natural entities. But at the same time, the rights, so we're talking about legal rights.
Mm-hmm.
We're not talking about human rights. Corporations don't have human rights. Rivers don't need or want human rights. They want river rights. So human rights are about our existence as human beings within our society. And river rights are about the rights of rivers to be and how it is, how it lives and breathes in its society and its ecosystem. So the rights. So that's another kind of barrier you sometimes get. Well, what use is the law for rivers, for nature? What use are human rights for rivers? And you can say, well, they're no use at all. And the fact that you're asking that question kind of reflects the idea that the law is anthropocentric and that humans are right at the top of that great chain of being, and only things that matter to humans matter in the law. So what are the river rights then? Well, in the Magpie River in Canada, there was a declaration of river rights. So these would be rights to be free from pollution, to maintain its natural biodiversity and to nurture the diversity of life that lives within it and in its ecosystem, its catchment or watershed, the right to maintain natural cycles and the right to flow. A number of the rivers where legal personhood has been sought for rivers have been rivers that have been dammed with this redevelopment of dams. And that involves not just the government in relation to Indigenous peoples, but also corporations and the private sector and private sector rights. So river rights, so rights of nature, seeking recognition of natural entities as legal persons who have standing in the law, who have rights that are appropriate to its existence and its life. For rivers, the right to flow and be free of pollution and to sustain its biodiversity. And Christopher Stone, he said, he responded to some questions he got. Well, why do you have to put it that way? Why do you have to say river rights or legal personhood rights? And, if we go back up the sort of the list of the kind of my logic structure, well, there's part of the answer there, that it's familiar. It's about law and legal rights. And it's a really remarkably open-ended and flexible category of who can get in, who isn't in. And its familiarity, I think, first of all, saves us the burden of having to come up with something completely new. and also allows us to build from an existing foundation. The other thing he said, which is interesting, and there's this, I've sort of made these points that it's perfectly normal, it's perfectly possible, it's been recognized in law before, and that's kind of the strategy in rights of nature, to say nothing to look at here, we're just doing what the law already allows. But there is another part of rights of nature in relation to legal personhood or recognition of the animate nature of nature, and it's very transformative. What Stone said to us nearly 60 years ago was, and here's a quote, "A society in which it is stated, however vaguely, that rivers have legal rights would evolve a different legal system than one which did not employ that expression." So by bringing nature in, we begin a transformation process, and we begin to knock away the idea of an anthropocentric, humans first framework of analysis and of what the law consists of.
And it's raising some questions for me, which are interesting, because it's funny, when in the earlier question, I realized I'd framed things very much from a Western point of view, myself, because that's what I did my history degree on, and that's what was taught mostly, right, was that viewpoint. But it's also true that, like, this is not a new concept either. And as you're talking about, I mean, this paper is 60 years now, that this notion that we could be undergoing this transformation, sure, but even before that, for thousands of years, there are indigenous concepts that reflect this. I mean, you can go back to Europe, and you can go back pre-Enlightenment, and you can find like belief systems that were not necessarily anthropocentric even in Europe. And so it is funny how much you've given a great kind of understanding of what this looks like from a legal perspective. But now I have all these questions that have come to mind, because I'm going, yeah, actually, in some ways we're not having to understand something that's necessarily like should be hard to understand. It seems to be actually more fundamental. And in a weird way, the way we look at legality and rights now is a construct we've created in a very recent period.
That's right.
And I also like just the idea of communications, right? Like for me, that's my background. I work in communications, not law. So the idea that by acknowledging the rights of nature, now I'm having a conversation not only between, say, people who live next to a natural environment, but also with the environment itself, is it's something I'm going to have to go home and spend a lot of time thinking about.
Yeah. I mean, you have raised a very important point, that sort of in the middle of the 17th century, 18th century, there was a big change in the way in which law was framed, and that was the sort of the moment of the English Enlightenment, the European Enlightenments, the final decline of feudalism, and so there were some new ideas that the individual, democracy rather than the monarch, of trying to keep the state out of everybody's business. So a very strong push towards that, and kind of that's become the foundation for what I think it suited the industrial, and grew out of the industrial revolutions as well. So it fostered the sort of economic model that we've got now, which, in an extremely short period of time, when you think of how long our planet has been here, what is it, 250, 300, 350 years, has brought us to the very brink in terms of sustainability of life systems, because of the damage that an industrial economy and a legal system which is built around sustaining or supporting that kind of industrial economy, the corporation as an individual, it's just less than a blink of an eye. Huge amounts of inequality that have developed, the period of colonization, decimation, the disaster for Indigenous peoples with the arrival of European nations.
I was going to say, often Indigenous people still to this day leading on this concept, as I understand it, and often leading the charge to have the rights of nature recognized.
Yeah, absolutely. Oh gosh, where to start though? So if we can just sort of circle back a sec.
Sure. Yeah.
Right. So I just sort of want to mention some of the ideas that are part of rights of nature thinking.
Sure.
It's not just about rights, but they're more fundamental ideas, and they, by and large, come from Indigenous legal orders and governance orders and ethical orders as well. But the idea that nature is animate and alive. The legal system that we developed with the advent of the industrial economy thought of nature as dead, as inanimate, as a thing, infinitely fungible, not having any inherent characteristics or life force. So rights of nature takes on board the idea that nature is animate and alive. There was also, and that nature and humans, and indeed nature and humans and other living species, are in an integral relationship with one another. They're not separate. Our legal system has it's the structure of persons and property. Persons think of nature as something external to them, as other, and with the great potentiality of being property, something which can be owned and exploited and turned into commodities. So these ideas that nature is animate and alive, that nature and humans aren't separate but integrated together, these are transformational ideas within rights of nature as well. Another idea that sort of is just that you've mentioned sort of the historical perspectives, and in feudalism, the private property didn't really exist. It would have been a very hard concept to grasp. Even farming, a lot of farming was done on strips of land, which required collaboration between different farmers. But the obligation of stewardship wasn't about ownership, but it was about stewardship of land and of nature, and even the existence of the commons as a reservoir of life and health. So another idea that's part of this rights of nature thinking that reflects Indigenous ways of being and knowing is this idea that nature is abundant. What our Western way of thinking has done is to say, oh, well, nature's scarce. So we have to have this system of allocating access and control and decision-making. We need to cut up nature into these blocks that can be owned because there's not enough to go around. And Robin Kimmerer, of course, has said, well, that's actually a construct. Scarcity is a construct. It's wasn't a fact or an empirical reality. But the idea is that if given the chance, the earth is bursting with life and capacity for regeneration. And that idea of somehow changing the legal structure which has been imposed on top of the earth is core to rights of nature, to remove the agents of destruction, pollution, and emissions that have created real conditions of scarcity and risk, and have done nothing at all to protect or enhance the world we live in. So those ideas, kind of, where do we get those ideas from now? Well, some from history, European history, but some, I think, from Indigenous ways of knowing and being, for sure.
And I'm curious, you touched on this a little bit earlier with the Magpie River, for instance, but are there cases where the rights of nature have already been applied, and how was this achieved? What brought it from point A to point B?
Okay, well, great. Yes, there's tons happening, and it's pretty exciting. And there are four approaches that have been used, some with more success than others. So I'll start off with constitutional change. So Ecuador, Bolivia have changed their constitutions to recognize Mother Nature as a being in the life of Ecuadorians and Bolivians. So that wouldn't happen in Canada. We can't change our constitution all that easily. But it's a constitutional change. Another has been going to court. And this is different than the climate change litigation by youth, in which they're claiming human rights to a livable planet. Right. But this is where cases have gone to court to say rivers should be recognized as legal persons primarily. So Bangladesh, in principle, courts have declared that all rivers in Bangladesh are legal persons. The Columbia-Arato River is a legal person through court decisions of judges. What judges are doing there is they're drawing on an ancient jurisdiction of courts and judges to take care of the vulnerable. So the vulnerability here is the river that's vulnerable to damage from human actions. There was the River Ganges as well in India. There was a decision by a judge in the High Court of India to recognize or say that the Ganges was a legal person. But that got, the High Court stayed that ruling, and courts aren't all that well situated to go into the nitty-gritty of how it could work and how it would work if nature was a legal person. What I think rights of nature thinkers and activists want is for courts to recognize legal personhood when it's brought to them through a couple of other means that have been used. So one of the ways that it's been used most notably, and I would argue kind of successfully in a transformational way, has been in New Zealand. So when I say at the beginning of our conversation, I grew up in New Zealand, I mean, I sort of have a watching brief about New Zealand. And so I was delighted to learn that there had been innovations in New Zealand. So there are two, about to be three, natural entities, elements of nature, that have been declared or recognized through legislation from a national parliament as legal persons and having all the rights and capacities of legal persons. So the first time was the Te Uawera. It's a wilderness area. It's an ecosystem. It has been or was a national park. It's also the traditional lands of an Indigenous nation. So that was recognized in 2014 as a legal person. It was no longer a national park, and a new system of representation and management of the area was introduced. In 2017, the Whanganui River, which is one of New Zealand's longest rivers, sort of between Auckland and Hamilton, it kind of rises in Hamilton, which is south of Auckland, and winds its way 300 kilometres south to the city of Wanganui. So that was recognised as a legal person in legislation, and the legislation sets out how that will work, and it also has a very and the same in the Te Uawera situation, a very eloquent and beautiful way of framing the relationship of the Indigenous people of the Maori of those areas, their relationship with the river, with the ecosystem. And there's currently a proposal for Mount Taranaki to be seen as a legal person. And again, Mount Taranaki used to be called Mount Egmont after a Governor-General appointed by the colonial government in the United Kingdom. Became Taranaki National Park. And a mountain like it's kind of like Mount Fuji. So it's one of these cylindrical volcanic mountains. And it has snow. The snow comes down in rivers. It's cyclical. It sustains an enormous ecosystem, the Taranaki Plains. So it's a mountain. It's sacred to the Maori in the area, an unbroken relationship between the mountain and the people. In fact, in relation to the river, it's right in the legislation. I am the river is me. There's no separation between the people and the river or the ecosystem. So those are three examples where this has been done. And again, you sort of raised the point about sources or inspirations from Indigenous ways of being and ordering. Well, these three examples in New Zealand were absolutely initiated by Indigenous people and grounded in Indigenous cosmology, ways of seeing and being in the world. And they were part of settling breaches of New Zealand's founding treaty, the Treaty of Waitangi, which, as in Canada, set out, sort of said Britain can have some sovereignty, but there are continuing rights of Indigenous peoples in New Zealand. But, well, as in Canada, those grand hopes on certainly on the Indigenous side, that it would be possible to integrate and manage these new people who were coming in by the boatload, they were very soon dispelled. There was war, there was confiscations of land, horrific attacks, deprivations, exclusions of Indigenous people from their place of being. And in fact, even in Canada with national parks, to found national parks in this country, it was, they were supposed to be these wilderness, people-free world.
There's a history there that we've documented on our website where we talk about the early Sierra, granted the U.S. Sierra Club, but still an organization from which we take our name by being a legally separate entity, and an organization that we work with, and they too have had to, talk about what is the history of this, advocating for national parks and treating those spaces as if nobody was there. And then the people who were in fact there and did in fact know that, often being forced either to vacate or to take on roles within a park system that deeply offensive and harmful in the long run. So
that's right. Yeah. It was in Canada as well. Banff National Park, Riding National Park. Their housing shelters were destroyed. They were gone. And the National Park Canada, what is the organization in Canada? Let's say Parks Canada. There it is.
Right. Yeah.
Parks Canada has begun to fundamentally change its relationship with Indigenous peoples, given that background. So New Zealand legislation grounded in Indigenous claims for restoration and reconciliation, and frankly, indigenization of their territories. The removal of Western law is not far behind in the thinking of these settlements. And, Jacinda Ruru, who was part of the Te Uawera and the Whanganui River, she had read Christopher Stone. The government negotiators had read Christopher Stone. They got to a stalemate. How are they going to get through it? Well, the idea was that legal personhood became an easy way to actually stop talking about who owned what, because the river or the ecosystem is the legal person, and there's ownership. So it was kind of a way of stepping away from that unresolvable question of ownership and property. Constitutional change, court challenges, legislation primarily to settle Indigenous claims. And Jacinda Ruru has made the point that this kind of thing, it really needs to be initiated by Indigenous peoples, led by Indigenous peoples. It's an Indigenous-led conservation model. It's not only conservation, it's also about sustainable use by Indigenous peoples within their territories. And it's consistent with the UN Declaration on the Rights of Indigenous People, about Indigenous peoples reclaiming their territories and how they are governed. So there's been another approach, and that's in Canada, a joint declaration between a regional municipality in Quebec and the Indigenous nation. That's the Magpie River. So it's a local declaration setting out rights. And the hope is that if hydro wants to develop some more, that declaration could be used in court to bring a different perspective into play, the perspective of the river.
Well, and that's something I wanted to ask you about, was before we go, because I know we are running out of time, I wanted to ask very specifically about what are some of the on-the-ground ramifications? What do you see, as a result of this? What does it change maybe for people afterwards?
Okay, so it's a standing place. It's a voice of the river at the table. It's a reset and a changing of relationships with the river. And Hydro-Quebec has already, I think, indicated that it knows it's time for them to change its relationship with Indigenous people and the resources where it has done the hydroelectric development. In New Zealand, there are new management structures, and in the Te Uawera, when they did their first sort of management plan, they said this is a plan about managing people and people's relationship to this ecosystem. It's not about managing the ecosystem. And that's sort of it's against some of its conceptual shifts, but with legal effect if and when called upon. And the CEO of the new body, the new kind of corporation, if you will, that is active in the Te Uawera, has said, we're able to do this so much better through this body than the government in New Zealand's ever been able to do it. They could send maybe 3 or 4 conservation officers at a time, but if we need to remove invasive species, we can mobilize 5,000 people who are our people. So a very much more integrated and effective approach to conservation that's locally based and driven by Indigenous people. In Canada, we have Indigenous protected and conserved areas, which are happening at the same time. And there's a common idea between rights of nature, legal personhood, and Indigenous protected and conserved areas. That's guardianship, involving elders and youth mentorship, getting back to the land, learning the land as the source of law and abundance, and being able to thrive as communities and nations. So those are some of the ways in which there have been practical changes on the ground.
In case you had a couple of other things that you wanted to chat about before we go, I just wanted to give, we have a couple more minutes left, so by all means, go ahead.
Okay, great. So when we began to talk, I sort of talked about my initial encounter with Christopher Stone's article, and then coming back and seeing it through new eyes and having it blow my own mind. In my own teaching and thinking over the last 15 years, rights of nature there's been an urgency in my teaching with my students. What's an education for on a planet with a biosphere? What's an education for? What's a legal education for in an environment where we're facing pollution, loss of biodiversity, climate breakdown? It's not about producing the same way of thinking or the same way of being among our students and those who go on to law school. So there's been an urgency in my thinking to sort of to open ways of thinking about our earth and our law and our relationships with it. So to me, rights of nature, it disrupts and interrupts the paradigm of humans first, of Western law, of legal persons as individuals, and of property and commodification of property. Think about it. Trees, where it all began. Do trees have legal standing? A tree standing in a forest, in an ecosystem, is an entity. It's a being. Think of the kauri trees in New Zealand or the redwoods in California, hundreds, thousands of years old, supporting entire ecosystems within one tree. But our Western way of thinking has said a tree, lumber. So the logic of law, of property law, property and forest tenures has turned nature into a commodity. And so we have to interrupt that way of thinking about property as well and introduce the idea that the planet, the forest, the tree are habitat. They're habitat for all of us and the source in which the source of all life, beginning and continuing. So my passion in my teaching has been to interrupt the paradigms of Western law and think about new ways to think about and act upon this in law. If you like, the new generation of negotiators in relation to that river or that mountain or that ecosystem. But it's also, to me, about opening up that space that gets opened with the interruption and bringing in Indigenous ways of knowing and being, Indigenous legal orders and Indigenous governance orders, Indigenous ethics to learn with, to sit with as non-Indigenous people. All of the good ideas about how to live in our habitat are in Indigenous ways of knowing and being and ethical structures already. So if we are, that's where the space comes from. And And the really encouraging thing is that there are Indigenous scholars in Canada who are saying, there's a kind of a new approach, a relational rights of nature, which draws in all of the little bits and pieces in Canadian law. Section 35, Aboriginal rights, envisages a multi-societal or a multi-juridical framework. There's not just one legal system. We know we have civil law and common law, but there's also Indigenous law. And so Section 35 also envisages that these legal orders living together. We've got the Canadian law of the legal person. Women are legal persons because of the living tree. Trees always figure in these discussions. The living tree of our Constitution, which can grow and change over time, open-ended and flexible. So we have a legal tool that we can use as well. And international documents as well allow us to pull in other modalities. So the idea is then that we can, in Canada, structure a distinctive rights of nature that builds on all of the threads and connections around law and rights and our habitat here on planet Earth. So I just thought it would be good to sort of say, well, to me, it's has been a passion, so that today's young people, my students, graduates, will have a new toolkit, a new way of thinking, will be adept at moving outside of paradigm that was presented as the only way of thinking and being, and that they'll be the agents of change as I end my teaching career in the next year or so.
Professor Dawson, thank you so much for joining me today.
I think it's been a pleasure.
Hi, everyone. So we do at the end of these podcasts a quick Q&A to answer questions from listeners, and we just want to clarify before we get into it for this week that the Q&A answers we give don't in any way reflect the views of our guests who join us on the podcast. This is just a response from Sierra Club Canada to our listeners, and also the subjects don't really tie into the episode because they're usually about previous episodes or other subjects. This week, we had somebody ask, what are some of the actual impacts of offshore oil? And it's an interesting question. It's tied very much into a lot of the work that we are doing right now around the impacts of offshore oil and proposed offshore oil projects like Vega Nord off the coast of Newfoundland and Labrador in Canada, but also to some of our international work with other organizations in other countries that are facing offshore oil development and trying to figure out ways to prevent it from happening. And simply put, there are a number of different impacts of offshore oil, and it kind of varies depending upon what we want to talk about. If we're talking about immediate impacts, there are obviously always the risk of spills that can do a lot of damage to local environments, to the marine ecosystem in the area, but also to larger scale marine ecosystems at the same time. Obviously, an oil spill doesn't have a boundary or no border. It will flow with ocean currents. And we've seen evidence, in fact, that, some of the oil projects that we are helping to fight elsewhere, these don't necessarily stay within a national border, right? This is something that can easily spread across multiple places and on a wide area. In Canada, with the Vega Nord oil project, one of the big concerns we've heard from Indigenous fisheries in New Brunswick is that they could very much be impacted by this offshore oil project that is over in Newfoundland and Labrador, because their salmon population, it could be impacted by that. So again, when we talk about the actual impacts of offshore oil directly, we definitely are talking about the impacts of a potential spill, or whether that's a large spill like a well blowout or smaller spills, but definitely talking about those immediate impacts as one thing. There are the impacts of exploration and sonic testing for oil, which of course can have impacts on whale populations and other species in a given area, and are often underestimated by companies. Often the risk of a spill too is underestimated by the company in question. There are other impacts that, of course, come with oil and gas, which are not just tied to the immediate environmental impacts. So a good example of this, for instance, is looking at the impacts of offshore oil and gas on climate change. If we look at this carbon budget that we have, there really is no room for oil and gas expansion. We've known that for a long time now, over a decade, in fact. That the first research I read came out saying that there was no room for further oil and gas expansion. So that's one massive impact of offshore oil, is that, any expansion of offshore oil really doesn't allow us to meet our carbon budget. It also doesn't allow us to meet national emissions targets if we're talking about expanding into new offshore oil projects. Certainly companies have made a lot of claims about reducing localized emissions to projects, but that doesn't really matter, because it's the cumulative total emissions of the oil. It's the oil when it's burned that really matters. That's where the vast majority of emissions from oil and gas come from, is from the burning of the oil itself. So whenever you hear labeling like, this is green oil, we're going to do green oil in the offshore, that's really false. I mean, there is no such thing as green oil. That even if it has slightly lower emissions at the source, that's not the major source of the emissions. But then there's another aspect of impacts that we maybe don't talk about as much. Definitely there are economic impacts from things like immediate spills, right? We could talk about fisheries being impacted by the risk of an oil spill. In the case of Beta Nord, as high as 16% a chance of a serious spill, something that the company vastly underplayed. If we want to talk about that's one thing. We could also talk about the risk of climate change to things like fisheries and other industries, where we see changes in ocean conditions that could very much lead to the collapse of a lot of Atlantic Canadian fisheries. And this is a huge problem that we are facing right now, and that is worsened with every barrel of oil we extract and burn. There's a third kind of impact, though, economic impact, that we maybe don't talk about as much. I'm talking about this in Newfoundland and Labrador's context, but its context also applies to a lot of other places around the world. Offshore oil is often sold by companies as an economic solution to an area's problems. And in the case of Newfoundland and Labrador, it's sold in terms of jobs, it's sold in terms of economic stability, and in terms of revenue. What we're increasingly seeing with oil and gas in general, let alone just offshore oil, is that the benefits to local economies are increasingly minimized. The jobs are increasingly minimal. We definitely see this with Beta Nord, that the sort of proposed economic impacts that they're saying, the benefits that could come out of it, don't match with what the project actually, even at its peak, even if it worked perfectly, would provide. But as well, in a world that's rapidly transitioning away from oil and gas, these projects are not very viable economically. Now, that doesn't necessarily mean that will stop a company from pursuing them, because companies actually don't always make the most economically sound choices. They are as much at the whim of individuals within the companies themselves thinking something is a good idea as anybody else's. And in the case of Newfoundland and Labrador, we've had a lot of promises around offshore oil creating some sort of bright future for the province, but there isn't the economics to make that point out. Even without the sort of climate aspect of this, where everybody's shifting away from dependence upon oil and how that prevents this from being a viable project, that is some of the most expensive offshore oil to create. So when these projects are sold to places as a solution for local economics, they really shouldn't be, and they really shouldn't be sold as fixes, because what it does is it not only affects, and we've gone into this in a previous podcast episode on Equinor Out, what it really does is sets unrealistic expectations for people that stops them from doing things like, changing their path in their education, or changing or going and getting retraining solutions, right? On an individual level, it means that they might take out things like a mortgage based upon the idea that offshore oil is going to come in and save the day. These are incredibly bad personal impacts that happen when these companies oversell these projects. And in general, oil and gas companies oversell their projects, because they know, and they must know at this point, that a lot of these projects are not viable. But from the second they start to talk about the climate risk of their own oil projects, they make all of the industry's oil projects sound less viable. So it is incredibly hard for them as a company to actually come out and be honest and say, oh, this oil and gas project doesn't actually work. So those are sort of the three impacts, if you like. There's the immediate local impacts of exploration for oil and gas and spills. There's the climate impact, which of course we see in terms of forest fires, extreme weather, but also changing ocean conditions that are a huge threat to fisheries. And then finally, there's the economic aspect of this and the impact it has on local communities. And if you want to find out more, you can find out more about our ongoing legal challenge to Equinor and the Canadian government on the approval of Baden Nord that we are pursuing with Indigenous communities in New Brunswick. You can also find out more about our participation in the global Equinor Out campaign. All of this is available on our website. Thank you for tuning in to another episode of the Environment in Canada podcast. Just a reminder that you can take action on environmental issues like the rights of nature or offshore oil by visiting sierraclub.ca. We have tons of petitions, other actions and events, and regular news updates you can sign up for on the homepage. You can also find Sierra Club Canada on social media, and you can listen to the Environment in Canada podcast on Spotify, Apple Podcasts, iHeartRadio, and YouTube, or wherever you get your podcasts. The podcast also airs on CKUT Broadcast Radio in Montreal, 90.3 FM, bi-weekly on Tuesdays at 11 a.m. ET. Don't forget to click follow or subscribe so you get the latest episodes from us.
Welcome to another episode of the Environment in Canada podcast, a podcast about the environment in Canada by Sierra Club Canada. I'm Jessica Murray, Sierra Club Canada's Ontario Director. Today, I am speaking with Leslie Ann St. Amour, who works at the intersection of Indigenous rights and environmental protection through her work with Raven Trust. Raven, which stands for Respecting Aboriginal Values and Environmental Needs, is a nonprofit organization that works with Indigenous nations to defend their land, water, rights, and culture with access to courts by raising legal defense funds. Leslie Ann is a lawyer who works at Raven as their campaigns director. She grew up in Eastern Ontario and is a member of the Bonachère Algonquin First Nations with both Algonquin and settler heritage. Today, we talk about some of the campaigns that Raven is working on and flesh out concepts like co-jurisdiction, UNDRIP, and how the law is one tool in a larger picture of truth and reconciliation in Canada. Before we begin, just a reminder that you can take action on environmental issues by visiting sierraclub.ca. We have tons of petitions, other actions and events, and regular new updates you can sign up for on the homepage. You can also find Sierra Club Canada on social media and wherever you listen to your podcasts. So Spotify, Apple Podcasts, iHeartRadio, YouTube. Don't forget to click follow or subscribe so you can get the latest episodes from us. I hope you'll enjoy this conversation with Leslie Ann St. Amour. Hello, and welcome to Leslie Ann to The Environment in Canada, a podcast by Sierra Club Canada. Thank you so much for joining us today. It's so nice to see you again.
Thank you so much for having me. I'm really excited.
So to start off, it would be great to just do some round of introductions. So get a sense of who you are, where you're calling from.
Totally. So my name is Leslie Ann St. Amour. I am currently the campaigns director for Raven, and I'm calling in from Victoria, BC. I am a lawyer by training. I spent several years in private practice before joining Raven. And when I was doing that, I was based out of Ontario, and I'm a member of the Bonachère Algonquin First Nation that's also based in Eastern Ontario. And so moving out to BC was a big move for me, and it's been really exciting.
That's great. How was it? How was the move moving from Eastern Ontario to BC?
It was hectic. I gave myself about 5 weeks from accepting the job to when I started, just because of other circumstance. And so I moved out sight unseen to my apartment, did a FaceTime viewing.
Wow.
Thank God I had a really good friend here who helped a lot with the move. Otherwise, would have been a lot more stressful.
Oh my goodness. Yeah, well, I'm glad that you had support during that, because moving across the country is no small feat. That's amazing. Thanks for sharing that. Over to Raven. It'd be great for our listeners to get a sense of who Raven is, what they get up to.
Absolutely. So Raven is a charitable organization that has two focuses that are very intertwined. One is we fundraise and support Indigenous communities that are engaged in the legal system to protect their rights, their territory, and environmental protection. And along with that, we have a mandate that also includes public legal education. So we're sharing not only the stories of the nations that are in court in order to fundraise for them, but also to help people understand this process and why the legal system works the way it does and why nations might be reluctant to go this route and why is it so expensive and are there alternatives and all of those different things. We also have a really great resource called Home on Native Land that focuses not only on the law today, but a little bit of a historical review of the law and Indigenous peoples since contact that I think is really helpful for folks in understanding the context we're in today. So that's what we do. We currently have several different campaigns with different nations. We are working with the Healthsick Nation in BC, who are engaged in the court system in the aftermath of the Nathan Stewart oil spill in their territory. We're working with the Gatineau Nation, who have been challenging the Mining Act in BC and the interpretation of BC's UNDRIP Act. We're working with several Wet'suwet'en hereditary chiefs who are taking Canada to court for not meeting the climate commitments Canada has legislated and how that is impacting their charter rights and their right to life, liberty, and security of the person. We're working with the Relay Cree Nation in Alberta, who are challenging the cumulative effects that have been happening in their territory and how they render their treaty rights essentially meaningless because they're not able to exercise those rights. We're working with a group of nations in Northern Ontario to support their challenge to the interpretation of Treaty 9 and arguing that that actually requires co-jurisdiction of the lands and the resources there. And we're always also looking at supporting what we call our intervener fund, where other nations can apply for funding to intervene in court cases, where they may not be the main parties involved, but if they have a perspective the court needs to hear, we also support them in doing that.
Wow. There's so much going on there to kind of unpack and learn more about. So thank you for sharing all of that. And it's really, really, I think, inspiring to see. The Wet'suwet'en case has definitely been, at least in my world, I've seen that case very front and center, but it's so great to hear that there are so many other cases that are happening as well. I guess to do kind of like a broad stroke, what do you find, if any, is there kind of like a certain kind of pattern or thread that's going through these different cases?
So one of the threads that we really focus on maintaining is that when we support a case, not only are we looking for a case that has potential of success and meets our criteria in terms of relating to Indigenous sovereignty, Indigenous rights, and the environment, but we want to be supporting cases that have the potential to set precedent because there's different ways of changing the laws in this country, and one of them is advocacy at Parliament and trying to convince the legislators to change the law. The other is the court system and setting a new precedent and changing the law that way. And so all of these cases have some aspect of the potential to set a precedent that will change the laws across the country. With the Wet'suwet'en case, it's actually really interesting because unlike in some of our cases that are a little more unique in their realm, this one is part of a movement of climate litigation we're seeing not only in Canada, but across the world right now. And it's a really great example of seeing the case law and precedents develop because at the federal court level, the federal Crown argued that the case should be dismissed, that it didn't have a chance of succeeding and it shouldn't even go to a hearing. And It was appealed to the federal court, and the federal court of appeal, sorry, it was appealed to the federal court of appeal. And at that point, the federal court of appeal said, actually, this case does have a chance. We're going to send it back for a hearing. And this is really exciting because there were similar cases 10, 12 years ago that didn't have that second chance, that were dismissed before a hearing. But we're seeing the way the laws are changing and developing, and the courts are understanding the urgency of climate change more. Lawyers are able to build off of these unsuccessful cases and target their arguments better. And we're seeing change actually happen in a way that is really, really exciting. And because so many different people are bringing climate litigation right now here and across the world, it's a really exciting one to kind of be able to track in real time and see these changes.
Mm-hmm.
And it's really exciting. And I think that's really one of the common threads, is that look at changing the law, not just outcomes for a specific situation.
Sure. And you mentioned that 10, 12 years ago, this was something that was less likely to happen. And I'm curious to know, I have some ideas, but I'm curious to know what your opinion is as to what's changed in kind of the landscape for the judiciary, for it to now be a little bit more open to hearing these sorts of cases.
So it's a couple of things, I think, one of which is quite technical, and it's how some of the arguments have been framed and also what laws have been passed in the meantime. Often the courts can only reflect on, or can only judge, laws that have been passed. Because of the way our separation of powers works, you can argue that the government should be doing something different, but the courts give the government a lot of discretion on how to do something, because the courts aren't the elected body. And so the first time something similar to this was argued, there wasn't the wealth of climate-based legislation that existed to specifically challenge. They were challenging the fact that the government hadn't done these things.
Mm-hmm.
Whereas now they're able to say, well, actually, the government passed this legislation, but they're not fulfilling those obligations.
Mm-hmm.
And so it gives them something more tangible to challenge. I think we're also looking at a world in which there's better evidence, unfortunately, of the urgency of climate change,
Mm-hmm.
which I think really helps in a lot of these climate litigation cases, because it's hard to build an argument around this is what we think will happen.
Mm-hmm.
But unfortunately, now we can say this is what's happening.
Right.
And courts aren't unaware of changing public sentiment.
Mm-hmm.
I don't know that in these cases they've explicitly said this, but sometimes they do in revisiting cases. A really good example that I can think of off the top of my head that's kind of unrelated, but in the constitutional challenges around sex work, the courts did explicitly acknowledge that there had been a lot of societal change since they'd last seen a case looking at sex work. It had been about 30 or 40 years since they had.
Mm-hmm.
And they acknowledged that, and it gave them the opportunity to reconsider. And so they aren't unaware, and they are allowed to kind of match changing public sentiment.
Mm-hmm. Well, thank goodness for that, right?
Yeah.
Yeah.
We'd be in a lot of trouble otherwise.
Yeah, for sure. Especially in Ontario, we've had our fair share. And I know Reclimate recently just came out with their kind of webinar summary on where Canada's at. And it was kind of worrying. I don't know if you tuned into it, but I was shocked. I mean, I think, people like you and I maybe kind of are in some sort of like bubble where we're like, oh, well, we're doing something, so everybody else must be too. And then so to hear that, the general public on the whole is even starting to question whether climate change is man-made is kind of like, oh, I really thought we were done talking about that. That's quite
Yeah, it's so scary looking at things like that. And it's so scary as well because obviously climate change is an international problem.
Mm-hmm.
And so, our neighbors to the south have generally worse numbers than we do on those things. And we know how much of an impact culturally our shared border has. It's just, it is very scary. Not that I'm giving Canada a pass by saying that it is also an us problem, but it's I think we feed off of each other.
Sure. I want to circle back to one of the cases, if you could dive a little bit deeper, because I'm quite interested in this topic of co-jurisdiction and how that's going to work. Like, I feel like, and correct me if I'm wrong, but co-jurisdiction is kind of like a really important stepping stone and when we look at the process of truth and reconciliation. So I'm curious to learn more about the case where co-jurisdiction is coming up as an issue and kind of whatever you can share about it, because I know oftentimes these cases are subject to sensitive information and stuff. But yeah, more information would be really, really cool.
Definitely. So this is the campaign we call our Breathing Lands campaign. And it's because a lot of the territory in Treaty 9 in Northern Ontario is these incredible peatlands that have been historically in Anishinaabe called the Breathing Lands. I can't remember off the top of my head their words for it, but that's the translation. And in this case, with Treaty 9, when it was negotiated, I know this is a podcast, so everyone else can't see me using air quotes, but I really do use that word a little bit tongue-in-cheek because it wasn't really negotiated.
Mm-hmm.
Representatives of the Crown, which in some cases showed up with a treaty already written, would talk a lot of talk and then make no changes to the actual written document. Not that in some ways it mattered because they didn't leave a copy of the written document with the nations who signed it in some cases. In many cases, the only translators available were ones hired by the Crown.
Right.
And so we have to wonder how reliable are those translations that were given to the nations, let alone, not even leaving necessarily a written copy, let alone a copy in their language. And so the oral promises that many of the First Nations received and have understood as being part of the treaty were not recorded in the written treaty. And as our understanding around treaties, particularly the numbered treaties in Canada, is developing in the legal world, we're recognizing that Canada can't just backtrack on the things it promised just because it didn't write them down. Because the nations, even though it's not written evidence, have oral traditions and evidence recorded in other ways of what those promises were. Because, and I think it's helpful to remember this isn't something that happened 300-400 years ago.
Right.
This happened less than 150 years ago. In many cases, these are somebody's grandparents or great-grandparents.
Right.
Stories that aren't even having to be passed down that far. And so we know that these discussions were had. We know that promises were made. And for the nations, they understood this as co-jurisdiction. They understood it as that they were going to be sharing the decision-making over the land. They were not giving up the land. They were promised they would be able to continue their way of life, that they would get to continue to exercise their rights on the land. Ontario interpreted it as, this is now our land. And these nations sometimes get a bit of a bad rap. And I say that because for many, many years, environmental groups really leaned into the idea of the noble savage when working with Indigenous folks. And this idea that Indigenous people will inherently always protect the land in the perfect way. And that's not necessarily true in the sense that some of the nations involved in this case may allow some resource development on their land. But they also have every right to engage in an economy that, unfortunately, is a capitalist economy. And so it's a little bit challenging for some people to get their head around because this is one where we're not explicitly just saying we're going to protect all this land by supporting this co-jurisdiction case. But it's really important that we're going to return the decision-making power to the stewards of this land to let them make those decisions. Because if anybody, in my mind, is going to, well, if anyone has a right to benefit economically from this land, it's these nations. But it's also, some of these developments will probably happen. Some of the mining will happen, because I do understand that we live in a world where we rely on our computers and our smartphones, and I know those minerals are coming from somewhere. And I also don't want to be the person who exports all of that to other parts of the world. But if I'm going to trust anyone to do that, it will be these nations who understand their territory and have lived there for years and know how to do this in a way that's going to have the least impact. The example I gave someone recently is that in my nation, which is different from the Anishinaabe nations up north, but we do have some connections and cultural similarities. The sturgeon are considered a grandfather, and sturgeon are one of the species at risk that a lot of people talk about in Northern Ontario when looking at these projects. And I have a lot more faith in somebody who looks at a sturgeon as a grandfather to engage in this development, because you're not going to just evict your grandfather.
Sure.
You're going to ensure you're doing this work in a way that is good and can protect him and that allows him to continue to flourish. And I think it's those connections that are so important to recognize. I feel like I've gotten a little bit off topic from your question about co-jurisdiction, but I think I've answered some of it. Okay.
Keep going. Yeah, I really love that. One of the major threads that I often see is like really connecting to nature in a way that is kin. Like that's kind of, I think, something that I've seen repeatedly throughout different First Nations groups. I'd love to know more about the story of the sturgeon, actually. Is there a story behind why sturgeon is grandfather?
From what I know, it's mostly just they're recognized as because they're such an old creature and they have been around longer than we have. They're recognized as being a grandfather and wise and an elder in the world. And I'm sure other nations do have more stories about them. And I'm sure folks of my nation who are more knowledgeable might have other stories, but that's the teaching I've received, is that they are these ancient beings, and we knew that, and we recognize that and their wisdom.
I love that. And it kind of really drives home the fact that it's sometimes not necessarily whether a project goes ahead, but also how it's then implemented. So, this is a little bit also off topic, but like nuclear waste is a good example of one where people are like, oh, but it's fine. We'll just bury it in giant concrete tanks and whatever else. And for the most part, whether we could debate whether that will hold long term, but the reality is that when we actually go to complete these projects, that's not the protocol we follow anyways, right? So yeah, that's really kind of good to kind of delineate this idea of the noble savage, and the differences in way that a Western perspective might carry out a project versus a First Nations band that is really so connected to the land. So. Thanks for sharing that.
Happy to, for sure.
So maybe we will circle back to co-jurisdiction now after that beautiful meandering path we just took together. And I'd be curious to know, like when you think about co-jurisdiction and perhaps have these conversations with hereditary chiefs and so on, what does that look like in terms of actual practice? Like, what would that look like in terms of how the relationship works between the federal crown and First Nations bands?
So it can look like a lot of different things. I don't know at this point how Treaty 9 wants it to look, but other nations that have engaged in modern treaty negotiations, for example, often develop some form of that. And some forms of what that can look like are quasi-independent management boards, for example. And I say quasi-independent because they'll have, for example, appointed members from government and from the First Nations. And it'll be that board that will make the decision on a project or a development. And that board will dictate, yes, no, under these conditions. And then the other governments will have to follow that. So it's not kind of independent in that it gets to make its own decisions, but it's based on being appointed members from both.
Right.
Other avenues I've seen are, so one example I can speak to is often when looking at jurisdiction and management of provincial or national parks is co-management plans where nation representatives and the government representatives in charge of managing that park will sit down and develop the 10, 15-year management plan for that park together. Decisions being made about the park are made by this group who generally try to operate towards consensus. I'm sure they have their own protocol for if they really can't reach consensus and like it's imminent, something has to happen.
Mm-hmm.
But generally, with co-management structures, the idea is to get to something everyone is good with. Sometimes it's in land claim agreements, there will be different classifications of land. So the modern treaty in the Yukon, I believe, is one example of this, where they have different, I think it's class A, B, and C land, where class A land, I think, is the one where the First Nations need to consent to anything happening in it.
Mm-hmm.
Class B is a very high level of consultation is required. And then class C is just like standard law applies. There's no heightened requirements. And it's with the idea of being the nations in their negotiation were able to say, these areas are particularly sensitive. We need to consent to anything happening there.
Mm-hmm.
These areas are not necessarily culturally or environmentally sensitive, but we use them and we want to have a say. And lands that like aren't particularly extra special for any reason, and we'd like to know what's happening, but it might be ones that we feel we don't need to be as involved with. And so those are some of the co-jurisdiction structures that I've seen.
Mm-hmm.
But I like to remind people that being a lawyer, I work in this world where everyone's like, go to court, win. But even just starting a court case can open the door to negotiations.
Right.
And negotiations are fun because you can be so creative. You can make things up if you want. It doesn't have to have been done before.
Right.
And sometimes being creative and being willing to really think outside the box can work really well.
Mm.
And so it's just being willing to, I mean, this requires negotiators on all sides who are willing to do this, but it's sometimes you'll get better results than you might have got through a winning court because a court can only kind of order specific things within their jurisdiction, but in negotiations, you can do anything.
Mm-hmm.
And so I think it's also really important to reframe what is a win or what isn't.
Sure.
But sometimes these negotiations can also be really effective and really exciting.
Can you share kind of an example of where like a really creative solution or idea that came out of a negotiation that really worked for everybody?
Well, I mean, one of the things I'll point to is just that like everything I just talked about came out of negotiations.
Like those structures for co-governance.
Yeah. The Yukon one was the first of its kind when they developed that, at least as far as I know. And there's other structures I've seen as well that have come out of things that are really, really interesting. Not always negotiations coming out of a court process, but one of my favorites in BC is there was a group of nations who were working on protection of the caribou and implementing different measures to protect the caribou herd in their area and to boost the population. And it became logistically challenging to be managing that through the structures of their nations just because of the coordination and wanting to access funding and who does the funding go to. And so the nations just created a nonprofit that is in charge of this caribou herd. And the nonprofit is governed by representatives from the nations involved, and they can receive funding. I first discovered this because I wrote a paper in law school about how conservation is actually more effective statistically when you take into account Indigenous knowledge and Indigenous teachings.
Mm-hmm.
And that's how they were leading their conservation work with these caribou. And it was actually more effective than government-led conservation that was focused just on Western science. And so that to me was a really exciting one of seeing these nations seeing what they were doing was working and saying, okay, how do we set this up in a way that lets us continue to do this? And okay, this nonprofit structure exists in Western law. Let's use that. It allows them to continue to do this work in their way.
That's pretty inspiring. And I'm sure, it makes me think of kind of like, it's kind of tricky, because it's like, you have to kind of be inside the system to kind of reap the benefits of the system. And there's like a tension in there that I find where, and maybe this is where in some ways, like there's some thoughts that are attached to the noble savage and this kind of romanticism of how things were and whether we should just revert back to it. But it's really cool to kind of hear a story of people that can move forward in the system that already exists.
Yeah, it is definitely a challenge, but I think there's a lot of potential. Another place lately we're sometimes seeing that challenge is with the development of land trusts. I have a good friend who works for a nonprofit that it's called the Nature-Based Solutions Foundation. And what they try to do is protect sensitive ecosystems. And they often work with nations to assist nations in being able to identify sensitive ecosystems and either lease the land, privately buy the land, gain control over the land to be able to protect that ecosystem, as well as finding alternative economic solutions for the area, particularly if it's a logging area and they're removing land from the logging potential. How can they fill that economic gap? But it's interesting because in talking with her, something they've run up against is nations can't always hold land in trust because a lot of the land trust legislation and conservation area legislation isn't set up in a way where it's easy to give that land to a First Nation. And so these nations are often having to set up a nonprofit trust just to hold this land, which is so problematic and like convoluted and kind of just bureaucracy on bureaucracy.
Yeah.
And so it's interesting because part of what her organization does is they've started just developing this expertise in supporting First Nations, in setting up land trusts, just because it was a problem they were encountering so often. And so it's interesting because this nonprofit that's not really what they do has just had to develop this expertise to be able to support nations in doing this, which is just bizarre and frustrating. But at the same time, I commend her for saying, okay, this is a problem. I'm not going to make it the nation's problem. We're going to figure out how to do this and be able to just give them the solution. But it's just bizarre. That's the issues that come in these systems intertwining. But I love when we're able to find these solutions and just find the ways to still make it work, because it would be so easy for nonprofits like hers to say, oh, well, we can't give the land to the First Nation. Give the land. If we can't put the land in the jurisdiction of the First Nation, we'll find another nonprofit who could hold it.
Right.
But they chose not to do that. And I think that's really important when you encounter these conflicts of systems.
Yeah, it's a really good example of finding like a creative solution. And I think I love kind of pointing at that because sometimes people think of creativity as like painting or drawing, making music, which obviously are also forms of creativity. But I think, especially as I've gotten older, I really embrace this idea that creativity is like everything. It's like how we kind of see a way forward. It's how we learn to communicate. It's like what words do I choose to speak as I'm talking to you? Like all of that is creativity, right? And I love when we can find that creativity and strategies and solutions for things where it's like something that seems so kind of like monolithic and stuffy as like a law, But I think at the same time, I think I've reflected on the fact that law is far more dynamic than it sounds. Because it sounds really straightforward, right? It's like, oh, here's a book. Here's like kind of like a sheet and it's got all the rules on it and we follow it and we follow the rules. That's not quite how it works as well. So there's also a dynamism in legal work as well.
Absolutely. And I think it's in the daily work for some lawyers, it is here's the book, here's the rules. One of my best friends is a tax lawyer, and that's why he loves it, because there's right answers, because the rules are there. But in a lot of other fields of law, it's not like that. And I never anticipated being a lawyer in private practice for my entire career. The joke has always been that I went to law school not to understand the law, but to understand the loopholes, because I was always more interested in using the law as a tool and an option for advocacy than I was about the day-to-day of being a lawyer and advising a client on their specific case and repeat. And so how you change the law and how you build the law is all about picking cases that stretch the law a little bit more every time. And sometimes you'll lose, and that sucks and it hurts and it's sad, but you probably still move the law that little bit forward, even if you didn't win, because you need those unsuccessful cases that push things a little bit further before you get the one that wins and pushes it that step further. It's very much a standing on the shoulder of giants kind of moment, in that you're really building off of each other, and you need to be able to be creative about what kind of argument can I make that is enough within the realms of what is accepted law to not get totally thrown out. But how can I push it that little bit further? And how can I push it not so far it's totally outside of my client's interest because they will lose right away.
Right.
But if they want to push the law a little bit further, where is that middle ground that we can hit? So it's definitely very dynamic.
Oh, I love that. There's so much there. But yeah, something that came up for me as you were speaking. Yeah, I think sometimes, especially in activism, we have this way of seeing events as like a discrete, separate thing. It's like, was it successful? Here were our goals. If we didn't meet them, it was unsuccessful. And then we kind of like continue to get more disheartened or feel kind of hopeless or despairing. But you're right. The reality is that everything that we do is a continuation of a huge history. And so I think it's really important to have that expansive way of seeing time and seeing what we're trying to do. And I think that it's hard sometimes when people get really kind of the blinders on. And it's like, it's about this one case. And at the same time, obviously, like when it's the person sticking out their neck, it is their neck on the line, right? So it's kind of both, right? It's both kind of happening at the same time.
And it's something I really try to focus on with our team at Raven, because when nations we're working with who we've had these relationships with for years are unsuccessful, it's heartbreaking, but it's reminding our team, as well as to a degree these nations, that we didn't get exactly what we wanted, but here's the progress we did get. Here's the things in this decision that will help somebody else that only came about because of you, even if we didn't win, or we may not have won, but look how many people now know about what you're going through and want to help. We may not have won, but look at all the people we met along the way and look at all the other projects that have come about because of that. And for my sanity, at least, and my climate anxiety, it's really important that we recognize all of those types of wins, even if they aren't a win before the court.
Yeah, that's so important. And I love that you've used this word a few times in our conversation today, this idea of reframing. And I think even sometimes when you talk about law school, people go to law school and it's like, maybe you even have a very narrow idea of what you come out as. But I love that your perspective was that I'm going to have a tool, I haven't changed, but now I have a tool. And I can do what I want with that tool. And so I think that's such an important thing to be able to have the flexibility to do, because I think sometimes we become almost dogmatic in our thinking, that it's like, this is the way and that's the only way and there's nowhere else to look. Right. So I really love that from everything that you're sharing.
I appreciate that. Thank you.
Yeah. I wanted to bring up UNDRIP and get a sense of kind of your sense of how, I mean, I think it's kind of still kind of early in how it's going to play out in the court system, but I'm curious to know what your opinion of it is in terms of it showing up in the court system and whether it's useful and all of that.
This is a really interesting question right now because so our Gitcatla case was looking at BC's UNDRIP legislation, and it was the first case to take BC's version to court. And when it was introduced, BC made all these announcements and all these promises about making sure laws are in line with UNDRIP and making sure that they would make the necessary changes. And then in court, in the Gitcatla case, they argued the legislation was not enforceable, that it actually wasn't something that the courts could enforce, that it was just a statement of things the government would do, but they couldn't be held to account legally. And that kind of sucked because it's you have this the province saying all these great things, but then at the same time arguing, but you can't make us do it. We'll do it if we want, when we want.
Right.
The courts agreed with that. They agreed it was not enforceable. That is what Gitcatla is appealing on. They're appealing that that is not a correct interpretation of that law. So we don't know what will happen there. But it's also really interesting because after that BC decision, a few months later, we had the Supreme Court decision on C-92, which was a reference case in which Quebec in which the Quebec government brought forward a reference on the constitutionality of Indigenous child welfare legislation. And UNDRIP was brought up within the context of that case. And the Supreme Court said UNDRIP is now incorporated into domestic law in Canada. We don't really know what that will mean yet.
Right.
But that was kind of a big deal because the act that Canada introduced saying we're going to take on UNDRIP had been in play for a couple of years, but we hadn't had a decision from the Supreme Court, the highest court, the court that all the other judges or all the other courts have to look to saying, yeah, UNDRIP is Canadian law. And so there's always a question of what does that mean? How does that interact with our domestic UNDRIP law? You know, what do we actually have to follow? What don't we? How does that work? But that was a big first step to say, yep, it's law. This thing that you're arguing about in BC, we're like, that's your problem, but federally, it's incorporated. And so it's just a really interesting time because we've seen two courts take things very differently and looking at different legislation, federal versus provincial legislation, but very different results. And in BC, at least, we now have overlapping results that are contradictory, but are both valid because one is federal law, one is provincial law. And so I really don't know what is going to happen.
Yeah.
Is the answer. But it's a really interesting time to be looking at this because before C-92, my answer would have been very different in terms of how I felt about this. I might have been more cynical. Based on that BC court decision. But I was really pleasantly surprised by the reference case and what the Supreme Court said. So I really don't know.
Yeah, I do have to, again, give kudos to our judiciary, who is, in some ways, one of the places that truth and reconciliation is really showing up in kind of an openness and tackling these new things. So that's really cool to be watching as well. Okay, we have a little bit of time left. I think I want to touch base on the Wet'suwet'en case. Can you share a little bit more about the prophecy, the story of the case, like what's going on there? And just in the context, like right now we're 2 weeks out from the RBC AGM. I know there's a lot of focus on Wet'suwet'en land defenders having their voice held there. So yeah, it's kind of timely to be thinking about this and sharing the story a bit more broadly.
Sure. So the prophecy you're referring to was shared during a webinar we had with the hereditary chiefs back in February, and it's available online if anyone would like to hear it. Many, many years ago, the Wet'suwet'en had a prophet whose name is Beanie. He said that when the last glacier near the village in what is now in the Smithers area when the last glacier melted, the world would catch on fire. This was shared in the context of these hereditary chiefs are seeing their glacier melt year by year.
Mm.
The prophecy is seemingly in progress. And I say seemingly because it hurts me to say that it's in progress, that our world is going to catch on fire, but it certainly does feel and seem that way. And this case is a little bit different than what a lot of people think about when they think about the Wet'suwet'en and their legal challenges. Is a lot of it is thinking about Coastal GasLink. And this case is not a direct challenge to the pipeline, but it came about because of that advocacy and because of that work. And with this case, the hereditary chiefs went to the federal court and argued and are saying that we cannot be Wet'suwet'en, we cannot exist here if Canada is not meeting their climate change obligations, because climate change will not allow us to live and exist here. They are arguing this under Section 7 of the Canadian Charter, which is your right to life, liberty, and security of the person. And they're talking about things like how they won't be able to feed themselves if the salmon stop running because of climate change, which they're already starting to see changes in the salmon population, particularly because of the increased water temperatures. They're seeing species they rely on for food, like bear and moose and caribou, change their populations and their habits. One of the hereditary chiefs, Smogulem, was talking about how earlier this year, already during a warm spell, he saw a bear come out of hibernation that was not ready, and there was not food for it to eat, for it to rely on. And because it shouldn't have been coming out yet, because it shouldn't have been that warm.
Mm-hmm.
And all of these impacts are making it difficult, and eventually it will be impossible to be Wet'suwet'en because their culture and their lives are so intertwined with their territory.
Mm-hmm.
You can't pass down knowledge to the youth on how to fish the salmon you rely on for food if there are no salmon.
Mm-hmm.
And so with this court challenge, they're arguing that because Canada did pass legislation around meeting the Paris Accord commitments, but are failing to fulfill that legislation, failing to meet those commitments, Canada has actually failing to protect their charter rights. And this is where it differs a little bit from some of the past climate legislation, where it was saying Canada's just not acting. Here they have the ability to say Canada actually legislated commitments that it's not meeting. And so it's not fulfilling its own laws that would be protecting us. And that's how we see the law develop as we learn. This case is also really exciting because there's another climate challenge from a group of youth happening in the federal courts, which is the LaRose case. And it's being heard alongside this because the federal government also tried to have that case dismissed before a hearing. So they were heard together at the federal court. And so that case also had life breathed back into it. And there's actually the nephew of some of the Wet'suwet'en hereditary chiefs is actually one of the plaintiffs in LaRose.
Oh, wow.
And so it's a really great reminder that there's this Wet'suwet'en-based challenge and there's this youth challenge. But we're not separate. We're all related. We're all interrelated. And we're all working across all fronts to address this and to deal with climate change, which is, I think, like a really beautiful reminder, because in the law, so often it's this case is different from this case is different from this case. But it's nice to see that we're all connected. We're all related as we do this work.
Yeah, I really find, like, I don't know if it's just the narrative in general public now, but I feel like intersectionality as a word comes up for me a lot now. It's like, it's so hard to not, when we're looking at the environment, and especially when we're talking about human populations, to then divorce from there, like, social issues And they're all kind of intertwined. And it's really interesting because I think there's an old school of thought that's like, oh, well, stay in your lane. And it's funny because it's also beautiful that I think there's a new kind of generation of activism here where we can see those connections, the hyperconnectivity, where it's like it's all related. The world is not that big. We are all part of that same world, right? So yeah, that's really, really cool to reflect on and to see those connections. I'd heard of La Rose, but I did not know the connection to what's happening in Wet'suwet'en with hereditary chief. Really great that you were able to share that.
Yeah, and like all my respect and props to the youth bringing that challenge, because it's hard to be the face of something like that. I think there's 13 or 14 youth, I think, and it's really incredible work that they're doing as well. And I think it's really important to also highlight that and speak about them.
Yeah, especially so sorely needed, I find these days. Like ever since Greta came, it's been a bit more dampened since then from the youth. So to see some youth still kind of like having that fight in them is really inspiring for sure.
Yeah.
Okay, so we're pretty close to time. Are there any last kernels of wonderfulness that you'd like to bestow on our listeners before we say goodbye?
I think just if you want to learn more, Raven has some really, really great educational resources and pieces about different cases that are happening and the law. And I really encourage you to learn more because it's so helpful as an advocate or an activist to be able to understand the legal system. And I'm really deliberate in that I call it a legal system and not a justice system, because I think it's really important to remember that the law is a tool and it's not necessarily a tool for justice. It is working how it was designed to work by excluding Indigenous folks and by making protecting their lands and rights incredibly difficult. And so we can't be surprised we don't always win them. We are working in a system stacked against us, but the work is incredibly important. And even when we don't win, we are taking those steps forward, which I think is really helpful.
And I think what I'm going to take away from this call is also to kind of to really lean into creativity, that the legal system might not be the best avenue for justice, but there are other tools that can also help us build justice as well. And that it's not just like our imperative because we care, but also because it's a joy. It's a joy to create the world that we want to live in and to be healing the planet and ourselves. So thank you so much for sharing all of your knowledge with us. And I always love connecting with you. So thanks so much again.
Thank you so much for having me. It was a joy.
Hi everyone, Connor Curtis here, Head of Communications with Sierra Club Canada, jumping in to do the podcast Q&A. Just to be clear before we begin, our Q&A section of the podcast is not representative of our guests on the show. It's purely responses from Sierra Club Canada to your questions. We are following up on our last episode, which was a special episode about the carbon tax, and in it, we talked about ways that you could talk to your friends and family about the carbon tax, and in the wake of that podcast, we heard back about some of the different myths that are going around on the carbon tax, and so we wanted to follow up with answers to how you can respond to them, and there's going to be links to everything I'm about to talk about in a link underneath. I do want to say, too, to those who listened to our previous podcast, thank you for speaking to others on this issue. I know it isn't easy to confront this kind of stuff. So first on the list is the myth that CO2 isn't causing climate change, or that CO2 is some net benefit to the climate. Human-caused CO2 that is causing climate change, that has been proven time and time again by science. We'll have a link again below that you can look to for evidence of this. CO2 is a pollutant in the case of climate change. It doesn't mean that it's a pollutant in every case. Obviously, it is a part of how plants function. That doesn't have anything to do with the fact that if we increase CO2 in the atmosphere by even a very small amount, that has a massive change on the greenhouse effect and how our planet warms. The fact that it's a minimal change, quote unquote, in CO2 relative to the total atmosphere, or the idea that CO2 is plant food, has nothing to do with the fact that anthropogenic, that is human-caused, increases in CO2 are what's driving climate change, and that climate change is extremely serious. I mean, we're seeing this in the form of wildfires. Worse,
by climate change. On that note, there's a lot of people out there saying those wildfires were caused by arson. It was not arson that caused these wildfires. So what's happened is that climate change has made things like wildfires much more possible because it made the conditions for wildfires much more likely. And so wildfires, whether they're caused by lightning or by human error, which is when it is human cause, is the predominant vast majority of cases. It's somebody accidentally leaving a cigarette somewhere burning. It's a spark off of a car going down a highway. Things that to a certain extent are unavoidable aspects of human activity that cause wildfires when it is human caused. And in the case of overall causes, another big cause is lightning strikes, right? This is something that causes wildfires to start. But no matter what the cause is, it's the fact that wildfires have become so much more likely to start because of the changing conditions in Canada, because of climate change, which is because of human activity. So it isn't arson. We'll have a link again to our site. We're going to just jump in straight to the carbon tax. It's not just about bringing down emissions that cause climate change. The carbon pricing system also brings down general emissions, general fossil fuel emissions. And that's extremely important because fossil fuel produced emissions take 1 in 7 deaths in Canada. We talked about that on the last episode of the podcast. That's an extremely serious issue. If you're not concerned about that aspect of carbon pricing, you should be. It affects people in your life who have health conditions. It affects people who do not have health conditions now, who would not develop health conditions if it weren't for the amount of air pollution in the atmosphere. In fact, worldwide, millions of people die every single year just as a result of air pollution. So that is an extremely serious thing, an aspect to this policy. When we go past that and we deal with what does carbon pricing actually have as a negative impact on society, we see that the impact of carbon pricing on inflation is a fraction of a percent. You have to contrast that with the fact that out of every dollar of inflation over the last 2 years in Canada, 25 cents has gone to oil and gas and mining extraction profits. That's what's causing inflation much more than any sort of carbon taxation. So that's another thing just to keep in mind. Also, you'll see numbers thrown out by people that they say are from the Parliamentary Budget Office's report on the impact of the carbon tax on the economy. Over 200 economists have said that the impact of the carbon tax on the economy is minimal, that it is a cheap way to deal with climate change, cheaper than its alternatives, and that it's something that gives most families more back. And that's backed up by every analysis we've seen that's legitimate, that says it does give more back to families than it takes away. The Parliamentary Budget Office's report cited numbers of economic losses that didn't account for the costs to the economy of billions that come from climate change or the benefits of a green economy. And as we deal with in the podcast, the carbon tax law, a previous podcast of this, that's kind of logic that would leave us still using horses because we wouldn't have accounted for the benefits of changing over to motorized vehicles, right? If we thought that way, nothing in society would progress. So that's where those numbers are coming from, and they're not the numbers people should be referring to when they talk about the impacts of a carbon pricing system on the economy. The renewable energy transition is completely possible, and we dealt with this on an episode of our podcast on renewable energy and grid issues in Alberta. You can access that link again below or on the podcast list for this episode. We dealt with what the renewable energy transition could look like in Canada and how it's entirely possible people won't freeze as a result of it. If you happen to be for or against carbon pricing, either way, listen to the podcast. It's worth getting an idea of how this actually works. Another bizarre sort of myth that we heard was the idea that volcanoes emit more CO2 than humans and therefore should be taxing volcanoes. Humans emit 100 times more CO2 than volcanoes. That's just patently wrong, the idea that volcanoes cause climate change. Also, you can't simultaneously argue CO2 is good for the environment and then blame volcanoes for causing climate change because of the CO2 that they emit. That doesn't make any sense. And it is humans who are causing the CO2 increase, not volcanoes. The run-on effects of carbon prices do not add more to inflation. That's another thing to just keep in mind. Carbon pricing does help bring down emissions, right? There's been evidence of this. It's been very well studied. Now, is it a complicated system for doing that most of us have trouble getting our heads around? Sure. Is it completely not understandable? I don't think so. I think actually if we weren't seeing so much muddying of the water about what the carbon pricing system is, it's actually not that difficult to understand. Is it the only climate policy or the best climate policy or ways to look at that? Well, a lot of economists say it's the cheapest climate policy. It's the one that gets you the most benefit for the least amount of cost. Maybe you agree with that. Maybe you think another way should be the way forward on climate policy. But whatever you think, we have to keep this conversation to the facts about what carbon pricing actually is, what its actual costs are, what its benefits are for the people around us, for the people we love, and for the people we care about, for the people who are vulnerable in our communities. That should be where we're having this discussion. And we shouldn't be so focused on this one policy that we forget to discuss all the other climate policies and ways to deal with climate change that are out there. I mean, climate change is already costing Canadian households billions of dollars. They're talking about not being able to get insurance in flood-prone areas for your house. That's a huge impact to Canadians. It's right there. A final myth that I'm going to cover just before we break for today's episode is the idea that Canada's forests absorb more carbon than we release, which isn't true. We do release more carbon than our forests absorb. And that's been the case for a very long time now. And certainly as we make climate change worse, and of course wildfires get worse, that's going to become even more true. A reminder that you can take action on environmental issues by visiting sierraclub.ca. We have tons of petitions, other actions and events, and regular news updates you can sign up for on the homepage. You can also find Sierra Club Canada on social media, and you can listen to the Environment in Canada podcast on Spotify, Apple Podcasts, iHeartRadio, and YouTube, or wherever you get your podcasts. This podcast also airs on CKUT Broadcast Radio in Montreal, 90.3 FM, bi-weekly on Tuesdays at 11 a.m. AT. Don't forget to click follow or subscribe so you get the latest episodes from us.
Welcome to another episode of the Environment in Canada podcast, a podcast about the environment in Canada by Sierra Club Canada. I'm Haley Davis, Communications Assistant for Sierra Club Canada, and today I'm going to be talking with Charlotte Craig about urban ecology, specifically looking at how climate change will be affecting bee populations in urban areas. Globally, understanding the rights of nature is evolving. Here at Sierra Club Canada, we are rooted in protecting our biodiversity in the face of climate change. It is becoming increasingly essential to understand that all ecosystems on our planet are deeply intertwined. By doing podcasts focusing on pollinators and the impacts of climate change, we want to emphasize the importance of the rights of nature and protecting our ecosystems. Before we begin, just a reminder that you can take action on environmental issues by visiting sierraclub.ca. We have tons of petitions, other actions and events, and regular new updates you can sign up for on the homepage. You can also find Sierra Club Canada on social media, and you can listen to the Environment in Canada podcast on Spotify, Apple Podcasts, iHeartRadio, and YouTube, or wherever you get your podcasts. The podcast also airs on CKUT Broadcast Radio in Montreal, 93 FM, bi-weekly on Tuesdays at 11 a.m. ET. Don't forget to click follow or subscribe so you can get the latest episodes from us. Hi, Charlotte. Firstly, welcome to the Environment in Canada podcast. It's an honor to have you speaking with us today. So we have a wide range of listeners tuning in here. So firstly, we'd love to hear a little bit about yourself and your research. Like, where did you grow up, go to school? What is urban ecology? And what made you interested in bees and pursue a bee master's research?
Great. So I'm really happy to be here and get a chance to speak to you all. In terms of my background, I grew up mostly on the east coast of Canada, but I did move to the Caribbean when I was young and then to Florida for boarding school a little bit later on. I then came to Toronto for university. I went to the University of Toronto. I did my undergrad there, focusing on environmental biology, forestry science, and environmental studies. I then continued at U of T and I completed my master's in ecology and evolutionary biology. In terms of my research, throughout my undergrad, I really focused on community ecology and how the world works together to make the ecosystems that we have today. My first research job was with the university in the Malcolm Forestry Lab. And in that research, we looked at how logging impacted beetle populations in Algonquin Park in Halliburton Forest Reserve. And from there, I really grew a love for research surrounding anthropogenic influences on communities as a whole. And also learning more about field work was always a really great opportunity. In my master's, I looked at similar themes. So anthropogenic influences on communities again. When I spoke to Professor McIver, my master's thesis supervisor, I realized that his lab was doing a lot of really cool work on community ecology, really on the cutting edge of innovative research. So it seemed like a really easy fit for me to join the lab. The lab also focused on urban ecology, which, to answer your question, is the study of ecological systems in urban spaces, which I think is an incredibly underserved area of research and is an area that people don't spend as much time because it's not as flashy. There's not as many researchers working in the space. So overall, yeah, just an environmentalist from the beginning and getting the chance to work on communities and indicator species such as bees and beetles has really been my passion.
That's awesome. Yeah, that's really cool. Thank you for giving us a little bit of insight into that. How would you think working with beetle populations and versus bee populations, do you think they're pretty similar, or how would you say they kind of compare to each other?
I think that a lot of people would think that they're so similar. I think a lot of people view the study of insects as a one and done kind of space, but it's really one of the most diverse areas of research. So beetles are, well, to begin, just the research of them is incredibly different. When I was working in Algonquin Park, we did a lot of flight intercept traps where beetles actually just run into a pane of glass and then fall into a bucket. And you are able to leave them for a certain amount of time and then go collect them. Whereas with bees, you actually have to go out and use an insect vacuum and get them into little vials so that they can be identified later. Because there's so many different kinds of both of them, it's actually really difficult to do non-invasive trapping methods.
Right.
So yeah, there's a big difference between all of them. I think they're both indicator species, so they show what's happening in their community really effectively. So there are a lot of similarities, especially in how diverse they are. So beetle populations and bee populations within Canada are much more diverse than anyone would know. We have over 400 species of bees in Ontario alone.
Wow. Okay. Yeah, I did not know that.
Yeah, there's a lot out there. You wouldn't recognize all of them.
That's crazy. Yeah, I feel like in school I took a honeybee biology class, and we learn about the honeybee and like a few other types of bees, but not the 400 species.
Yeah, the honeybees definitely dominate the airwaves, but native bees play such an important unsung role. They aren't as glamorous. I mean, you don't get to eat anything they make, but they play a huge role. And beetles, no one really enjoys them. No one wants them in their house, but they're so diverse and so important to our ecosystems and part of our food chains.
Cool. Awesome. Yeah, moving on to the next question. So, how do you think your research has filled a gap in knowledge of current studies so far? So, I guess specifically your master's research.
Yeah, so my research is still in the process of being published. So I'm waiting for the opportunity for it to really start being an influence on future research outside of my lab. But I think that when it does become more widely available, I'll be able to inform a lot of different areas of research. Most prevalent would be the in situ manipulation of experiments and experimental approaches to emulate climate change warming in external in situ experiments. So my research took an incredible amount of trial and error. And I think that people who are looking to emulate climate change scenarios will be able to benefit from my research and not have to do quite as much failure to get to their success.
Right.
I also think that the application of different theses around temperature mitigation and management in smaller animals will also benefit those working in insects and ectotherms. So temperature management is examined in a lot of larger species, and it's a lot easier to see, but these theories haven't been tested on our smaller, less prominently studied species. So I think that the application of that work will open up a whole new avenue of research. Specifically for the Bogart effect would be a really great area for them to learn more.
Okay. Do you want
Also,
to explain a little bit about the Bogart effect?
yeah, of course. So the Bogart effect is the idea that animals are maintaining their thermal optimum by making changes in their short-term processes, such as phonemic plasticity, and long-term processes such as evolutionary adaptation. So they can manage their temperature internally by changing the behavior that they do instantly, and then also evolving to be more tolerant of temperature.
Okay, which is, very essential in the next forthcoming years based on all the warming we're seeing.
Yeah, absolutely. And the Bogart effect only is so applicable in a place that's changing so rapidly, such as our urban centers, because, evolutionary adaptation can't move as quickly as climate change is moving in.
Right. Yeah, right. That makes sense. So moving on, and we kind of touched on that, but moving on to the next question. So based on your research, how have bees been shown to manage temperature changes and maintain their thermal optimum? Just kind of explaining a bit more about that Bogart effect. And
Yeah, definitely. So just to give a little bit of background, so bees are ectothermic, meaning that they don't have any ways of internally managing their body temperatures like us as humans do. So instead of internal methods, they actually manage their temperature through different behaviors. So we were talking a little about honeybees earlier, and they're one of the most studied groups of bees due to their implication for human benefit. But honeybees have a lot of examples of maintaining their temperature through different activities. So, for example, honeybees have conducted group movements within their hives. So they actually shiver by contracting their flight muscles to create heat around the queen. And they're also known to sun themselves on rocks on cool mornings to warm themselves up in order to get to that thermal optimum range that they best perform in. Another one that I find very interesting, which might not be as interesting to those who haven't spent as much time around bees, is that honeybees, and actually are known to regurgitate honey onto their face to create an evaporative cooling effect on themselves.
okay.
Yeah, so it's like their own personalized version of sweating.
Nice.
Maybe a little bit grosser than ours, but very effective.
Okay.
Smaller native bees also have their methods of cooling themselves. So they're known to take cooling flights, which are briefer and more frequent flights that cool themselves down through the addition of airflow. And other pollinators also have this kind of need to maintain their temperatures to do the necessary actions that they have every day. So pollinating wasps are also impacted by temperature, as they're also ectothermic. So pollinating wasps actually have been shown by many studies to have a significantly shorter lifespan and fly less when they're exposed to high temperatures. And pollinating flies also need their temperature needs met, and they actually have been known to spend long periods of time on warmer flowers when the air is cold, and vice versa when they go to colder flowers when the air is hot.
Okay.
And this is all really important. As much as it is fun facts about bees and other pollinators, it's really important because all of these methods of temperature control really impacts how and when bees and other pollinators can forage and fly, which in turn impacts pollination services to plants, which is so necessary not only for humans, but animals as well.
Right. Okay. Well, yeah, that's awesome. That's very interesting. I feel like, I remember even from my class, it felt like bees are there's just such an interesting organism. It kind of felt like I was in a little fairy tale, like within the Bee Movie or something, like just learning about their dances and all the things they can do. Like, I don't know if this is correct, but do they also do fanning to manage temperature changes, or is that maybe something else?
I'm not sure. I'm sure honeybees have some kind of activity that allows them to fan the hive when they need to cool down. I'm not sure what the process would be called, but one other thing that I would like to mention is that I mentioned a bunch of different processes for different groups of pollinators, but also within the pollinators, there's also a huge difference in climate sensitivity based off of taxonomic differences, as well as ecological traits such as sociality, body size, or specialized foraging behaviors. So a lot of studies have shown that social bees are actually more heat tolerant than solitary bees, suggesting that their life history can predict climate sensitivity. And it's also well known that smaller bees are differently impacted by changes in temperature than their larger counterparts. And, there's a lot of studies that focus a lot on that thermal range, and it's just incredibly variant depending on the species, even if they reside in the same ecosystem.
Right. Okay. And yeah, just to kind of jump in, do you mind, just for our listeners, do you want to explain a little bit the difference between social bees and solitary bees?
Yeah, definitely. So again, a lot of us picture a honeybee and its hive when we think of a bee, and we think of this kind of hive mind, this large group of organisms that work together and they all have dedicated roles, but that's actually not the case for most of our bees. Most of our bees, outside of a handful, especially within Canada, are actually solitary bees. So without the inclusion of their mating season, they actually live primarily socially. So they forage for themselves, they create homes for themselves. Some bees bury themselves in tunnels underground. Some go and they nest in holes in trees. And while occasionally we can see bees of the same type residing in the same area, just due to the validity and the accessibility of the area itself, they actually do very little interacting with themselves besides mating. And then so there's a big difference between some of them. So I think that it's just really interesting how different their lives can be, and how we assume that they're all buddies and friends with each other with a central home to all hang out.
Yeah, that's so true. I feel like growing up, that's definitely what we've learned, is that they like fly together, they live together, just kind of do everything. But you're saying they're a little more like solitary than we think.
Yeah, the majority of bees are absolutely solitary, and they have so many protection mechanisms to keep themselves safe. A lot of bees use different materials to kind of barricade their eggs into their hidey spots. So whether that be in a tree or in a dugout tunnel, they use pieces of leaves or pieces of petals to barricade their fertilized eggs so that they're protected once they have died and the season continues on, and waiting for those bees to hatch in the coming year.
Oh, wow.
So they do a lot of stuff, and it's incredibly important to recognize these habitats as integral to bee populations. So, keeping the leaves on the ground in the fall, also leaving open patches of not tightly packed soil for those bees that do tunnel, and then also having opportunities in trees for bees to get into those nooks and crannies to breed.
Okay, that's awesome. Yeah, that's good to know. I feel like, we're always taught just, plant flowers that are good pollinators for bees. But it sounds like you have some other tips and tricks that we can do to save the bees.
Oh, absolutely.
Yeah, so moving on to the next question. What are the main effects warming temperatures and climatic changes have had on bee pollination events? And why do you think, just a little bit, I was looking at some of your results from your research, you kind of explained that larger bodied bees, such as carpenter bees, were able to tolerate warmer flowers. So why do you think that's the case?
Yeah, so to address your first question, so what are the main effects of warming temperature and climatic changes on bee pollination events? So in my study, we tested the hypothesis that higher floral temperature is negatively correlated with floral visitor abundance. So as temperature goes up, there's going to be less bees. And this is due to the Bogart effect that we talked a little about earlier, and the need to stay within that thermal optimum. And my research found that during the summer season, when bees are most likely to be exposed to extreme heat events outside of their thermal range, they did in fact choose to avoid hotter foraging areas. But in less extreme times, like the spring and the fall, these trends were not as consistent, most likely due to the lack of extremes that bees experienced. So in the spring and fall, when they weren't as pressured, they were more likely to evenly choose the flowers. And then in the summer, when there were extreme heat events, they really did rely on those cooler flowers to forage. Yeah, and it's really complicated just because the experiment that we did had a lot to do with emulating even more extreme temperatures. So even with the extreme temperature events that we experienced during the summer in which I conducted my master's, we actually had heaters that emulated an even more extreme scenario of climate change increase. So about a 2.1% temperature increase in our urban centers is what we emulated. And yeah, so we saw a more extreme response, and that makes sense because bees are quite adaptive. They're not going to, there is a lot of variation, especially within our urban spaces of temperature. The temperature difference between green spaces and the gray industry spaces is a lot bigger than a lot of people expect. So they do have some plasticity in their ability to forage.
Okay, cool. So yeah, do you think, and we'll talk a little bit about this later, but do you think that certain bee populations like the smaller bodied bees will be affected more negatively with climate change then and continued like increased anthropogenic sources?
Yeah, based on my research and the study by others, it definitely is likely that smaller bodied bees are going to be more impacted by temperature change. So, and this has to do a lot with different aspects, again, due to taxonomic differences, sociality, and things like that. But the thing that we can really attribute to in terms of size is that larger bees have a larger surface area to volume ratio, which limits water loss. So they aren't as impacted as quickly as smaller bees. So they can be better adapted to change their activities to mitigate that water loss, whereas smaller bees are at higher risk.
Okay, that makes sense. And just on another note, when they are foraging, do they have certain like receptors on them that will like they can how do they detect basically the temperature of the flower? Just out of curiosity.
Yeah, so it's still left to be researched much more extensively how they can perceive the temperature of the flowers and themselves, but it's somewhat similar to other insects. So they're able to just have that in their system to let them know that it's hotter or colder. I'm not quite sure what the actual taxonomic determinant is, but they are known to be able to choose based off of different temperatures.
Okay.
They also, if you look at a picture of a flower in a thermal camera, there's actually a lot of flowers that use different thermal and color patterns to draw pollinators into the center where the pollen and the nectar are. So having that indication of temperature is actually beneficial to them as they look to forage and find those areas of optimal of nectar.
Okay, cool. Yeah, and I guess just kind of a little bit more about your research, but like when you were looking at the different flowers, did you find that the actual flower itself, like certain species would tolerate the warmer temperatures better? Or did you not really, was that not really something you like paid too much attention to during your study?
Yeah, during our study, we did bring in our own flowers. So we brought in 3 different species dependent on the season. And what we did was we actually consistently tried to keep them as healthy as possible to entice further visitation. So they were all given water and they were all given an opportunity to not be in direct sunlight so they wouldn't completely dry out and die. So we didn't really look at the impact of temperature on the plants themselves. But a lot of studies do look into how temperature impacts plant growth and development and pollination subsequently. And it's known that as temperature increase, nectar is actually going to increasingly evaporate, which will be much more difficult for bees and other pollinators to detect it. And this is something that dependent on a lot of things in the flower. So the shape of the flower, the height, the number of blooms, the color is all going to really impact how flowers respond in the heat, and then also how pollinators perceive them as they change in the heat.
Okay, interesting. So yeah, when you were doing the studies, did you find that like because temperature was your controls, and I noticed you used, was it infrared light, I think?
We just used a heater, yeah.
Oh, just a heater. Okay. Did you find like it was hard to manage with like other abiotic factors like wind or rain? Did you find it hard to kind of maintain that, or how'd you guys deal with that?
Yeah, it, as most field experiments, was incredibly difficult to manage all of those impacts.
Yeah.
And one of the ways that we did try to mitigate the impact, or at least compensate for changes in abiotic factors, was we took just a plethora of temperature measurements. So we took a consistent, at a 1 minute interval for each and every plant, we took a like a air temperature measurement of the plant surrounding temperature. And we also had a thermal gun that we took a picture of every single flower and traced out all of the flowers on each plant to get their surface temperature for each trial. And we also had temperature measurements as control throughout the study area, so that we were able to compare and see how our manipulation was changing as we look to, see, like, have that 2-degree increase in our flowers.
Okay. Interesting. So moving on to the next question. In general, how do you foresee warming temperatures and climatic changes to continue to affect bee populations and foraging patterns in urban areas? I know we briefly touched on that, but yeah, what do you think are the most important things we can do in order to minimize any negative impacts? Like, what can we as the public do?
Yeah, so how do I foresee the warming temperatures and climatic changes and their effect on bee populations? So as temperature increases due to the synergistic effects of climate change in the urban heat island effect, bees are going to increasingly struggle to do their necessary functions. The increased heat is going to act as a filter for our bee species in Canada. And out of the over 400 bees within, our rural Ontario spaces, for example, many could be extirpated from our communities and leaving us without the necessary pollinators, which has a huge impact for humans and animals alike. And I think that beyond the need for systematic changes to limit the consistent degradation of our ecosystems that is in turn resulting in climate change and among other many big issues, there are small scale things that we can do to support our pollinators. So my research specifically highlighted the importance of high floral density. So high floral density seems to help mitigate the impact of extreme temperatures on bees. So just having increasing access to blooms for them to feed on, so that as they go through, they're able to select blooms that serve them and their thermal needs, rather than being isolated to flowers that they have to go out of that thermal range for them to feed on, is really important. Okay. And then one of the biggest things overall is just to provide more green space. So green spaces provide cooling effects in comparison to the gray infrastructure counterparts. And this is beneficial not only to our bees, but also to humans. And it's shown time and time again that green spaces have physiological benefits for humans, and also mental benefits for us, as it improves our mental health to be in these green spaces. Right. And yeah, we're all going to need the cooling effects of green spaces, so we might as well amp them up.
Yeah. And I was just going to jump in just because you mentioned I guess it's kind of relevant, but the urban heat island effect, and just so for people who don't really know what that is, yeah, correct me if I'm mistaken, but it's when it's just kind of in more urban areas, we see hotter temperatures as opposed to like more forested spaces, correct?
Yeah, absolutely. And it's really something that's more seen in the night. So urban centers retain additional heat in comparison to our green spaces.
Right. Okay. Yeah. And I mean, yeah, like even with kind of incorporating, more forested spaces into urban areas that'll, not only affect, like positively affect our bee populations, but also reduce the urban heat island effect. So it also cool off the urban areas, right?
Yeah. Yeah, absolutely.
Okay. Awesome. Yeah. Do you have any other kind of important things that we as the public should know in order to minimize any negative impacts?
I think that just, making availability for green spaces and floral resources for bees is really important. And that can be as small as including access to spaces in your backyard or advocating for the addition of green roofs in your condo community if you're more in an urban space. There's lots of resources online that talk about bee hotels, and you can obviously get into those kinds of resources. But again, as I mentioned earlier, really just maintaining those natural spaces for bees to thrive in. So, arid soil, trees, and bushes for them to continue their way of life is incredibly important.
Okay, awesome. That's great to know. Thank you, Charlotte.
Yep.
And then on another note, so you worked for many different environmental organizations and have a lot of experience in environmental communication. So what do you think are some key differences and key commonalities in how environmental protection is portrayed to the public? In your opinion, is there any area that environmental advocacy organizations need to focus more on, or that they're lacking, or what should be the focus in your opinion?
Yeah, so I have done a lot of environmental communication as well as working on the science side, because I really do believe that science without accessible communication lacks a lot of purpose. Science for the purpose of science isn't going to create change, and it's going to create some kind of barrier between people and learning about the systems that work around them. So I think that it's incredibly important, and it is done in a lot of different ways. So there's a lot of differences based off of the organization and context, but there are quite a few commonalities. So in terms of differences, beyond, the typical subject matter and area of focus that each organization is going to hold within their community, one big thing that I see is the messaging tone. So a lot of organizations vary their tone of messaging. So, they could have an alarmist tone or an optimistic tone. And that just has a lot to do with the subject matter and the target audience that they are looking to engage with. So, things like demographics, interests, and values are all going to impact how that messaging is portrayed to the public. I see a lot of messaging aimed at young adults that focus on the impacts of the climate change for future generations, as you see yourself in that information. And then there's other forms of communication to organizations such as business that really emphasizes the economic benefits of sustainability and kind of put that shiny look on the sustainability aspect. So there's just a lot of variance in how this information is communicated to the public. And I think that there's a time and place for all of it. And in terms of commonality, more and more, I would just like to say that there is an increasing emphasis on the science itself and making science increasingly interesting and losing the jargon that we need to do to present scientific evidence to support advocacy. And I really love seeing this trend of having the science first and foremost and really make it accessible and having people connect with that information. And a lot of this is shown through visuals and stories. So a lot of organizations that I have worked with have really spent a lot of time showing kind of the whole life cycle of an environmental advocacy campaign. And I think that that's another area that's really thriving, so that people feel more engaged with the action that the conservation group is doing, rather than just sending out a newsletter saying, we've done it, we've fixed this problem. People are able to identify the problem, be informed about it, and see the action that goes into it as the solution is met.
Yeah, and see the process more. Yeah, I agree. I feel like 5 to 10 years, even just with, it sounds silly, but even just with TikTok and increasing social media, you can see that science is becoming a lot more accessible. Like, even though there is still a lot of greenwashing and jargon out there. It's definitely is. It's really interesting to see, especially I feel like after COVID, it's just kind of ramped up, in my opinion, which is great.
Yeah, I think there's a lot of things that have led to this trend. I mean, I think a lot of us grew up with, Bill Nye the Science Guy, who is just, maybe the coolest person I've ever seen in my entire life. But more and more, yeah, with the introduction of online resources, especially social media and YouTube, you're able to really get a hands-on approach to these things that never used to be accessible. And that goes hand in hand with the increased education of our population. The proportion of people now receiving higher level science diplomas and master's degree is just exploding. So we just have more and more of a team to tackle these big problems that are coming our way. And you can really see, I had the opportunity to have a documentary made about my research through a grant program, and it's been a really great tool to communicate with the public about these bigger issues, because not everyone is going to read a 70-page thesis report, but people will watch a 5-minute documentary.
Yeah, yeah, exactly. Yeah, and you kind of touched on that, like a lot of environmental communications is geared towards the younger generation, which I think is great, and I love that. Do you think there's any merit to really focusing on like the older generation, or do you think that's kind of maybe just like too far gone, or do you think just an even spread? Like what would your kind of be advice going forward for environmental advocacy organizations?
Yeah, I think environmental advocacy and environmental education is for everyone, and it needs to be for everyone if we're going to find a solution to the bigger problems. It's just a matter of having specialized communication for those groups, right? Like I mentioned a couple different forms of communication that one could take when you're reaching out to your target audience. And you just really have to be conscious of the differences in their goals and their values when you're communicating this information, so that they can build a common connection with the information, rather than feeling as if they're being left behind and they can't keep up with the environmental movement or they don't understand it. I think that just having a really comprehensive, multifaceted approach to advocacy and education is really the solution. We can't leave anyone behind or make people feel excluded. Science is for all and advocacy is for all.
That's true. Yeah, we have to work together if we want to figure this thing out.
Yeah, absolutely.
Yeah, so moving on, in your opinion, based on where you work and all of that, what is the best way for the public to get involved and influence policy decisions in wildlife conservation?
Yeah, I think I'm going to go back to the last question just to kind of set this one up a bit. So I think that in terms of what environmental advocacy organizations may need to focus on or are lacking is I think that intersectionality could be more included in a lot of campaigns. So environmental issues are intrinsically interconnected with social justice, economic inequality, and other systematic issues. And environmental advocacy organizations have come like leaps and bounds in their work to benefit these intersectional perspectives. But I think that there's always more work to be done to these relationships to ensure that environmental solutions are equitable and inclusive. And this work is just going to bring, again, more groups of people into the environmental movement and make sure that all of our solutions are going to work for everyone and are not single-handedly going down a one-way street. Also, one thing that I wanted to talk about before I talk about what individuals can do and what advocacy and work that you can do yourself is that really, as environmentalists and working in the environmental sphere, I think it's really important that we do focus on going after the groups who are creating the biggest proportion of the problem. So, according to the Intergovernmental Panel on Climate Change, the IPCC, around 70% of our carbon dioxide emissions stem from just 100 companies worldwide. So this statistic really highlights that individual effort alone is not going to single-handedly solve the climate crisis. Mm-hmm. And while I am a huge advocate for self-sustainability, and I think that there's so much that an individual can do, I think that making individuals feel as if the weight of the world is on their single consumer shoulders is inaccurate. So I just like to preface that before I go into the, what an individual can do, because if you're listening to this podcast and you're involved in the environmental movement, I just want you to be able to give yourself that little bit of kudos. And while there's always more work to be done, there's a lot that you're already doing for yourself and making small changes.
Yeah, that's really great to touch on, because you're right. I feel like there is so much pressure even from growing up, just do this, like to reduce your footprint and all that. And yes, that's important, and do your part and try your best. But you're right, it's not the root of the issue. The root of the issue is like carbon tax and going after those big corporate companies that have the highest emissions.
Yeah, definitely. I think that as someone who has spent, her whole adult life in the environmental sphere in different capacities, that environmental guilt is very easy to experience. And I'm going to talk a little bit about the best way for the public to be involved in wildlife conservation and, climate action. But just being able to do these things without the guilt of feeling the need to be perfect is really important.
Yeah, that's so true. Yeah, that's really great to touch on.
Yeah. So I can now get to your original question, Haley.
Perfect.
Sorry about that.
No, I appreciate that. Thank you. Yeah, that was definitely great to add. So thank you.
Yeah, to all the young environmentalists out there, progress is better than perfection. So anyway, so in terms of what I think that the public can do to get involved, I think that there's so many avenues for how the public can participate in conservation work, and there's an option that fits for everyone. So if you don't find the way that works for you, then keep looking, keep reaching out to the people that have the options available to you, and you'll find something that's best suited to you. I think that the biggest thing is just to be educated on the issues, specifically those within your community. So like we were talking a little bit earlier, so there's short resources like short documentaries, social media, and other, online sources where you can become more familiar with the topics that are most impactful to you. I recommend looking into those close to home, but there's also a lot of information around the world in which you can get involved in as well. If you do want to be more hands-on, and you can do that in a lot of different ways, you can volunteer your yard for ecological monitoring. This is something that's done a lot in, I know for sure, Scarborough, where I did my research, and they do a lot of recording of species and ecological features within your backyard. You can also support environmental organizations monetarily, and you could also volunteer for citizen science projects. Through U of T, there's quite a few projects where you can volunteer to report on invasive species, ecological damage, or any other aspects within areas such as the ravines or, larger parks. So if you feel like you would really like to be out in nature and feel like you're making the impact, there's a lot of options available for you that I don't know if everyone knows about.
Yeah.
And then finally, and I think people hear it time and time again, but the best thing that you can do is vote. So once you're educated and you're feeling empowered about the environment, really the biggest thing you can do is fight and petition for those running for election to, satisfy those needs that you feel like you need in your community environmentally. There's a lot of resources that actually specifically focus on environmental politics. One of the resources I would recommend would be the 100 Debate Series, which is a cross-Canada program that actually brings together local officials who are running for office in smaller communities, where they only debate about online environmental issues. I did this when I was working with Wildlands League for multiple districts, and it's really interesting to see the different groups have to focus on environmental issues in that sense, and they're not allowed to switch to other topics. And you really get to be informed to the highest capacity when you're involved in projects like that.
Yeah, that's awesome. Yeah, I have to second that. I mean, I remember when I could first vote at 18, it was very daunting because I was like, I wasn't too involved in politics, and I just felt like I didn't want to make the wrong decision. And there was just a lot of pressure to to vote which way. And then, but it's so true. Just, try and be informed. And it's so true. It's very crucial because just the smallest thing can make that difference in the fight against climate change. So I second that.
Yeah, absolutely. And, it feels like you can be disconnected from the process because you are just one person. But if you get involved and vote, then that can really, you can see the change that you want to see.
Yeah, for sure. I love that. Yeah, do you have any other advice for young aspiring environmentalists and, just the fight against climate change in general? Or have you kind of said what you said?
I think that one theme that through my mentorship through the years that I always try to communicate with environmentalists is taking care of yourself is important as taking care of the planet. A lot of times young environmentalists can feel, again, the weight of the world on their shoulders, and every decision that they make day to day can make or break big decisions. But in your fight to mitigate any environmental issue that you're pursuing, make sure that you have a sustainability plan for yourself and that you're taking care of yourself as you move through your career. The most successful environmentalists that I know are able to do their most effective work when they're taking care of themselves as well as the environment. So it's a big issue and can seem massive at times, but we're going to figure it out, and we're going to be able to, address any of the problems that you seek.
Yeah, I love that. I mean, even I had one professor in university, and she would always say after kind of a more, it was called climate change biology. That was the course she was teaching. And after a heavier class, she would always say, like, just go out, go for a walk in the forest, hug a tree, do something that'll just make you feel good because we'll get through this.
Yeah, it's a heavy burden to carry, especially when you're starting out. You feel, you're learning all of these things and it's coming at you so rapid fire. But yeah, it's important to make sure that you have a sustainability plan for yourself as you go forward.
Awesome. Thank you. Yeah. Do you have any other things you want to mention about bees or anything?
No, I think that I covered everything that I wanted to talk about today. I think that there are lots of resources that people can have access to. People are always free to reach out to me if they would like to learn more. But otherwise, thank you for having me today.
Of course. Yeah. Awesome. Well, thank you for speaking with us and giving us some insight into how climate change is affecting bee populations and pollination events and everything in the environmental realm. So it's been a pleasure speaking with you. Thank you.
No problem.
So now we're going to move on to our question of the week. So here's a question from a listener. The Ministry of Natural Resources condones aerial spraying of the Vermilion Forest in Northern Ontario. How do we stop this? So I reached out to Ole Hendrickson, the chair of the Conservation Committee of Sierra Club Canada, and here's what he had to say. So herbicide spraying is ingrained in many forest management practices and can be difficult to stop at the local level. As first steps, self-education and ensuring you know exactly what points you want to bring to the public and to the individuals making decisions about spraying is the best way to assure maximum efficacy. To take action, it can be best to get in touch with the groups or individuals making this decision directly. So Mark Lockhart, who works at Vermilion Forest Management Company, would be great to get into contact with and to voice your concerns too. In their Sudbury Management Plan, it notes that aerial herbicide applications may be prescribed if competition levels from other vegetation is deemed to be significant enough to inhibit renewal success. And this is talking about if other vegetation is inhibiting renewal success of their primary species of concern, such as pines, spruces, and other conifers, then aerial application would be used. This is also important to keep in mind whilst voicing opinions. Other effective ways would be campaigning and petitioning to get the federal governments to deregister forest herbicide use. Those are some points Ole sent to me on this. We do also have some resources on the issues with spraying and the use of herbicides on our website, sierraclub.ca. One particular article you might want to check out is Why We Need a Glyphosate Ban in Forestry. You can send us a Q&A for us to answer during the next podcast at info@sierraclub.ca. A reminder also that you can take action on environmental issues by visiting sierraclub.ca. We have tons of petitions, other actions and events, and regular new updates you can sign up for on the homepage. You can also find Sierra Club Canada on social media, and you can listen to the Environment in Canada podcast on Spotify, Apple Podcasts, iHeartRadio, and YouTube, or wherever you get your podcasts. The podcast also airs on CKUT Broadcast Radio in Montreal, 93 FM, bi-weekly on Tuesdays at 11 a.m. ET. Don't forget to click follow or subscribe so you can get the latest episodes from us.
Welcome to another episode of the Environment in Canada podcast, a podcast about the environment in Canada by Sierra Club Canada. I'm Jessica Murray, Sierra Club Canada's Ontario Director. Today, I am speaking with John Borrows, who is a full professor of law and the Loveland Chair in Indigenous Law at the University of Toronto Faculty of Law. He is known as a leading authority on Canadian Indigenous law, constitutional law, and has been cited by the Supreme Court of Canada. John Borrows is a knowledge keeper from the Chippewas Nawash First Nations located at Cape Croker in the Bruce Peninsula, or known as the Saugeen Peninsula. And today, we talk about Indigenous law and the more than human world, drawing stories from cases about wild rice, also known as Minoan, and the Hoof Clan. We also talk more about John's latest book and about how the Anishinaabe relate to time as something that is not discrete and objective, but fluid and has its own personality. Before we begin, just a reminder that you can take action on environmental issues by visiting sierraclub.ca. We have tons of petitions, other actions and events, and regular new updates you can sign up for on the homepage. You can also find Sierra Club Canada on social media. Our podcast can be found on the Harbinger Media Network, Apple Podcasts, iHeartRadio, our YouTube channel, and on our website, as well as many other places you listen to podcasts. The Environment in Canada podcast is additionally broadcast bi-weekly on CKUT Radio in Montreal, 90.3 FM. Don't forget to follow or subscribe so you can get the latest episodes from us. I hope you'll enjoy this conversation with John Borrows. Thank you so much for joining me, John. I'm so excited to talk with you. Welcome to the Environment in Canada podcast with Sierra Club Canada. I'm really looking forward to this conversation. Maybe we can start with some intros. So
Sure.
I think everybody knows who you are, but it's always kind of interesting to know how people self-introduce themselves. So
Yeah. So first in the language, Giganos Indigenous, Neashi Winigaming and Donjaban Nigigandodam. So John Borrows, I'm the Loveland Chair in Indigenous Law at the University of Toronto Law School right now.
that's beautiful. And your introduction is short and brief, but I think it's an understatement of your contribution as well as your position in Indigenous law and just the body of knowledge that you carry. So I want to bring that in as well.
Thank you. No, I try. I love learning. And so I think that's one of the things that motivates me each day is to keep trying to expand the possibilities of what's out there in terms of what I can know and pass along.
Mm-hmm. That's a beautiful intention. So just for the purpose of the conversation, I like to kind of separate Aboriginal law as in like the Canadian version of Indigenous law, and then Indigenous law as in like within the bodies of First Nations themselves as like governing bodies, their own sets of laws. Because I think in the question of truth and reconciliation, we're kind of seeing these two different ways and hopefully some conversations between them. And that's kind of where I wanted to start the conversation with you.
Well, I also make that distinction, but I also see that they can be related too. So that's great.
Yeah. I'd love to hear more about, at this current juncture, I guess, whether you're seeing that there's more openness to recognizing Indigenous laws within Canadian law, the legal system as well.
Yeah, I see that at different levels. So I think you're seeing that more in the community level where that revitalization is happening in band councils and looking to see where there's the opportunity to share that information with proponents and governments through consultation and accommodation protocols. You'll also see some of that happening in the legislatures, recognizing Indigenous law and referentially incorporating that as federal law is one of the models. And then I think the courts are also doing that, but I see that more in the lower courts right now. The Supreme Court is certainly creating a framework for it, but at the same time going quite slow in trying to make sure that they don't get ahead of the other branches of government and communities, I suppose.
It's always kind of tricky that way, isn't it?
Yeah,
Staying within your lane.
that's right. So I can, appreciate why they want to exercise judicial restraint. They are not elected. They do need to take direction from other parts of society. At the same time, we want them to be able to identify the things that are happening, and that is slowly going on in the courts, although I'm trying not to be impatient.
Yeah, it's interesting. I was just about to kind of shift gears, and you bring up the feeling of impatience. I wanted to get a sense of how your outlook is, or kind of just how you feel about where we are, I guess, as a society, as Canadians, as we begin to really look at what reconciliation is actually going to look like.
Yeah, I think one of the things I appreciate is that it's not just legislatures and courts that are picking up this work. So the 94 calls to action from the Truth and Reconciliation Commission were really also addressed to what we call civil society. And so to see businesses and museums and arts organizations and universities and healthcare providers and other the churches, in other words, I see that what's exciting is that it's not just a hierarchical top-down approach, but it's becoming more infused in various parts of society in accordance with the needs of and the connections, I guess, that they have with Indigenous communities in those spaces. So that's hopeful.
Yeah, and I think it's important to kind of like celebrate the wins that are happening for sure. And I think overall, speaking of kind of like when we're talking about environmental climate change and kind of activism around that, I find whereas sometimes it can be hard, let's say for a protest or a rally, to have a really good show for, let's say, a climate rally, where I have seen kind of repeated support is when it's like a First Nations, group that is really leading it. And then I think it is very hopeful and inspiring to see the non-Indigenous community come out and support them. So I would like to echo that there are some really good things and exciting things happening as well.
Yeah, I see that in my classes too, where students have some knowledge, particularly compared to, say, 15 or 20 years ago. And that knowledge is usually more or less spread through the class, whereas before it might have been just someone who was studying Indigenous studies, for instance, at university. Now I think it's coming to them in secondary school. It's happening in different disciplines. And then that means when you have a call out to do something, there's a little bit more appreciation as to why that might be important in those settings.
Yeah, I think there's a good amount of readiness for more integration and bringing that in. So that's really beautiful. I know you recently lectured at Western,
Yes.
and I had a chance to listen in. So I thought we'd maybe highlight some of the stories that you featured in that lecture, because maybe they'll be top of mind and still fresh.
Yes.
So I just really loved some of the stories that you shared. Because I think, like I say, I think there's a lot of curiosity. Is like, well, what are the differences between Canadian law and, laws within Indigenous groups, which, of course, keeping in mind that the laws might be quite different between different bands as well, right? So
Yeah.
it's important to also keep that awareness that the stories that we share are about this specific band council or group of people, and not to be extrapolated into a pan-Indigenous kind of way of understanding First Nations culture and ways of being.
I think I really appreciate what the Chippewa of the Thames have done recently. They're called the Deishkan Zibing, and they're a community that's a bit west of Toronto, a couple of hours outside of what's now called London, Ontario. And really, what I appreciate about them is the constitution that they promulgated has a recognition of, as we would say, the more than human world in that constitution. They recognize, for instance, the agency, the legal sort of personality of fish and animals and plants and birds. And in that context, they see that the decision making that they have to engage in is fully a part of the surrounding territory that they're in. And then you take that a little bit further, and they say that everyone in that territory has the rights to be inherent as recipients of those rights. And so that for me is really powerful. All the rights entitled, all the waterways within the territory are extended to fish, rocks, plants, flyers, crawlers, and four-leggeds. And so that, is happening in that setting. And then they've also developed a consultation protocol under Canadian law dealing with Aboriginal peoples. There's this doctrine, if you're going to infringe rights, you have to consult with Aboriginal peoples, and then you have to accommodate them. And then in the United Nations Declaration on the Rights of Indigenous Peoples, it says that there should be a right to free, prior, and informed consent if you're going to deal with Indigenous peoples. And so the Anishinaabe there, the Deishkan-Zibing people have taken that constitutional provision, recognizing the more than human world, and said, when we do work with one another, we're going to recognize that we're sharing the world with our clans, and that this sharing has shaped our treaties with the more than human world, our treaties with the British, and that settlers are drawn into that web of kinship relations through the treaty process. And so to the extent that consultation and accommodation happens in the light of these Anishinaabe legal principles, then you get Anishinaabe law applied not only by the Deishkan-Zibing people, but by the governments, by the proponents that come to work with them. And then the other part of this agreement, which I really appreciate, this consultation protocol, is the advancing of what we call our 7 grandmother and grandfather principles of wisdom and love, respect, bravery, honesty, humility, and truth. And so taking those principles and seeing those principles is also necessary to living in good relationship with the earth is something that will happen through the Constitution and the consultation and accommodation protocols. Could develop that further, but I can stop here if you want to. But, this is happening in Minnesota with a wild rice law. There's some climate change litigation with the Grand Council of Treaty 3. We're also there bringing these same kinds of views into all of their legal relationships.
Yeah, that's really beautiful. And you brought up the wild rice or the Monoman, and I would love to, I think that's a really interesting case study because the Anishinaabe are both in what is known as United States and so-called Canada as well. So to me, it's quite an interesting situation where we're looking at almost like a cross-border kind of understanding of how we govern the world and take care of it. And then I guess it also kind of relates to the fact that the Great Lakes are right there as well, too, right? And again, that's also shared by the different groups, Canada, US, and Anishinaabe. And so it's a really interesting case study. So maybe we can talk a little bit more about that if you're up for it.
Yeah, that sounds great. So I'm obviously in Toronto right now and teaching near my reserve, which is about 3 hours away. But I did teach at the University of Minnesota for 5 years and got to know the Anishinaabe people there on the other side of the Great Lakes. And the same language by and large, and stories and political and legal structures in terms of clans and treaties, etc. And what they've done is they've received recognition of having treaty rights that run off reserve, and they can regulate these treaty rights off reserve. And they've created relationships with Michigan, Wisconsin, and Minnesota to kind of co-manage in those relationships. But one of the things that the Anishinaabe people have been concerned about on that side of the lake is pipelines, and they're worried about the water that gets used in the process of the creation of the pipelines. And they also, of course, worry about potential degradation of that water if there's going to be some kind of spill. And so under their treaty authority, what they did is they recognized that wild rice or monoman has inherent rights to exist. And they say that those rights include flourishing and regenerating and evolving, and that those rights include restoration, recovery, and preservation. And so in this law that recognizes wild rice's own legal personality, they say that there's a right to pure water and freshwater habitat and a right to a healthy climate and natural environment. And in particular, they make reference to be free from human-caused global warming impacts and emissions. And there's further parts of the law that talk about being free from infection and infestation and drift from genetically modified seeds. And so the idea is that this on its own has its legal personality. And then there's provisions to enforce that law. It's unlawful to violate monoman's rights in this area. And that if a government or a business or a private or public entity would violate these rights, they're liable for damages. And part of the damages that they would be required to make whole is measured by the cost of restoring monoman as well as its habitat. And so the law recognizing Monoman with its own legal personality. If there is a violation, recognizes this idea of restoration. And then this can be enforced within a court, tribal court, for instance. And so what happened is an action was brought in the White Earth Tribal Court asking for a declaratory and adjunctive relief because there was a perceived threat to Monoman as a result of 5 billion gallons of public ground and surface water that could be used for drilling rivers and whatnot under the Mississippi watershed. And so here's the First Nation and the Treaty Authority promulgating this law on behalf of wild rice, Monoman. There is all of these systems, and then there's this allegation of damage, and then it goes to the tribal court, and the tribal court actually finds, hey, we don't have jurisdiction off of the reservation to be able to deal with that question of wild rice's own rights. And I have a challenge with that reading from that tribal court there. I've taught federal Indian law. I know that there are jurisdictional elements that tribes have off of the reserve there, off the reservation, as they say. And so I think that the court was a little bit too circumspect. They could have found a wild rice protection off of the reservation in accordance with their treaties and in accordance with the subject matter that the tribe has in tribal court to be able to deal with these questions. I guess the message here is that even under Anishinaabe law or Indigenous law, that doesn't mean that at the end of the day, that's going to do all the work that we hope needs to be done, which is why, again, it's so important to work beyond courts, even tribal courts, to try to solve these questions.
I'm really curious as to your perspective on why you think the tribal court found that. Considering just how connected everything is, it's really hard to divide nature that way, right? So it's kind of curious to me as to why they came to that conclusion. Was there reasoning behind, you think?
So I think part of the reasoning is the federal, state, tribal political jurisdictions, legal jurisdictions in the United States. And so tribes are a third order of government in the United States alongside the state and federal fora. And there's, well-developed rules as to who should have jurisdiction over what. And I just think it's applying the more conventional rules that are in the broader system, recognizing that division where, the state wouldn't have authority on the tribal lands and the tribe wouldn't have authority on the state lands. That's sort of the general rule. But that is not the rule in the case with treaty rights, because treaty rights in a case called Mille Lacs, which comes out of Minnesota, those can be exercised off reserve and can be regulated off of reserve. And so I just think the court read a convention too narrowly and didn't actually follow the treaty jurisprudence in that area.
That's interesting. So in terms of that case, is there a next step where they can appeal or do anything about that? Or is that kind of just...
That's kind of it, because that's the equivalent of the Supreme Court in the White Earth Nation. So you can imagine that they would reformulate the law perhaps, and maybe there would be an action that's brought on the reservation where something that's happening off the reservation, say water quality or quantity, is affecting on reservation rights. And then the tribal court might say, oh yeah, we've got jurisdiction on the reserve. And as a result of that, then there could be, implications for off reservation activity at that point. But I haven't heard that's occurring, but I can imagine that would be another step to try to take this law's principles into application.
And I mean, correct me if I'm wrong, but it's almost like, from what I heard you speak about at the lecture, it was almost like, well, I think you used the term, it's not ripe yet, like no damage has been done yet. And it just seems to me a little bit kind of like, so we're going to wait for the damage to happen and then restore. It just seems a little bit like, it's going to happen.
Yeah, you want to put the fence at the top of the hill rather than the ambulance at the bottom of the hill, right? So that you don't have the people wandering off. So yes, I think that's what the Treaty Authority was trying to do, and the White Earth Reservation was trying to do, is be more proactive and prevent the harm from happening. There is this doctrine, though, in judicial circles called ripeness, meaning you can't bring the action until it's actually transpired. And the idea here is that you want to preserve judicial resources because you can't just be speculating to all the possible things that would happen in the world and bring actions before they actually transpire. So this is, it's a, we were talking about earlier, that the judges try to stay in their lane, and this is one way they try to stay in their lane, is only rule on actions when there's actually that's before them.
But this case in particular was about Enbridge, isn't that right?
I think it's line 3. I think that's it.
Yeah.
Right?
So Enbridge is line 3. And I just wonder, it's like, well, we've seen the history, like Enbridge's track record, and I just wonder whether that could have played more into the analysis, because, there already has been a spill. Bad River Band is still kind of dealing with that even years after the initial spill happened.
Yeah.
So yeah, to me, I guess, I mean, I often feel this way about the world, but I feel very puzzled. Like, what are we doing? What's on?
You're right. And yet the challenge from a legal perspective is that you can't have something wrong happen and then pass a law to try to deal with the wrong that happened in the past. In other words, that's a retrospective law. So say you and I did something wrong and it's not illegal, but 2 months from now, the legislature acts to try to make the thing illegal when it wasn't illegal, we'd go, no, wait a second, that's unfair. That's not due process. And so I think that's the challenge here, is you can't bring an action before it's actually transpired, and you can't also pass a law to just deal with something that's happened in the past, because you need the law to be there first before the action can be brought in relationship to the harm.
There's a bit of a circular reasoning there, though, isn't it?
There is a circular reasoning, that's right. And so what they're trying to do is keep time in check. And you know that that's not always possible. I've written a book. It's not published yet, but it's going to be out there soon. It's called Life's Shifting Cycles. And it's trying to understand that we can't just control linearity in the way that you and I are talking about right now. And causation in time doesn't always flow in that linear fashion as well. And so to draw on Anishinaabe insights around, we call the good life, the fast life, the wandering life, the doing life, the planning life, realizing life, and the elder life, right? The notion is that we need to think of time more holistically as well, but the courts are not doing that. But that doesn't mean that you and I can't do that, or legislatures can't do that, or First Nations can't act in other ways to try to deal with prevention, or to try to clean up the mess that we've already created.
Yeah, I guess in some ways the law is almost like, you almost like don't want to have to use the law. If we've gotten there, it's kind of like, well, something not so great has already happened.
Yeah, we certainly don't want to use those official channels of law, but what would be great is if we could use Anishinaabe law or Indigenous law to prevent things, right? Like if we carried around the idea of love and wisdom and humility and truth, then those are preventative legal principles. And so we want to use law then before something happens. And hopefully then we don't have to get to the courts.
Yeah, because I mean, you talk about love and wisdom and truth and honesty, and I wonder how often those words show up in Canadian legislature as even of values, right?
Yeah. I mean, you can see, you swear to tell the truth in cases, and so there's that honesty and truth that's found there. And we do, want to find places of respect and courage, but they're just so much more prominent in this Anishinaabe legal formulation. In Canada, United States, we talk about life, liberty, and security, and equality, and good principles. But there's a different aim with Anishinaabe law. Like, let's talk about love.
I was just gonna say, that's the main thing that I think was missing. Like, it wasn't the word of love. Yeah, and I think maybe love is seen as like this kind of squishy, too soft, doesn't belong in something that's so.
Yeah, as if life, liberty, and security isn't squishy and soft, right?
Yeah.
Those are really hard things to work out too. But I think the challenge is that people don't want to be coerced to love. And in Western law, we think of law as coercion, and it would not love if you're coerced. But in Anishinaabe law is not only, it does have an aspect, if you want it in particular areas to be enforced, but it's not primarily relying on coercion. So you can talk about love in relationship to Anishinaabeg law and not coerce someone into a relationship. Whereas in the Western forms, that's more challenging.
So I wonder if we're almost like kind of picking up on a cultural difference. Like, I think in the Western world, the idea of love is it's for your significant other, it's for your family. And I mean, sometimes there's conversation of like love as like for friends and comradeship. But often it just sounds like to me, and correct me if I'm wrong, that in at least in the Anishinaabe way of viewing life, love is more expansive than that. It's not nearly quite as limited and finite.
Well, it could be. So there's different words for love.
Okay.
One of our words for love is the Gidawin, which is stingy love, like an exclusive love, as it were.
Okay, sure.
And so we need that because we want to have some fidelity between people and relationships. But the idea of Joanam is a notion of love that is about compassion and recognition of our mutual needs and our interdependence. And that sense of love is the concept, is the practice that can be legally enacted, that we do have reciprocity in law, that there is opportunity for recognizing the interdependence of people and species. And so, yeah, I think that we can do more to explain the possibilities of law and love through an Anishinaabeg legal lens, and then find perhaps analogies in Canadian law, not all over the place, of course, but in defined channels so that you can, get some rough comparisons happening there.
Sure. Does anything come to mind in terms of an analogy?
So I think of the work that's done around restorative justice in some of the Western legal systems that isn't just about past backward looking, let's identify who's to blame, but forward looking, let's get better, let's heal from the damage that's been occurring. And so when you talk about the healing, when you talk about the restoration, when you talk about restorative justice, then it's not only about love. There's also all those other values too. You want truth and honesty and respect and courage, etc. But there's more of a place for thinking about the mutuality of our reciprocities there, and that the fellow feeling, as it were, for one another in that setting.
Just in case our listeners are kind of new to the concept of restorative justice, could you kind of flesh out what that is? What does it look like in action?
Yeah, so let's just give an example. Some young person is upset, angry, and they go into the school and they put graffiti all over the walls of the gym, and they maybe break a window, and they maybe just throw all the teacher supplies all over the floor. Our conventional system of justice in the Western realm would be to try to figure out whether or not that person did it. So we'd be looking to find blame, as it were, for that person. And then that person would be charged, convicted to deal with that past harm. But in a restorative justice system, you would bring that person in and they would sit with the custodian and hear from the custodian all the work they have to do to clean that up. And they might hear from the superintendent of the school boards to know how much it costs to be able to clean it up. And they might hear from the teacher in terms of their investment of time and energy, so that they internalize some of the costs that they created for others in that process. And then they might, as a part of the sentence, as it were, be asked to work with the custodian for a month and see what that's like, or perhaps be a shadow to a teacher for a couple of weeks as they're cleaning up at the end of the day, so that rather than being sequestered away, being fined, or being imprisoned and externalizing, that's someone else's problem, I just sit here, do my time, pay my dues. This actually requires an active engagement of the person that's done the wrong. And so there's a restoration that can occur that would also maybe change that person's own heart. And what they, it's an educational opportunity in many respects. And so that's what I mean by restorative justice, is trying to bring out the interdependencies, the reconciliations, I suppose, that restorative justice is aiming at.
Yeah. And what I also see in that is almost like in the more conventional method, you're almost like casting them out. You're exiled. We're done. Pay this and we'll move on. But this is like, you're not going anywhere. You're staying right here.
That's right.
And it's like, we're still together and we're going to talk this out and we're going to work our way through this.
Yeah. Yeah, and of course there can be a role for denunciation and separation. There's
Sure,
some
sure, sure, of
things that
course.
require that. But just to go to that by default in all of our circumstances is to cut us off from
Yeah.
the restorative justice dimensions.
That's really beautiful. Thank you for clarifying that and fleshing that
Yeah,
out.
yeah.
I wanted to come back to your book because I believe you were writing it for quite some time and it sounds like you just finished. So, yeah, I love thinking about time. Like, I've learned about concepts like deep time that seem to be kind of like at least analogous to some of the things that you've been saying. So, I'd love to hear more on kind of about your book and I guess your perspective on time. And maybe this is a draws from Anishinaabe culture as well.
Yeah. So the point is that, right now for us, it's the same time on the clock.
2:31?
So there we
Yeah.
go.
Okay.
And so there's a
Agreed.
kind of a synchronicity in
Sure,
relationship to
sure.
how we measure time. But you've got different things going through your mind. I've got different things going through my mind. And that will bring us into an asynchronous relationship with time. In other words, you will perceive time differently than I will, despite us being at the same moment on the clock. And then that opens up a world of possibilities for us to help one another appreciate all of the opportunities that exist in relationship to time, because it's not just objective. There's a subjectivity in regard to how we relate with time. And that subjectivity means that I can be benefited by how you structure your life's patterns. I might be able to learn from that and perhaps pick up something in my patterns because of what you're doing with your patterns. Or the contrast between those patterns might also illustrate a mindfulness for me about what I'm doing that I wouldn't otherwise appreciate if I just thought, this is the only way of doing things in the world. So I guess the point of the book is to recognize the living nature of time, that time is being, that it has a personality, and that we relate to time as not an it, but as a force. And in Anishinaabe, when you mark out time, you actually mark time as an agent, third, fourth person, as we talk about that in our etymologies. And that just means that I can be more available, I suppose, to other people, recognizing that I'm not just relating them with a clock, but I can be available to them in other measures, in other ways of thinking about passages. And so the book is an attempt to do that work of opening up space to be more available to more than human world, the human world, because there's fluidity with time. It's not just a rigid set of mechanistic approaches. Time is experiential. It's not just chronological. And so to bring out that aspect is a part of what I'm trying to do. And then I've tried to talk about this in regard to some environmental settings around deep time and geological time and colonial time and elder time. We can talk about that if you'd like. But in thinking about our relationships around climate change, particularly, we can have another view when we see time more fluidly.
Tell me more about what you mean by that. This all sounds very fascinating. So, yeah.
Yeah. So we have stories as Anishinaabe people in this territory of how the earth was formed on the back of a turtle. And there's a whole creation story that would take hours to tell. But part of what we see in our territory is that these Niagara Escarpment features that run back the Ontario over to Michigan and Wisconsin, that Niagara Escarpment was formed 440 million years ago, and it was formed at the equator when Ontario, what is now Ontario, was a warm, shallow sea. And there was all of these little swimmers in that water, and it was much like the Great Barrier Reef. And eventually they die, and dying upon one another, they form these corals and these reefs, and this limestone feature gets built, and then plate tectonics happens, and over 440 million years, what was once at the equator drifts into our territory, drifts to the latitude that it is now. And what that means for climate change is to recognize the earth moves. The earth is dynamic. The earth is fluid. It has had changes through time, and those changes are there for us to see when we're looking across the cliff face at the Niagara Escarpment. We also see that there are those changes when we look back 12,000 years ago here. So moving from deep time to geological time, if I stood here in Toronto and looked up a kilometer above my head, there'd be an ice sheet that would rise that high. And that ice sheet pressed down on the earth and caused the earth to change its form. And of course, when it started to melt, it created all sorts of rivers and lakes and different, rebounds in the earth and depressions in the earth. So in other words, there was another dimension of climate change, as it were. And Anishinaabe people start to have stories of their own personal experiences as the waters melt here. We have other stories about these times. So those two are climate change that's natural. But the next two stories, the next two measures of time, show human provoked climate change. So again, standing in Toronto here 500 years ago, there would have been Wendat people, Seneca people, Haudenosaunee people, Huron, Tobacco, and neutral people. And then quickly the climate changed because people came and they started cutting down the pine and oak forests, which caused the streams to warm, which led to changes in microclimates. And then the fields were planted with monocultures, which creates further microclimatic changes. And so from 500 years ago to now, in this colonial time, we've seen the dramatic change of these environments, the human caused, right? And then, of course, in the last 90 years, if you talk to elders, they will tell you that the fish are running at different times, or there's no more certain species of fish that are running anymore, or the flowers are blooming at a different period. The sap is running from the maple sugar and birch trees much earlier than it used to. And so you get the sense of human-caused climate change from these elder stories that is because of those colonial time events that we were in. And that means that the larger changes that we saw in the geological cycles or the deep time cycles are being accelerated. It's becoming more dangerous for human and more than human, to exist in those places. And so I often say, if you want to know what it's like to live through an apocalypse of climate change, look to an Indigenous nation and see how their climates, their environments have been changed over the past 200-300 years. And look what the people are doing, how, they've been impoverished and they are not as well fed and sheltered as they were. And part of that is because of the manipulation that's happened through colonialism. But a part of it is that we just don't have the same carrying capacity of the land as well. And so, and likewise with the last 90 years of climate change, if you want to know what the future might look like, you can see resilience. Indigenous peoples have been resilient in the faces of these collapses, but that resilience doesn't bring back the fish and doesn't cool down the air like we need. And so this is what I mean in thinking about the relationships to time that we might have and how we can think through we might do, for instance, around climate change. Which I know I'm talking a lot now, but there's this case that came out of Ontario recently, the Mather case, which is about climate change. And there was an argument that the emissions targets being changed was going to create greater hazard for young people. And so young people brought a charter challenge saying that their life, liberty, and security was being violated under Section 7 because they would be more heavily impacted by climate change, say as a 15-year-old than you would as a 70-year-old. And the court found, oh no, life, liberty, and security, that can't be brought forward in this instance. It's being appealed to the Court of Appeal now. And the Grand Council of the Treaty 3, which is an Anishinaabe group north of Minnesota in the western parts of Ontario, talk about these relationships to time. And they say, in Canadian courts, we need to have both Aboriginal law and Indigenous law address the question of climate change because it's about these, as I've been saying, these relations with our kin, the more than human world, the Monome and the wild rice, or the our clan relatives, or the the corn, or whatever the case is. So I guess I'm seeing and saying that you're seeing these concepts of time that Anishinaabe people have moving into not only things like Monoman law, but also moving into climate change litigation as well.
There's so much there. Yeah.
Yeah. And so when you think about being so much there, what we need is one another, right?
Yeah.
We need to slow down because there's just so much to process.
Yeah.
And we
Tell me
need
about
each
it.
other to process through what those implications are for one another. And then again, like those consultation protocols I talked about with the Deishka and Zibing, how do we make sure that we're living Minomatsu in the good life? How do we ensure that we can keep all those relations that we're so dependent upon as humans?
And part of what your talk that I was listening to earlier, you talked about kind of existing treaties that the Indigenous First Nations had with the more than human world. So there was a story about a treaty with Buffalo, a treaty with the Hoof Clan. And I'm curious to know when, let's say, a First Nations community is finding that some sort of, let's pretend it's a corporation, they're infringing on their ability to, let's say, hunt caribou, just as an example.
Yeah.
Do you find then that in that court of law, when it comes up, that they're able to say, well, we have this treaty with the caribou, and because this came far before colonialism even happened, this actually, I don't know if time plays into it, but actually this came first, and actually this would supersede anything that you say after. Is there
Yeah.
anything along those lines that's allowed?
Yeah, so that's the implication of the argument. If we have treaties with the more than human world, those treaties are the first treaties and they have priority over the subsequent treaties. They can be harmonized with those subsequent treaties. That's what we tried to do, was invite the British settlers into those treaties we had with the Hoof Nation, say, or other groups. But so far, courts have not taken that approach. They've not said, oh, we need to view our treaties, that is the treaties with the Crown, in light of those treaties with the more than human world. They've not done that. And they've certainly not said, oh, and those first treaties with the more than human world are the priority treaties. They're stronger than the treaties you made with the British Crown. We might argue that as Anishinaabe people, but we would also argue that the importance of those treaties with the Crown should be reconciled. We should be able to put those two things together and see that the implementation of the treaty with the Crown is an implementation of the treaty with the Hoof Nation, not regarding them as either or, but regarding them as being, again, related.
I think something you also touched on in your talk was that there's space in when you're kind of relating with the more than human world, that there's a level of kind of interpretation. It's not magical, but it's like you're kind of listening in a way that's nonverbal. It's not like in language. It's done maybe through the body, maybe through our senses. I'm not sure. You can clarify that if you like. Like it's like a whole other way of being that I find perhaps that the Western world is still, I don't know if they've maybe like a lack of embracing it or kind of like are still kind of learning it, even though it's where we come from. This strange homecoming to return back to what we already were in some ways.
Yeah, no, that's a beautiful way of expressing it, a homecoming to return to who we are. I think that's part of the challenge here. I do think that in the Western ways, we have information that's provided to us about listening to the more than human world. The challenge right now is that it's couched in the language of science. So, of course, we do important studies and we need to control for variables to understand what the need of the watershed is, or the animal group, or the particular fish, as it were. And that's all well and good. We need to keep doing that work. But to see it as those things that are communicated through science have to be taken into the mind and into the body, into the heart in particular, so their decision making is connected to the more cold calculation, I suppose, that you would see that science is often engaged with. And so we can do that in Western forms, but we are prevented by almost this bifurcation between science and other approaches to life. Whereas in Anishinaabe forms, in the language through thousands of years has been embedded observation about the more than human world. So to learn the language is to learn some of the things that animals and plants and fish have been telling you through the years. And then stories have been passed along about these relatives that we have that give us some more of that information. And we have clan responsibilities. And part of what we uptake in our clan responsibilities is what we learn from, say, the bear or the pike or the otter in my case. And so you have that as an aspect. And then, of course, you have the deliberation that's there and you have the constant observation. In other words, it's not magic because it's a system of observation and relationship that's just encoded in a way that doesn't always bifurcate what we learn from the more than human world. And then because it's more coldly and calculating, we think it's magic somehow to think that we can understand what wild rice might be needing to be healthy in the future. Well, it's not. You could get there through science, but you can also get there by triangulating, cross-referencing, putting together the varied insights that, say, Anishinaabe people might bring to that. And then, of course, it's even stronger if you can combine that with science, which is what they tried to do in that case we talked about earlier.
I think something that I really love about more and more exposure to Anishinaabe ways of thinking and stories is the storytelling. And I think it's really, I think that, like, I mean, in general, I think storytelling is such a profound way of learning, and to be able to learn through metaphor and symbolism without kind of like the dry, like spelling it out, this is what happened and therefore X, Y, and Z. And I was just thinking that it's not like the Western world doesn't tell stories. And I think if we were able to recognize that, it's like we're always telling ourselves a story. And that's just kind of like how being a human being, having a mind, and how you're going to process information, it's through stories. And it's good to recognize. And also, it's almost a kind of like, it's almost like the fish that doesn't realize that it's in water.
Yeah, exactly. Yeah, so we do process meaning through stories with narratives attached to them. And sometimes that can get us into problems. We have to be aware of the danger of a single story. We want to hear a variety of stories. So again, we can cross-reference and triangulate. And then that opens up space for participation, right? When you hear a story, you're often invited into interpretation. And that telling and then talking about what it means can be radically democratic, radically participatory activity. It means that we don't just give it to a judge to tell us, oh, what's the meaning of that case or that story, or over to a legislature. We together can work through what meaning is. And that hope is the democratic potential of Indigenous law, the participatory potential of Indigenous law, the notion that we are invited into a relationship as opposed to giving it to someone else to tell us what to do. That's key for me.
Yeah, that's so beautiful. It's almost like the story is a tool for then just for further understanding and sharing of perspectives. Because I'm sometimes like, when I'm in circles with others, it's like, it's sometimes quite profound what people share. And it's like, you might not have experienced that yourself, but when you hear it, you're like, oh yeah, I can totally see that. And that's like a really beautiful experience that everybody leaves kind of with something fresh and new that they wouldn't have had otherwise. So I love that.
Yeah, I mean, again, that you're trying to understand someone else. And if you can put off your own egocentric nature for a moment, right? If I can do that, then I can be more likely to learn from that other person and then perhaps change the way I'm thinking about it because I've recognized they've got something I don't have and I need them. I can't be fully what I'd like to be without other people around me.
Yeah. It kind of makes me think of like sometimes we talk about interconnectedness, but it's like instead of saying like we have a relationship, I've also heard the saying we are a relationship. And I really like that as well. I think it's so easy to think that we're separate. And it's very like quickly when you start to like remove you can't like take any of the elements away without everything kind of falling apart. So it's
Yeah.
really beautiful to just kind of really kind of constantly, it's like our mind is constantly saying that these are different objects in different places and they're separate, when the reality is the opposite. And you constantly have to be kind of like exposing yourself to that experience to really keep living into that.
Yeah, that's right. So, Walt Whitman said, I contain multitudes. That notion that we are a relationship is so profound. And, I've also heard, I think it's Thich Nhat Hanh talks about when I'm eating a sandwich, I'm related to the sun who gave the light. I'm related to the water that fell on the roots. And I'm related to the laborer who collects the wheat. And I'm related to the baker. So that, just sitting with that sandwich is to sit with a multitude of relationships that we might not otherwise appreciate unless we slow down and see the narrative that's in that I am relationship point that you made a moment ago.
Yeah, so beautiful. And I wanted to just bring that to kind of full circle to kind of a related concept that I heard you say, that nuance is sacred. I wanted to finish off on that because I think we've really lost the practice of engaging with nuance, to being open to nuance. It's like there's like a kind of knee-jerk reaction of any nuance is just a reason to cast someone out. And we're at a time where we need each other even more to really kind of pull through for the planet, for each other. And yeah, I'm curious to know kind of your thoughts as to how to regain that, like to kind of pull ourselves out of that nosedive of kind of the tendency to reject and push away.
Yeah. So I think part of that is embracing the different ways of relating with time. That there's a moment for social media time, but people are sometimes spending 8-9 hours a day on social media. And there's a moment to be able to have the kind of conversation you and I are having. And there's a moment to sit quietly in a park. And there's a moment to, go running. There's a moment to maybe be in a ritual, church or a synagogue or whatever that might look like. And there's a moment to be able to find yourself in a friend situation where you're just all talking at the same time and talking over one another. And we get into chambers, I think particularly with social media, where there's just one way of communicating that tends to bifurcation and dichotomization and polarization. And we need to pull out of that back into these other socialities to be able to see that we can relate with time in different ways. And then the nuance emerges. Because what was happening in this place is different than this place, but they're connected. And I can see the shades of possibility that are there. It's not just an either or. There's all sorts of granulation that exists in those places too. So yeah, that's my sense, is that we do that with our bodies, and we need to just get away from our eyes with screens in order to have that occur.
Yeah, I love that. Well, thank you so much. I think it's nice to kind of leave on a note of what I'm taking away. So what I'm taking away is, for me, is this idea that time is alive. I almost like, as an artist, I kind of think like, what would time look like? Like, does it have a feeling right now?
Who is time?
Yeah. Who's its mother?
Yeah.
Do I need to tend to it? Kind of like a really interesting thought experiment there. So thank you for that. And I was wondering for you, is there like a kernel that you'd like to leave with our listeners as a takeaway, or something you'd like to take away?
I guess just the joy in being able to talk with you is part of the joy of life. That is, if we can keep searching out one another, and you and I hadn't met before being on this conversation today, but I find that this is what days can look like. You can just encounter people and be surprised and find that possibility. And so thank you for the gift of reaching out and being able to learn more. It's good to be with you today.
Oh, it's so good to be with you too. Thank you so much for your time and your wisdom and all your sharing and everything you contribute to the world of law. All of that too.
Thanks.
Hi everyone, Connor Curtis, Head of Communications with Sierra Club Canada, jumping in here to do the Q&A for this week. A quick note before we begin: the Q&A section of our podcast is just us responding to questions on behalf of Sierra Club Canada. The views we express here are not on behalf of our guests on the podcast. We have a question this week, which is, why aren't all roofs and pavement being painted white to supplement glacial reflection of the sun? And this is a very interesting question. I was not as familiar with this particular idea as a concept, and I'm not going to claim to be an expert in any way in responding to it, but I was able to do a bit of research, and what I found out was actually quite interesting. For one thing, this has been discussed for quite a long time. There are articles going back at least 10 years discussing this as an option. Part of our work with climate change is how do we both mitigate and adapt to its effects at the same time. And in that respect, this does seem to have some promise in certain areas. In fact, one of the biggest benefits to it is not so much the reduction in climate change, but a reduction in ambient heat within the house and within city areas when basically house roofs are white. The only issue I could see with pavement being painted white is you might run into in certain situations something similar to what happens actually if you're in a very snowy area and it's quite bright outside, which is snow blindness. So obviously this isn't going to affect the painting of roofs, or I should say the change in the coloration of roofs to reflect sunlight, but this could be an issue if you're putting a lot of white surfaces at ground level. And this is actually where the reflection from the light, if you're not familiar with it, is so intense from the pavement or white surface on the ground that it actually can affect your eyesight. Again, I'm not going to pretend to be an expert on any of this. That's something that just came to mind when I was thinking about this and its potential limitations. My grandfather actually used to have a pair of special sunglasses for in the north, protecting your eyes from snow blindness. So this was very interesting, though, and this is actually being done in some other places. In India, for instance, there are initiatives, what seems to be a local level, that are attempting to get people to paint their roofs white, and it actually does seem to have a positive effect. Again, maybe less so in terms of preventing climate change or reducing the impacts of climate change, although it does seem to have some benefit in that respect, but more so instead of reducing overheating within houses. This gave me another really interesting thing to think about, which was how would you make this practical from a policy perspective. And for those of you who don't know, I studied environmental policy, so I'm always interested in the problem solving of that. There have been attempts to do some of this to encourage basically lighter roof tiling in the United States. It does receive heavy pushback from industry. Exactly why is a little bit vague, but basically the same story as always. So I think that there would need to be a very strong push for something like this, and it would need to be against potentially industry backlash. Of course, I'm saying all this, none of this is the solution to climate change, of course, and to our person who wrote in the question, I didn't get the feeling that's what you were suggesting at all either. The main way we solve climate change is to reduce emissions that are coming out. But this is an interesting solution that seems to have a lot of benefits for urban areas in other ways. There are some times when it might actually be the opposite way that you want to go, and you want your roof to actually be a darker color, because if you live in a relatively cold area, a darker roof can actually help reduce your electricity bill, which if you are reliant upon electricity that comes from a fossil fuel source at this time, that might be a good way to actually reduce your reliance on that electricity and on the fossil fuel source. So there's nuance here. It's definitely not we should paint every single house in the world white on top, but there are a lot of ways in which this seems to be beneficial for particularly sunny areas where there is a lot of light, a lot of heat problems. I'm actually thinking of Montreal where I am and some of the issues that you get in Montreal. This is really interesting. How you would roll this out, I am not entirely sure, but there are a few possibilities. One way that you would roll this out would be to encourage it as part of a rebate system or as part of a green building initiative. We already have systems like this in Canada, and I'm not sure whether or not this is already covered by them or if this is something that's ever been considered. Again, I'm not going to pretend to be able to give a final answer on this. There seems to be generally some evidence that this works, that this is something that's beneficial to people. If there is anybody listening who is in fact an expert on this topic or has studied it academically, please do write in. I'd be really interested to hear what you have to say, particularly if there's been any policy attempts at this. Could look at some sort of mandate for larger buildings, for instance, for them to have white roofs, particularly apartment blocks, where is it going to really affect anybody at all if, on a 3-story apartment block, the roof is white? I doubt that very much. It's going to be beneficial for the reasons I've just said, but, is that really going to affect the visual appeal of the roof? That's probably a very easy sell, but again, you could face that sort of industry pushback. If you are listening to this podcast and you have a question, or you want to write in to respond on this topic, you can write to us at info@sierraclub.ca. We'll be very happy to hear from you. A reminder also that you can take action on environmental issues by visiting sierraclub.ca. We have tons of petitions, other actions and events, and regular news updates you can sign up for on the homepage. You can also find Sierra Club Canada on social media, and you can listen to the Environment in Canada podcast on Spotify, Apple Podcasts, iHeartRadio, and YouTube, or wherever you get your podcasts. This podcast also airs on CKUT Broadcast Radio in Montreal, 90.3 FM, bi-weekly on Tuesdays at 11 a.m. ET. Don't forget to click follow or subscribe so you get the latest episodes from us. Welcome to another episode of the Environment in Canada podcast, a podcast about the environment in Canada by Sierra Club Canada. I'm Connor Curtis, Head of Communications with Sierra Club Canada, and today I'm talking with Gilbert, Whiteduck, and Yenny, Vega, Cardenas, both of whom are working to see the rights of nature acknowledged and respected. We're going to chat about legal personhood for rivers like the Tenàgàdino, Zibi, and the Magpie River, what this means and how it was achieved in the case of the latter. We're going to chat about how you can look into protecting the rights of nature where you live. We're also going to talk about hope for the future, what to say when electoral candidates come to your door, and growing a grassroots movement that can make change in leaps and bounds. Before we begin, just a reminder that you can take action on environmental issues by visiting sierraclub.ca. We have tons of petitions, including, as of the broadcast of this episode, a petition on the rights of nature you can sign, other actions and events, and regular news updates you can sign up for on the homepage. You can also find Sierra Club Canada on social media, and you can listen to the Environment in Canada podcast on the Harbinger Media Network, Spotify, Apple Podcasts, iHeartRadio, and YouTube, or wherever you get your podcasts. This podcast also airs on CKUT Broadcast Radio in Montreal, 90.3 FM bi-weekly on Tuesdays at 11 a.m. ET. Don't forget to click follow or subscribe so you get the latest episodes from us. And a quick note that as of the launch of this episode on July 30th, 2024, for the next 3 days we will be holding emissions cap town halls in St. John's, Newfoundland and Labrador tonight, and Fredericton and Sackville, New Brunswick over the next 2 days respectively. You can find out more at sierraclub.ca/town halls. Gilbert, Yenny, thank you so much for joining me today.
Thank you so much.
First of all, for those joining in, can you give us a brief intro to who you are and what you do?
I'm Yenny Vega Cardenas. I'm a lawyer and president of the International Observatory on Nature's Rights, based in Montreal. Through the observatory, we promote nature's rights to improve the legal protection of natural entities in Canada and around the world.
Kakina, Gilbert Whiteduck, Tenàgàdino, Kitigan Zibi Nindon Shaba. My name is Gilbert Whiteduck from the Algonquin Anishinaabe community of Kitigan Zibi. I'm Algonquin Anishinaabe myself. I've resided in this territory, Western Quebec, for all of my life. I'm involved in many things. I was chief in a community at one point. I was counselor. I've done many things touching the land or in negotiations or discussions with municipalities and a number of things. All of these areas related to biodiversity and the rights of nature, especially that concept of the rights of nature, are very important to me and are historically important. And I hope that what I'm bringing is what the ancestors would have hoped that the future generations would be bringing, especially in light to what's going on with nature and against nature, whether it be in Canada or around the world.
And so that sort of brings us into today's topic, because you've both worked or are working on getting, and I saw this term used, jurisdictional personhood for natural spaces like Magpie River and the Tenàgàdino Zibi or Gatineau River. For people tuning in who are new to that concept, we've had a previous episode on the rights of nature as like a general concept. But what does jurisdictional personhood mean, or legal personhood mean, and how does it tie into that concept of rights of nature?
Yeah, absolutely. In fact, since this is one of the questions that comes very often, we have written a blog in our website where you can find a simple explanations in just one page. It's www.observatoirenature.org. In essence, legal personality is the institution that defines whether an entity or being is a holder of rights. So it is the channel that exists in our current legal system to identify what really matters in law. It also allows us to represent the interest and rights to that entity before the courts, so that that person has legal standing.
Because I know corporations, for instance, have sort of version of this actually underneath Canadian law. They're an organization, obviously, but they have a jurisdictional personhood.
Exactly. For example, human beings, we are endowed with legal personhood, which allow us to recognize us as subject of rights. So we have the right to live, the right to health, the right to freedom of speech. But also when people are gathered together, reunited together with a purpose, they can start a corporations or create a corporations. And that corporation has a legal personhood. It also has rights. And the same is happening for natural entities. So like rivers, mountains, forests, jungles, they have been bestowed with certain inherent rights, like the rights of preservation, maintenance, and restoration. So legal personhood is a channel that allows us to protect a natural entity or a person or a human person or a moral person that is a corporation. So it's a very useful tool to hear the voice of people, of objectives, and now natural entities as rivers. So to listen the voice of the river is a very important channel that we can use toward a better protection of those entities in law, in our legal systems.
I know that the Magpie River in Quebec was given legal personhood by the Innu Council of Equinichit and the Mingani Regional County and Municipality. What did that process look like, and what have been some of the outcomes for the river since?
That process was unique. So for the recognition of the legal personhood for the Magpie River, it begins with a conversation between Indigenous and non-Indigenous, only individuals. People were concerned with the protection of the river before a dam project in this particular river. So they wanted to know how they could protect the river to make the voice of the river to be heard. So we went there and we started to analyze different cases around the world to find the best way to recognize the legal rights of the river to be heard. So we came to a consensus on the importance of elevating the river as a person and giving it rights and legal standing so that its voice could be heard around the world. But of course, the leadership of the Innu of the Quanichit was a key part of the process, because they were already in contact with the Maori in the New Zealand, who had recognized already the legal personhood of a sacred river there, the Whanganui River. So they wanted to follow that path. So a consensus was reached with the concurrence of the regional county municipality of Mangani, who wanted also to work with the Innu to protect the river. So an important consensus that we could found there. That's why we say always that was a perfect case. So the passage or the adoption of these twin resolutions, was a demonstration of a truly beautiful understanding, cooperation, and even reconciliation between Indigenous and non-Indigenous peoples in the north coast of Quebec. And now the river is a legal entity with rights, and its voice has been heard around the world. So now we can say that it's now one of the most recognized rivers in Canada because it now has a story to tell between generations. And it is a powerful example of how a river, to understand how a river is sacred and should be preserved for future generations, and how important it is to change also the relationship we have with rivers. The example that we have, beautiful examples to follow.
And I'm interested in that. You said it also was sort of a forum for reconciliation within the communities as well. I wasn't aware of that aspect, but that's very interesting.
The chief, Jean-Charles Pietachot, said it before the ONU instances. He said, many people are speaking about reconciliation, but we are not speaking, we are doing it.
Yeah.
It was great because he was there presenting the case also with the prefect or the director of the regional county municipality of Mangani, who were really good friends.
Well, and Gilbert, I read in an article covering your speech at last year's Gatineau Riverfest that you're hoping people will start a dialogue on the personhood of the Tenàgàdino Zibi in Gatineau River. Can you chat more about what you feel is important about dialogue and gaining personhood for places like the river?
Well, it means a lot. And let me just come back a little bit, I suppose, on what happened with the Magpie and
sure,
maybe some of the differences that we're working with. For me, because we acknowledge as Indigenous people that we live in a very colonized Canadian society with the colonizers' justice system. So words matter. Words are very important. Whether we're saying jurisdictional personhood, the rights of the river, and then the use of an Indigenous language versus English or French can be very different in its meaning. And for me, the work that we were attempting to initiate by engaging people, whether it be Indigenous and non-Indigenous, together and having a greater understanding, in our case, about one of many rivers in our territory, because we believe that if we can solidify something over one river, then really it should duplicate itself in other rivers in our unceded, unsurrendered territory, and that's very important. But the basis of it, from the teachings I get, it's two main components. One of them is teachings from the sacred or sacred law that guides us, and then natural law that guides us. And each one of those bring us teachings that, as Yenny has indicated, that Nibi, water, the water as a voice. And that voice, like nature, needs to be listened to. And how all of these are connected together and connected to humanity. When we're impacting the water, whether it be a river, large, small, or streams, we're impacting humanity. Now, what are we going to do about it? What are the limitations? How do we engage individuals who up to now had not given reflection? They're having to do a paradigm shift in thinking and the words that they use in relationship to the land and the water. There's a rethinking. And bringing people together, and that's what I've been trying to do at a very minuscule level, bringing people together, at least from the region, as much as we can and collectively can, to have a dialogue and discussion and say, what does it mean to you when you think about it? And more importantly, what will it mean to your children and grandchildren and future generation? Because what we're doing now is really not just for us now, it's all of what is to come. And that's what's important, trying to get people thinking about that. And there's been an interest, there's been an engagement. People are still having difficulty to understand, to saying, well, what does it mean? You're going to take control of the river? You're going to stop all development? Because already on the river, there are 3 hydro dams. It's different than the Magpie.
Right.
386 kilometers long. It used to have many, many rapids, but that has changed with the dams. And there are many villages and towns, and it empties into the Kitchissippi, into the Ottawa River. So these are all aspects that need to be considered. And as I've often said, it's not about stopping development. It's about taking care of the river in the best possible way. And when development is to be considered, that there be increased factors to be looked at before any development is allowed. Because the idea here is not to confront, it's not to say no, no, no to everything, but rather we need to do a deeper reflection each time we do it and say and ask ourselves, are we hearing the voice of that water that's been flowing for hundreds and thousands of years, have been flowing and have been used and misused, in our case, not for environmental purposes, but for economic reasons? It's been misused and will continue. And how do we engage people? And that takes work, and that takes connection between people, Indigenous and non-Indigenous people, talking to each other and understanding each other, and saying it's not the non-Indigenous people that will take the lead. We will do it together. We will do it together, and we will do it by listening to the voice of that river. And how do we do that? That takes work. That takes rethinking. That takes my experience up to now, having met many, many people, it takes a lot of reflection. It's just not how they were raised for most people. Some, yes, I have to acknowledge. But for many others, it's just not where they're at. So I know, and I'm going to be patient and be hopeful that change can be brought about, like the Magpie in this river, but other rivers, and that kind of not new approach, because for us it's not a new approach. It's an historical way of how things were done, how the rivers were taken care of, and the purpose of the water that flows. But to have that understanding go out there, and indeed, Canada as a whole speaks about reconciliation. And very often it's a very broad term of what that means, reconciliation. Some would say we need reconciliation. Where is the action? And what are the benefits? And what are the benefits? And they cannot be benefits that come to individuals. It's a collective benefit that we have to seek, a collective benefit for all generations. So again, dialogue, connection, getting to know each other, because Indigenous people and Canadians in general, we don't know each other very well. I've made many presentations, we don't know each other. And the history of Canada is not well known. And therefore, when I speak of sacred law and natural law as being fundamental in hearing the voice of the river, it engages people. It pushes them against the wall to question what they have been doing also. Not in a negative way, never in a negative way, but in a reflective way that will be meaningful. And I'm hoping that when I have, and my colleagues have some of those discussions, that these individuals are going back home and within their family talking about it and saying, what did they mean? And what does it mean for us? And getting that dialogue going, especially among younger people who are either in leadership positions or on the verge to take on leadership. So they need to feel it also and have that understanding in order to kind of catapult it or ramp it up to where it is that some of these things need to go. I mean, in this region, in the Outaouais region, in the Gatineau Valley region, but really across Quebec and across Canada for that matter, and let alone around the world.
Well, and it's interesting you say that dialogue, the dialogue being a dialogue with the river as well, and with the space that you're talking about, because that's something too. When we did the Rights of Nature podcast, the earlier one, that was something that came up. This idea that there would be this conversation now, not just between people, but between people in a natural space, was something that caught me off guard. And it's funny, but I get exposed to a lot of environmental concepts through my work and everything. And even for me, when I first heard about the rights of nature and people were first bringing it to me, I guess maybe because I've been so involved in the activist side, and in quotation marks, I've been so involved with the fighting over a topic with somebody thing. My mind first goes to what's going to be the knee-jerk reaction to this, right? Like somebody will go, "Oh, it's anti-development" or something like that. My head was immediately there as an activist, whereas as opposed to what you were talking about, which is much more having conversations and actually talking about these concepts and having a conversation with the natural world as well.
Well, I think the goal in my mind, what I've come to learn, it's the connection with people. That connection and what we can call grassroots. And that takes time, because it's not only about large gatherings and a lot of people and beautiful speeches. It's really being able to reach people fundamentally in their heart, really, and what that means, and then that understanding about how we work together, because in Canada, let alone in Quebec, that relationship between Indigenous and non-Indigenous people is still very, very difficult. It's continues to appear that we don't have our place. We only have our place when it benefits the non-Indigenous society. Then we're invited. As I often say, we are invited to many things, but it's a little bit like being invited to supper. You're invited to supper, but you're not allowed to sit at the adult table. We're put at the children's table. And I'm saying that has to change. And in some places it has changed, depending on how that dialogue is going. But it takes persistence, it takes work, it takes trying to define even those terminologies, colonial terminology of legal personhood. The river always had it. Really, the river always had it. It's just that government law, society in general, the foundation of Canada, the constitutional foundation of Canada, didn't really take those things into consideration in a way that it should have. I think for Indigenous people, maybe we assumed that it had, but we quickly found out how governments can quickly change laws, environmental laws, soften them up for the benefit of corporations very quickly. So even in the work that we're doing, we need to be mindful that even though we may believe we've made gains, that we always have to be so vigilant and be able to voice very openly in a respectful but affirmative manner the concerns that we collectively have and what we need to do to work together to bring about those changes. And as we well know, and as we well hear, we're on that brink of major impact. It's happening for sure. But for me, environmental changes don't happen within a year. They happen over decades. But it's when you're able to focus on what that means in a bigger picture that I think we become not alarmed, but maybe more involved, more prepared to invest a little bit of ourselves, because there are many issues in Canada, but we invest a bit of ourselves through our voice, through the people that we elect to Parliament, through the people that are representative of organizations and whatnot, and are doing those things. For me, that has become very important. But it's been a real interesting, not challenging, but eye opener for me in the past couple of years. And I want to mention this here. For me, when we speak of the voice of the river, which is so important, because I travel down to Ottawa from my community, 130 kilometers away along the river, and I look at the river, and I've often said this. I said, when I travel, and again, many, many years of doing politics and education and whatnot, in my mind, at times when I'm driving, sometimes on a beautiful evening or early in the morning, the fog is just rising, and on other days the water is just sparkling. There's something magical going on. I think in my mind of my ancestors, the ancestors of the Algonquin Anishinaabe, paddling either up or down the river, having to portage at the time without the dams, the many portages in order to get into the territory. And I wonder, in my mind, the spirits of who they were is still there. And as I'm driving, what are they thinking of me in the sense of taking care of this sacred water? What are they thinking of me? I'm thinking about them, that as they canoed or up or down, that they were under the belief, for sure, that it would always remain from what they saw. And keeping in mind, along this river, like many other rivers in our ancestral territory, there's burial sites. There were people born alongside that river. There are people that died alongside that river. There were ceremonies. So you have the sacredness of the water. You have the sacredness of what took place along, in this case, 386 kilometers of the river. So there's an overall sacredness that comes to put an envelope around all of this, along then that combines to the sacredness of water, as we well know the importance of water. And it comes down to, so what are we going to do concretely? And how can we do it? And indeed, what is the role of government within all of this? Federal, provincial, municipal governments, organizations, all of these things. And for me, it starts from people. I'm a strong believer in people movements. I get weary when governments all of a sudden get interested. And I know they have a role to play, but I get weary when they get too involved and they want to control where the canoe is going to travel and how it's going to travel. And they start paddling. And they say, just sit back, we'll take care of it. No. It's got to be a people movement, because each individual, I often compare, each individual brings a grain of sand or a drop of water. We'll say a drop of water. And that drop of water that we all bring is what creates that road of opportunity and hope that things should not, at a minimum, get worse. Can't allow it. That we need to be thinking about things getting better and moving beyond status quo. Huge challenge. It is a challenge. Many people I meet and people wanting to take control, who leads, all that kind of thing. And I say, no, stop for a minute. It's not about us. It's about the sacred water. Not about us, directly about us. It is, but we can't forget the water and the voice that it has and what it's telling us. We can't neglect that, because all of a sudden we as humans, we want to control everything. We want to have a say over everything. We want, we're the most powerful. Well, the most powerful is our environment, is really that biodiversity and that connection of all of these things, which includes water, which nourishes all of these things. And we in turn are connected, because for us, Algonquin and Anishinaabe, I mean, our roots are in this territory that goes back thousands of years. This is where ancestors lived and used and connected and prayed and tried to understand. And I take it now that my generation, generations to come, have the sacred responsibility to do what we can in the best way we can. Unfortunately, within a colonized state, which is Canada, with its laws and whatnot, we work within that paradigm that's been imposed on us. But we maintain our own paradigm of sacredness and natural law that hopefully guides us in a good way.
Well, and it's true, the story, and I mean, like, again, maybe I'm a little biased here. Part of my job is obviously monitoring news headlines every day, and the story is very much always one of decline, right? The natural world is declining, or we're seeing more destruction. That proactivity that you mentioned, that idea that actually we can have gains for the environment, that something can be proactive and building, it's so missing from the dialogue that we have nationally and in the media. It's something that's, yeah, it's very sad not to see it there. I did want to ask you about that sort of governmental interaction with this, because obviously there are going to be lots of different levels of government. In the case of the Magpie, you were talking about sort of municipal governments, I think, being quite involved, or regional government, right, being quite involved. And we've also seen the release of a preliminary for the National Biodiversity Strategy and those sorts of policies recently. I'm curious if you see connections between those policies and if there's anything that maybe they're doing or failing to do.
In fact, I totally agree with what Gilbert says already, that it's important the involvement of people and also different organizations as Sierra Club and others in the rights of nature movement, because we have tried to ask governments also and politicians to embrace the movement, and it's not easy to get there. But I think I really consider that it's the right time to all people who are now listening to ask the governments and politicians to fulfill their commitments to protect nature and take action to fight biodiversity crisis and climate change. Because if they really want to do something to make a difference, it is to recognize at their level, federal or provincial, that nature has rights. One statement is enough. We have asked already the federal government several times to recognize that not only do people have rights to a healthy environment, but that nature also has rights because it has an intrinsic value. And I don't know if you are aware, but some of the old water regulations are going to be revised at the federal level in the next year. So this could be an opportunity to include the rights of rivers. And the same could be done at the provincial level. So I think it's time for action, for us to mobilize ourselves, to ask them to do what they need to do, what have to be done. And at the municipal level, they can work hand in hand with Indigenous nations to recognize legal personhood and rights to specific rivers that are found within their jurisdiction and act as legal guardians. They will be very effective because local communities are in a better position to protect rivers, to monitor them, and to recognize when some interested are not respecting the regulation already in place, and are harming the river in a significant way. So we really believe in local communities, Indigenous nations, but please ask your representatives, your governments, federal, at the provincial and a local level to take action to recognize the rights of nature, because it's very, very powerful to protect nature for future generations. Humans are not humans.
So people may be looking at personhood for natural spaces elsewhere who are interested in the work that you're doing and they'd like to do something similar. What would you recommend their first steps be?
Yeah, we invite people to read some of our blogs to try to understand better the movement. Also, our book that we have launched on the legal personhood for the San Lorenzo River and other rivers of the world. They can start because we have many cases. For example, the case of Ecuador that is very interesting. Colombian case too, the Whanganui River in New Zealand, so they can start learning what happened in other countries. And also we have published a text on the Magpie River and also in the Quebec law system and how it is prepared to make now the important step of recognizing the rights of river. They can also find some webinars in our website, and then when they are really, they can also better understand the implications of the nature's rights movement. They can identify a natural entity to be protected. Once this exercise is done, we encourage them to contact the International Observatory on Nature's Rights, as we have more and more volunteers to help communities start these processes in a successful way. So we can give them some orientation. But first of all, they should read a little bit, look in our website, and we have webinars, blogs, and the book too, and then to be prepared to do the big step.
I'm curious too, like for your work, Gilbert, what's the next step?
Well, there's a couple of things. We know that we need to have better data in regards to the river. There's a lot of data available, especially for the southern part of the river, but we'd like to have more data for all of the river. So there is work to try to secure some funding to hire some expertise that would help us, and including elders, of course, to help us gather some of that data and then make that data available on our website. That's one thing. We are now finalizing, because we created an alliance, a group of people who came together and we're forming that alliance, and without wanting though to make it into a corporate structure. I'm not a believer in make this in a corporate structure, and then we lose perspective from that. So we got to be careful of how we're going to formulate all of this. And we continue speaking to people at every event in every possible way. But again, studying the river and laying out some of the important issues that need to be considered, continuing to raise these questions, if there are questions or reflections, more importantly, with municipal governments or at public forums. Federal elections are around the corner very soon, and asking the individual candidates who will be running in this riding, which by the way is called Pontiac Kitigan Zibi. It's interesting that it's now called Pontiac Kitigan Zibi, which is the name of our community. Someone in the federal government decided that that's what they were going to do. And as I once asked someone, do you even know why it's called Pontiac and who Pontiac was? The Grand Chief Pontiac and whatnot, and most people don't know. Anyhow, asking these individuals who are running, where do you stand on it? And what are you prepared to do as an individual MP? I understand the party has position, but where do you stand on it? And what are you prepared to do? Which is different for me. And that seeking some level of commitment that they're going to be a strong voice whenever and however this issue of the water and the rivers and the biodiversity comes up, or if they're a standing committee or whatever the case may be, they will be a voice, because hopefully they will be the voice of the people, because that's what you are. You're elected to be the voice of the people. And if the people are saying this is what we want you to advance, and it may go against your party sometimes, I get it. But I would hope that when you're speaking, you're the voice of the people. It's the voice of the people that will trump even your own party's position. That's my belief. That's how I would approach it.
In what is always a difficult time in terms of polarization on issues, I think it's always refreshing when somebody, no matter what particular perspective they come from, is willing to talk about the natural environment and represent people, and maybe break sometimes with what they feel like they would have to say, but actually to represent what they hopefully truly believe in, right?
Well, what I have to say about that, having been a local politician in a sense, as chief in the community and then counselor and whatnot, like I don't believe in being muzzled. I don't, you say what you believe and not without just saying anything. Got to say something that's important, and to the thing. But being able to voice those things, that's a responsibility for me. It's a sacred responsibility that we have, and maybe too often that has not been the case, where people have been silent or they become really good at detouring and going all over the place without ever saying anything, and then at the end saying, "Oh, reconciliation." Kind of hear the word reconciliation. Well, reconciliation, yes, with Indigenous people, reconciliation with the biodiversity. We have a reconciliation with nature and the rights that they carry, and that reconciliation, each one of us, in the best way that we can. Where no human is perfect, but the best way we can to find ways to have the reconciliation again, for the present moment, but more importantly, for the future. And one of the things that I repeat when I'm given the opportunity is that when I look ahead 25 years, who knows, 50 years, whatever the time period is, and I'm long gone, you're long gone, we're all long gone, I'm hoping that the generations that are going to be in that time, and when they're looking back, because they're going to look back as we look back at our history, I'm hoping that when they look back, they're going to say, you know what? These people, a lot of, not all of them, but a lot of them came together and they did things to ensure that we have the biodiversity, and they moved the discussion in regards to the rights of the rivers and nature forward. They did things. They didn't achieve everything they wanted to. They squabbled and whatnot. That's okay. But you know what? They didn't just remain status quo or regress. Rather than the future generations looking back and say it was on the brink and they had an opportunity, but all they did was talk and they weren't honest. And look where we're at now. I'm hoping that will never happen. And I'm saying the little drop of water I can bring, I hope that this will bring that kind of reflection in generations to come. When I'm, like I say, I'm in a spirit world elsewhere, still in the territory, but part of all of that. So that in my mind, whenever, I'm reflecting and talking to people, I think about. Another thing I just want to point out is, for me, is that all of this is important for everyone. And I know decision makers, but most important for those young people that are just coming up. The elementary children, the teenagers. So the education system has a tremendous role to make this part of curriculum and discussion within the school. I know some teachers do it. Having been an educator for 30 years, I know some do it, some don't. But we must find ways to sow the seed of understanding very early on, so that we're not trying to get people to unlearn things to teach them new things, that they will already have a lot of those things to bring forward an understanding. And certainly this will allow for these issues that we're facing today in Canada and elsewhere in the world to move forward not in baby steps, but in leaps and bounds. I don't think we can allow, and I know that's where we're at. It's baby steps, and maybe I'm not patient enough, but it's leaps and bounds. We have so much, we're already losing so much. We know what's happening, and we need to invigor. There's a word that sometimes uses, it's called volition. And volition is that word, the meaning is that energy that we have inside of us, of who we are as human beings, and the spirit we carry that propels us to achieving things. It's that propelling. And we need to find that, or we need to create it. We need to ensure that it's there for this and future generations.
I share your sense of impatience sometimes with this. Before we go today, I just want to ask, is there anything else you'd both like to say, or I know we'll have links to the Alliance below and links to all the organizations that you're working with below the podcast, but is there anything else you'd like to say to people, or is there anywhere that they should be going to find information?
With the Tenàgàdino Alliance, I think it's still just to have a look at our website and whatnot. But more importantly, I think is for any individual listening to the podcast is to have their own reflection and to seek out and talking to other people, maybe reading some books, but to talk to people and to make this a part of their conversation at whatever level that they're at. Make it. One voice becomes 10 voices, and 10 voices become louder. At last, there's such a roar. One can compare it is that each individual is one fire, and we're many fires, and we need to pull all of those fires together to make one large fire of change. But it begins by each individual, and where they're at, and then learning more, finding out, questioning. And that doesn't mean it's, accepting everything that everybody says. No, questioning it, finding out, and making your own determination based on fact and information, based on, what you've learned over time, and combining it. But again, thinking, what does this mean for the future? If I don't do anything, if I don't say anything, what will that mean? And how can we come together collectively? Because we must. And I believe, I really do, that we will.
Yenny, Gilbert, Miigwech, thank you so much for joining me today.
Miigwech, appreciate it.
Thank you so much. Muchas gracias.
Hi everybody, Connor Curtis, Head of Communications, jumping in again here to do the Q&A for today's episode. And before I get into the answer for today's question, I just want to state the answers to these questions are entirely on behalf of Sierra Club Canada. They don't reflect the views of our guests, so I just want to make that clear before we begin. We got a question from somebody asking, why don't farmers affected by weather events just get insurance? Weather is unpredictable and we've got nothing to do with it. And I want to respond to this because I think it's actually important that we reach out to these questions. And more importantly, maybe for those of you listening, show how to maybe respond to one of these questions. So first of all, one of the issues with climate change and the weather events that we are in fact very much responsible for producing as a species is that we're making weather more unpredictable, and it's actually getting very hard for people to get insurance, especially if they're in flood prone areas, because insurance companies are basically saying we don't want to take the risk. I mean, if it's that unpredictable, they don't even want to take the risk giving somebody insurance. So we can't just ask farmers affected by extreme weather events to just get insurance. I don't think anybody could turn around to, for instance, somebody affected by forest fires, in fact thousands of Canadians at the time of this recording who are being evacuated in Alberta and in BC, and say to them, why don't you just get insurance? We build lives, we invest in things, and even if there was insurance that would cover any damages we had, that doesn't mean that people deserve to lose their homes. And we can prevent it. We can prevent it with very little effort, in fact, because the primary cause of the emissions that are creating these wildfires, that are creating severe weather events, that are flooding farmers' fields, or causing droughts for other farmers that they cannot adapt to in time. The primary cause is not even individual people. The primary cause is large industries who've been making insane profits, just incredible profits, without having to regulate themselves at all, while saying to governments, we will regulate ourselves, don't worry about our emissions. And quite literally, literally, if we just regulated those industries, if we just made them pay for the pollution that they produce, we can actually make a huge step towards addressing that pollution. And I know that some people are going to talk about the whole, well, it's not Canada's fault. There are other countries with far bigger emissions profiles, things. You're probably going to hear a lot of that if you're listening to this podcast. Canada has very high per capita emissions. And again, that's not down to individuals' faults per se. That's actually one of the reasons we've always missed our emissions targets as a country, is again those large heavy industry actors, especially the oil and gas industry. And that's why an emissions cap on the oil and gas industry is so important, because we do have other industries in this country. We do have industries like farming that people rely on, that actually produces food, something that realistically we can't do without. We can change away from oil and gas. We can never actually exist without food. Prioritizing those, putting those first, and making extremely wealthy corporations pay the price for the pollution is one big way on how we can actually help people. We can't just ask people to get insurance. There isn't the money out there to deal with the amount of adaptation we would need to deal with in order to deal with just runaway climate change. There is no way to adapt out of this situation that doesn't involve a huge number of people worldwide dying as a result of it, and losing their homes, and being displaced, and all of the other effects that we say. And you say to yourself, like, how inconvenient is it if tomorrow, if your home floods, or your home catches on fire? How inconvenient is that to you? Ask yourself that. Okay, that's the best case scenario for a lot of people, not only around the world, but in Canada with climate change. That's their best case scenario. Because the worst case scenario for a lot of them is that they lose family members, is that they lose people they love, that they lose entire communities to this. So we really need to be thinking about, how do we make changes now that prevent the impacts in the future? Again, if at this point, if you can turn around and hear these stories and say, weather is just unpredictable, get insurance. If you can turn around and ignore the thousands of people who have been evacuated, maybe we don't have anything to say to each other at that point, because maybe there's nothing I can say to convince this person. But I tell you what, there's a lot of other people out there who need to know the connection between climate change, extreme weather, and the emissions of the oil and gas industry. That's why we're having some town halls over the next few days, as we mentioned at the beginning of this podcast. It's why you should chat to others about this issue. Because yes, you won't convince everybody, but there are a lot of people on the fence. There are a lot of people out there going, but is climate change really that serious? I know it's real, but is it really that serious? Go talk to those people. Go chat to them. I hope this gave a little insight, at least for the people listening, as to how to talk about some of these issues. I think we need to tell stories. We need to tell facts, but we also need to tell stories about how this affects people personally, because it does. And we need to ground those in facts, but we need to make the impacts noticeable and real and talk about what they actually mean for people, because it's easy enough to dismiss a headline like thousands of people evacuated. If you've ever met people who need to evacuate an area, they are not just statistics. They're not just numbers. It's too much when it's one family that needs to evacuate. It's too much. And people have lost whole communities. People have lost their entire lives. People have lost loved ones. Before we end today, just a reminder that you can take action on environmental issues by visiting sierraclub.ca with tons of petitions, including, as of the broadcast of this episode, a petition on the rights of nature you can sign, other actions events, and regular news updates you can sign up for on the homepage. You can also find Sierra Club Canada on social media, and you can listen to the Environment in Canada podcast on the Harbinger Media Network, Spotify, Apple Podcasts, iHeartRadio, and YouTube, or wherever you get your podcasts. This podcast also airs on CKUT Broadcast Radio in Montreal, 90.3 FM bi-weekly on Tuesdays at 11 a.m. ET. Don't forget to click follow or subscribe so you get the latest episodes from us. And again, check out those 3 town halls happening tonight, tomorrow night, and the third night in St. John's, Newfoundland, Labrador, Fredericton, New Brunswick, and Sackville, New Brunswick. More on that at sierraclub.ca/town halls.